Good morning, commissioners. Good morning.
Morning, Chief Justice.
You look vibrant this morning.
Too much. Too much.
You think the white mask will do the trick? Yeah, but I see that your neighbor also has a white mask. I think that we can start. I have been informed that Commissioner Malema is not able to attend today and tomorrow, but we can proceed. It's for a valid reason. Thank you.
Progress.
Good morning, Mr. Heffer. You may take off your mask because there is enough distance between you and the commissioners. Thank you.
Thank you, Chief Justice.
How are you this morning?
I'm okay, thank you.
Thank you. I wish to welcome the Judge President of the Free State, Acting Judge President. Thank you very much for joining us this morning.
Thank you, Chief Justice.
Thank you. I am advised that the Premier of the Free State is represented by the MEC for Social Development, Ms. M. Qabate. Ms. Qabate, are you there?
Morning, Chief Justice. Yes, I am in, and greetings to all.
Yes, thank you very much. You are welcome. Thank you for joining us. Okay. I want to start off, Mr. Heffer, by thanking you for availing yourself for consideration for appointment as a judge of the Free State Division. We appreciate that.
Thank you for the opportunity, Chief Justice.
Yes. I am going to ask you some questions, and after I am done, I will ask the Acting Judge President to put questions to you, and thereafter the MEC representing the Premier will do the same, and then commissioners who wish to ask you questions will then be allowed to do so after that.
Thank you.
The questions that all of us will be asking you will be aimed at satisfying ourselves how your appointment would meet the selection criteria that this commission applies when interviewing candidates, which were approved quite some time back. Those criteria include whether you are appropriately qualified, whether you are a fit and proper person, and whether your appointment would help reflect the racial and gender composition of South Africa, and whether you are a person of integrity, and whether you have the necessary energy and motivation, and whether you are a competent person, technically competent, and whether you have capacity to give expression to the values of the Constitution, and whether you are an experienced person technically, and whether you are experienced in regard to the values and needs of the community, and whether you possess the potential, you possess the appropriate potential, and what message your appointment would send to the community at large. So questions will be directed to you, aimed at satisfying ourselves how your appointment would meet those criteria.
Yes.
The questions that commissioners will put to you will be crisp, and you are urged to do your best to also give crisp answers.
I'll do so.
Okay, all right, thank you. So we'll start. I see that in terms of your qualifications, you possess or you hold a B.Juris degree, which you obtained in 1985, and an LLB degree, which you obtained in 1989. Is that correct?
That is correct, Chief Justice.
And you obtained both of them from the University of the Free State, is that right?
Yes, that is correct.
And after you had completed your B.Juris degree, but before you completed your LLB, you worked as a judge's registrar from 1986 to 1988, is that correct?
That is correct, Chief Justice.
Yes, and then you served your articles in a law firm called Jan S. de Villiers and Son in Cape Town from 1989 to 1990.
That is also correct.
And you were then admitted as an advocate in 1991, and you have been practicing as an advocate since then.
That is correct, yes, Chief Justice.
In the Free State.
Yes, Chief Justice.
Yes. And that means you have been practicing for about, 31 years?
December last year was 30 years, Chief Justice.
Sorry?
December last year was 30 years.
Yes. And when did you take silk?
2018,
2018.
3 years ago.
Yes.
3 years ago, more or less 3 years ago.
Yes. Tell us about the branches of law that your practice covers. What branches of law do your matters that you deal with in practice relate to?
Chief Justice, currently it does not consist it consists of all civil fields, excluding, I would say all civil law, but it excludes employment law. I don't do any employment law at all. I don't do much administrative work. Now and then I will have a look, or might have been involved in administrative reviews, but not fully up to the end. Mostly it's commercial work and contractual matters, and eviction from property and properties in the Northern Cape. That is what my practice consists of at this stage.
And you are talking about what your practice covers now, but you can tell us also about what it has covered over the years, because there may have been some branches of law in the past in which you were involved, but you are no longer involved now.
Yes, Chief Justice. Previously, I had been doing the first approximately 8 to 10 years of my practice. I've been doing criminal work, the so-called Prodeo system, which we had many years ago, which assisted the accused or the people who could not afford legal representation. So that was mainly what my practice consisted of at that stage. Thereafter, I started doing some work mostly in the magistrate court civil matters, which combined my practice with civil as well as criminal matters. And then on that basis, I started doing more and more civil matters, which up to at that stage, I'm not doing any criminal work for the past, I would say, 20 years.
Yes. And how much constitutional law, administrative law do you do in your practice, or have you done?
Chief Justice, not much constitutional
much.
law. No, I haven't done
Yes.
much. The same goes for administrative law.
Yes.
I have done in a lesser degree some consultations, and which often happens, but not often, but it does happen. But I haven't done much, no.
Yes. And labor?
Labor, not at all.
Not.
I tended to stay away from that because it's a specialized field, which I did not want to venture on.
Yeah. And in terms of acting, what periods have you acted in the High Court?
Chief Justice, in totality, approximately 6 months.
About 26 months?
No, 6 months, Chief Justice.
About 6 months?
6 months, yes.
Oh, okay. Would that translate into 2 terms, or it's more than 2 terms?
I would say, all in all, it would be approximately, everything together combined would be about 2 terms, yes. But it was on and off periods.
Okay.
Once was for a full term, and then the others were just, it was
Small periods
small
here and there.
periods. Yes, Chief Justice.
Okay, all right. And how have you enjoyed acting?
Chief Justice, the very first time when I was asked to act, I was very nervous, and I remember the first time when I walked into court, especially the open motion court for unopposed motions, I did not enjoy it. I was really nervous. And I remember saying to the people, instead of thanking somebody, I said, please, may they please the court, as from the bar side. So the very first time I really did not enjoy it. And that it started getting better, and that at, I think, about the second stint perhaps, I started enjoying it. I became more confident.
Yes. And you sat both in motion court and in trials, of course?
Trials as well, and motion court, and unopposed motions and unopposed motions.
You said that in recent years in your practice you were not involved in criminal work. But when you were acting, did you sit in criminal trials by any chance?
Yes, Chief Justice, I was allocated a criminal trial in the Circuit Court in Harry Smith, which was a trial which ran from the beginning to start. That was
Yes.
that was the only one that was allocated to me.
Yes. During your acting stints, what kinds of branches of law did the matters you dealt with relate to?
It was
Roughly.
it was RAF, one RAF matter, evictions. One was a review of a taxation. Then there was an opposed matter about costs and about the application of Rule 45, whether the process of execution is to be stayed pending an appeal. Yes, that was about it, if I can, in short.
Yes. Matters in which you have written judgments. About how many written judgments have you written during your acting stints, if you are able to give us an idea?
Chief Justice, I've counted them some time ago last year. I think it was approximately 40, if I recall correctly.
About 40?
Yes, Chief Justice.
Yes, okay. Have some of them been reported by any chance?
I believe...
And for me, reported means South African law reports and
Yes, not the one on
Butterworths and...
Yes, I believe the one criminal matter has been reported in the criminal law reports. Chief Justice.
How many?
One had been reported in the
Yes.
criminal law reports.
Yes, okay. And in matters in which you have appeared, which resulted in reported judgments, have you got many of those?
Only one many years ago, which was reported, if I recall, in the SCA, Chief Justice, but I'm not sure about that, but that's as far as I can recall.
Yes. Okay. Now, what is the test used to decide whether to grant interim relief?
Chief Justice, do you mean an interdict? Or
Let's say interim interdict, to be more specific.
it will be a prima facie case, whether a prima facie case exists, where there's an apprehension of harm. The balance of convenience favors the applicant and no alternative remedy, Chief Justice.
Yes. And when it's a final interdict?
It will be the same, save for the fact that it will not be a prima facie case, but a clear right.
Yes. And when you sit on appeal and you have to consider whether to uphold a decision granted by a lower court in the exercise of a discretion, what guides you on whether to interfere or not?
Chief Justice, the main consideration will be whether the presiding officer in the court or quo has misdirected him or herself in the application of the law and of the facts.
And when you are sitting on appeal and you are asked to set aside factual findings of a trial court, what would guide you?
The factual findings of the trial court, Chief Justice. I would say, in which regard the court found, with regards to the credibility of the witnesses, in which regard the trial court may have made mistakes in regards to the facts which was before court.
If you are appointed, when you are sitting as a judge of the High Court, you may find yourself having to deal with matters where the constitutional validity of legislation is challenged.
Yes.
You have indicated that you haven't had much of constitutional law cases to deal with. Did I understand you correctly?
That is correct, Chief Justice.
What can you say to the commissioners with regard to how you would handle such a matter, seeing that you haven't had this opportunity?
Chief Justice, I'm not making excuses, but first of all, I think in the Free State, especially in Bloemfontein, there is not that many constitutional matters which comes across in that division as such. But I will deal with the matters as far as my knowledge of the Constitution is concerned up to this far. And I will deal with constitutional matters as I would deal with any other matter which I'm not very familiar with, and go and study the principles of the Constitution and the applications as contained in the Bill of Rights, etc., in the Constitution, and then I will apply them. But I will make sure, as I say, because they are very, very. I think for every presiding judge, there are very often fields or laws which are not applicable very often, and which are not worked with on a frequent basis by a certain judge or division. So I will fully acquaint myself with the principles again, as contained in the Constitution, and see in which regard the values are being protected as far as that particular matter is concerned.
You may not have been dealing with constitutional cases, and I think you said administrative law matters as well.
Yes, you said.
In your practice, but have you been taking the trouble to read and try and keep yourself up to date about the developments in those branches of law?
I have, especially in constitutional law, Chief Justice, not only for being here today, but also in general. I thought it'd be appropriate. It's in the interest of my practice as such, also to be up to date with constitutional matters. So I sometimes read some articles about the constitutional law. Of course, the matters as we find in constitutional court as such in the SA law reports, I studied them as well. So I try to far as possible to keep up to date with the principles of the constitutional law and other branches of law which I consider to be applicable in my practice, or might be applicable in practice and in future.
Yes, thank you. I'm now going to give the acting JP the opportunity to put questions to you. Acting JP, the commissioners have agreed to limit themselves in terms of the questions to 2 questions, but we give the JP or acting JP a little bit more leeway because he or she would know the division and the candidate. So I'll give you a little bit of more leeway. You can start.
Thank you, Chief Justice. Good morning, Mr. Jeffer.
Good morning, JP.
You've already indicated that all in all, you've acted for a period of about 6 months in the Free State High Court.
That is correct.
During this period, how many times did you do motion court?
You meaning by unopposed motions?
Yes, unopposed motion.
If I recall correctly, I think it was 3 or 4 times.
How many times?
3 or 4 times in the unopposed motions.
In view of the fact that in the Free State, a judge doing unopposed motion does urgent matters on the same week and all chamber work, how did you find your experience while dealing with the unopposed motion in those 3 times that you have dealt with unopposed?
If I understand the question correctly, there was how did I deal with the urgent matters?
Yeah, how did you find that experience?
Well, it was sort of, if I may say so, it was sort of exciting sometimes to receive an urgent application, and because it's sort of out of the ordinary from the matters which you find in the unopposed motions, which is a long roll most of the times. But I didn't find it inconvenient or anything of that's in that sense, if I understand your question correctly.
Thank you. At the time of completing your questionnaire, you've indicated that you have one partly heard matter. Has that matter been finalized?
It has been finalized and judgment has been delivered yesterday, Judge President.
Thank you. Thank you, Chief Justice.
Thank you, AJP. the MEC Kabata, I now give, Kabate, I'm sorry. I now give you an opportunity to put questions to the candidate. That is if you
Thank
have
very
any.
much.
That is if you
Yeah,
have
no,
any.
I do.
Yeah.
I do.
Yes.
Chief Justice, thank you very much. And I hear you saying you have discussed with the commissioners and have agreed to 2 questions. I have 3 questions. Can I be allowed to ask
That's
the
fine,
3
yeah.
questions?
Yeah, that's fine.
Okay. Thank you. Advocate Hifa,
Commissioner.
my first question to you will be, what is your view about gender equity?
Gender.
According to you, is the pace of addressing gender equity within the judiciary satisfactory according to you? And if not, what plans and strategies will you put in place to address the challenge? Should a woman be a preferred candidate, will you embrace the decision or will you blame it on gender equity? My third question.
I'm
was my
sorry.
second question.
I'm sorry, MEC. Let him answer the first question and then you can put the second one.
Okay.
Thank you, Chief Justice. Thank you, Commissioner. Commissioner, I think the whole process, if I can use a word which is going to come up again, the question of transformation, especially in regards to gender, is an ongoing process which started, I think, many years ago, just since '94 perhaps, and then it gained momentum over the years. To answer your question, whether it should be improved in future, I think definitely so. But I must say, I think, especially if I look at the division in the Free State, as far as the bench is concerned, and I can also say as far as the Free State Society of Advocacy is concerned, there has been a vast improvement as far as transformation is concerned, especially in regards to the female members, as far as members in the bar again, and as members on the bench is concerned. Yes, indeed, and as I say, the process of transformation should continue if one is confronted with the fact that you are, as in my case, for instance, that you must choose whether a white male should be appointed or not. With respect, one should also consider the merits, as in any other application. And if that particular applicant's qualifications adhere to the requirements or the guidelines in regards to what was being set out, what is being considered by this commission, then with respect, that should be considered favorably. If there is not a female, in particular in regards to gender, a female candidate who has the same qualifications and experience and skills.
Okay. Can I then proceed to ask the second question? Advocate Hifa, what will be your plans and strategies? What will you do to reduce postponements of cases, taking into account the negative bearing it has on victims and witnesses?
Commissioner, I would first of all, I would inquire and ascertain what is the reason for the postponement sought by the parties concerned in a particular trial or application, and then I will also go as far as possible in the recent matter which I was dealt with, to which the acting judge president just has been referred to. For instance, there was a request for postponement at some stage, which I denied because I thought it should have, or the matter should be finalized as soon as possible, or on the condition, of course, that you do not prejudice any one of the parties concerned. So I would ascertain as far as possible what is the reasons for the postponement, and first of all, whether the postponement itself cannot be stopped, if I can call it like that, or or curtailed in any manner so that the matter can be finalized as soon as possible.
Okay, thank you very much. My last question will be on rural communities and farming communities. With the recent indabas and seminars that we have held with farming and rural communities, the outcry is that when they are having cases, particularly against their employers, they are not able to attend to their cases because they depend on their employers for transport. And deliberately, their employers will leave them behind. And their cases would therefore be thrown out of court because of their absence to attend. Whereas it was not out of their own will, it was because they were struggling with the transports to attend to the cases. What will be your plans and strategies to address that challenge? And there's a lot of outcry on it.
Commissioner, may I ask you, that will be in my capacity as a judge, if so appointed.
Yeah.
I will do everything in my powers.
I take it that you will also be playing a role in improving the services within the magistrates' offices.
Yes, indeed so. Indeed so,
Yeah.
Commissioner. As far as possible, as far as it can be within my power, I will try and arrange for transport to assist those people in the rural communities, which I think is important. So as far, I don't want to, I will not overstep my powers to say that, listen, you make an order to the effect that people should be accommodated and transported to the relevant venues. But I will do anything in my power to see whether those people can be assisted, for instance, by the police services to attend the trial, or whatever the other proceedings might be relevant.
I was asking the question based on improving either our policies or administrative processes to ensure that the farming and rural communities also are fairly represented when they are having cases.
Commissioner, then I would propose that at some stage with the Department of Employment and the other relevant departments concerned, that there might be some consideration at some stage to be built into legislation or into contracts of employment, that if the instances as in that regard should arise, for instance, where employees should attend court or other proceedings, there's an obligation on the employee to provide such transport to the employers.
Thank you very much. Thank you.
Thank you, Commissioner.
Thank you, MEC. I will now allow commissioners to ask their crisp questions. And I know that where they can ask one question, they'll ask one question. Commissioner Makwanisha.
Thank you very much, Chief Justice. I have two short questions. Good morning, Advocate Heffer.
Morning, Commissioner.
I think let me start by commending you for being involved in the training of pupils for the past 14 years. And I think you will agree with me that training is a very important component, but training without work does not also assist. So how many black lawyers have you assisted as a senior counsel and women in your lifespan as a senior counsel?
Commissioner, since I've been appointed as senior counsel, last 3 years ago, I've assisted 2 black women, yes, to assist me in trials and applications.
The second one is the mentoring of black lawyers. So you have said here you have only mentored 2. Would you agree that that is a very low number?
Yes, Commissioner, if I might just explain, when you get to a certain certain age or years of seniority, then you do not get allocated any pupils anymore. But then you still are available to be appointed as, well, not all being not appointed, but you act as a senior mentor for such a pupil. Because I was myself involved for the vocational training in the chairman, or most of the time in the chairman capacity, I didn't appoint myself. I sought help from other people, but I was still fully involved with all the pupils as a whole as well. So they were not my pupils, but if I may say so, all of them was under my guidance, if I might say so.
Thank you very much, Advocate Heffer. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Matolo Zlepu.
Thank you, Chief Justice, and good morning, Judge.
Morning, Commissioner.
Sorry, good morning, Advocate Heffer. Just a follow-up from Commissioner Mangwanishi. You say because of your seniority, you haven't had the opportunity, or you are not allocated pupils. What I want to find out from it, is it a fair thing that senior counsel should not have pupils? Because this is where the experience lies, and this is where we have to get all the experience. You are the pillars and, the brains behind the advocacy. Why shouldn't we have pupils? Do you think it's fair?
Commissioner, I don't think it's fair just to answer your question from the offset, but the reason for that being is that in general, I don't know at other bars, but in general, I think we now all have the principle, or it happens that senior counsel does not go to court that often as junior counsel do. So you you're not actually excluded as a senior, but the reason for that is you mostly appoint people from 5 years onwards to be mentors, assisted by senior counsel, just to give them some the exposure as far as appearances in court, etc., is concerned. So that is the reason for that. So it might come across as being unfair, but it's just in the interest of pupils, which has been done. But as such, as I say, at our bar, and I think at other societies as well, all the senior counsel are still available, if I can put it like that, to help in the pupillage as well. For the past, I think, 8 years, for instance, at the Free State Society, we had the principle that you have a junior mentor and a senior as well, and at presently it's still the same. So senior counsel is not completely excluded from being mentors.
Okay, just the second question, I still feel it's unfair. I must just say that. The second question, I heard you saying that you were doing a lot of evictions. I hope there are no farm evictions involved.
They were not.
Farm workers evictions. Were you doing some?
No,
of them?
it was mostly it was in the Northern Cape. The one was in Kwakwa because of the illegal occupiers. We were occupying some ground of the University of the Free State, and most recently, which I was quite involved with and still is involved in a certain respect, is illegal occupiers of communities of land which had been allocated to communal groups in terms of the Act. And where mining is taking place, it's not farmers, no.
Thank you. I had a lot, Chief Justice, but I'm respecting the protocol.
I'm happy you are respecting that. We have taken 30 minutes already. Commissioner Singh.
Thank you very much, Chief Justice. Good morning. I'll take 1 minute. Good morning, Advocate Heffer.
Morning, Commissioner.
Yeah. We get comments from and feedback from law bodies, and I think it's appropriate for us to actually follow up on what they say and to put it to you as a candidate. Now, in your case, LSSA does not support your candidacy. You might have seen that. And the reason they give is your involvement, your lack of involvement in constitutional, administrative, and labor law.
Yes.
So that's one. And then Nadal, on the other hand, speaks about, also does not support your appointment because you have not shown any form, I'm quoting, of social involvement. And they also say that your appointment will not aid in making the division reflective on the demographics in the Free State. Would you like to just comment briefly on those comments? Thank you.
I've seen that, yes. Thank you, Commissioner. As far as the involvement in the community is concerned, I've been involved in community as far as possible. Not possible, but as far as the opportunity arisen over the years, I've been involved in the community. And behind the scenes, I'm also involved, which I don't, with respect, I don't always use that to say that this is what I'm doing for the benefit of the minorities or people that might need it. So in that sense, it's not. I'm not doing anything for the community at this stage. I'm still doing something, although not as a parent in previous years when I was involved at university or with NICRA, for instance. I'm not involved in organizations like that anymore. As far as the second part is concerned, and presently it is correct, the percentage is also mentioned by Nadal in regards to representation of the population in the Free State in general. I think mention is made of the 35% of the people of the bench in the Free State is currently white, which will include white females as well. The only thing I can say about that is that the vacancy which came about was because of the retirement of a white male judge as well, who, if I recall correctly, was appointed under the same dispensation after 1994 with the same considerations as well. If I should be appointed, that will mean that in respect of the 14 judges in the Free State, there will be 3 white male judges, 3 female white judges, and the rest is with respect to the black judges. So in that sense, the 35, I haven't worked out the percentage, being the 2 males in respect of the 14, but in submission, the 35 might come very close to the percentage of representation on the Free State bench.
Thank you, Advocate. Thank you, Chief Justice.
And thank you, Commissioner Singh. Before I go to Commissioner Nyambi, may I ask this question, Advocate Hilfer?
Chief Justice.
It looks like you took silk after 26 or 27 years in practice.
Yes, Chief Justice.
That sounds to me like a very long time. I may not be up to date about how long advocates take silk, but my impression is that it's usually around 12 years to 15 years. That information might not be accurate, but 26 years, 27 years seems quite a long time. What's the explanation for that, if there is any?
Chief Justice, yes, you are perfectly right. I think especially in the old dispensation, it was indeed the average was about 12 years to take silk, which later again changed. I think the reason for that, I don't know the reason why it took so long. The thing is...
Did you want to take it?
Did I want to take it, Chief Justice?
Did you want to take silk?
I indeed wanted to take silk, but again, in the Free State, you are very wary of taking silk too fast, because I think in the Free State and also in the Northern Cape, you don't have that great number of matters, which like commercial matters or big matters, as if I can say it, SC matters, which warrants an SC that you have in other divisions. So you're very wary of being that. And even when I took silk 3 years ago, then I was very hesitant to do that as well, But the reason because I've done it at that stage, because I noticed at that some stage I was the only briefs I received, or not the only, or the majority of briefs I received was mostly in regards to intricate matters, which warrants senior counsel, and then I made the decision. But to answer your question, I was very hesitant because I was scared.
Okay, all right. Commissioner Nyambi?
Thank you, CJ. Morning, Advocate FSC.
Morning, Commissioner.
One question from me. As somebody that has acted in that division, what are the challenges facing the division that you think with your appointment you can be able to assist?
Commissioner, I'm not aware, if I may say so, with the challenges, whilst the time whilst I'll be, well, from the perspectives of whilst being in a acting capacity, I could not find that there were great challenges. There might have been challenges in regards to infrastructure. Sometimes everything wasn't quite working in the chambers or at court. But the system itself, which I experienced both from the side as being in an acting capacity as well as from the bar side, there appears to be everything appears to be going well, if I may say so. So with respect, I can't say there are many challenges which I can say which need to be resolved at this stage.
In short, everything is perfect in Free State.
Perfect with respect is a very strong word, but it's working.
Thank you, Advocate Heffer. Thank you, CJ.
And thank you, Commissioner. Commissioner Schlemmer?
Thank you, CJ. Good morning, Mr. Heffer.
Morning, Commissioner.
I was interested when you said that you read articles and stuff to get you up to date with constitutional matters, etc. And then it kind of caught my eye, and I was wondering about the fact that in some of the cases that the judgments that you attach to your application to the questionnaire, you don't refer to a single piece of authority, specifically the SB Guarantee Company case. I didn't pick up any authority that you are referring to there, not even case law, and it seems to me it dealt with independent guarantees, which is an area of the law where a lot of development is taking place and a lot of issues has arisen. How important do you feel is it to refer to authority in cases? The writing of scholarly judgments, as I call it, because in the other cases you do refer to authority quite extensively, but in this particular case, not one.
Commissioner, may I just have the opportunity to study I don't know whether it forms part of the judgments in the bundle. I can't just recall just from name which matter was it about. Can I just have a look at it, please?
It is on page, let me just get to the page. Paginated 73.
Thank you. Just want to make sure about the bundle, Commissioner.
It's attached to your questionnaire.
Thank you. I've got it, thank you. Yes, Commissioner, if I may answer your question, this was in regards to the to the summary judgment, which was the application of summary judgment. With respect, to me, it was actually clear cut what was involved, and especially in this particular matter, I had a look at the contents and the wording of the contracts concerned. I didn't deem it necessary to go into authorities, because it was, with respect, it was quite straightforward to me. I think it's important to write scholarly judgment, yes. I think when you are, and I'm not looking for excuses, again, I'm not making excuses, but when you are in acting capacity, you're very hesitant to do that in the sense that you are, I think even if you are in a permanent capacity as a junior judge, you're still learning. So it's not necessary always to, if I may say so, with respect again to all judges and to the profession, that you always have to refer to authorities to make a good impression. I think that's mostly in that regard it is the SCA and the Constitutional Court who plays a big role in that regard. But as far as is necessary, I refer to authorities and apply them, yes.
Thank you, Chief Justice. Mr. Heffer, I just think that even as in the division that you're in, it is important also that one just does do that. I mean, it is important for the parties to know if they want to appeal what you've said based on what principles you have based your judgment. So it's just something that I thought to raise with you. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Schlemmer. Commissioner Pillay.
Thank you, Chief Justice. Good morning, Mr. Heffer.
Good morning, Commissioner.
Mr. Heffer, I followed with interest your answer to questions raised about transformation. And the one thing that you indicated was that I think you said you were satisfied that there were more efforts made to transform the Free State bar and bench, as I understood your answer?
Yes, that's correct.
Now, you see, Mr. Heffer, the discussions about transformation are best grounded in fact, so that we can assess progress from the facts. And I would like to put some facts to you and then pose some questions to you. Now, these are facts that we've gleaned from AFT members in the Free State bar, and I just want to put it to you in terms of numbers, right? We're looking at 0 black women silks, 1 black man silk, right? 0 black women over the years of 10 years at the bar, or 10 years seniority or more, 0 women, black women. 1 black woman between 5 and 10 years, and 7 black women under the age of 5 years. Now, can you confirm that that's more or less correct?
That is more or less correct, yes. I know the total number of women is approximately 12, if I recall correctly, at this stage, yes. But as far as other statistics are concerned, it's correct. There are no black female silks at our bar.
But more importantly, besides no black female silks, which in my view is already an indictment, but besides that, I'm interested in the fact that there's 0 black women over 10 years seniority at the Free State bar, and 1 black woman between 5 and 10.
Commissioner, if I can be frank, I think in the Free State, and the reason for that being is, I don't think in the Free State we've reached the point yet that the community and perhaps also the lawyers as well, I beg your pardon, the attorneys as well, have enough confidence in black women. That is my perception, and there must be some way in regards to perhaps expose junior silk black women as well. Just last week when I was leaving Chambers, I had 2 very senior, 2 female members who passed exams last week, who were really, you could see that they don't know which way to go. They said, listen, we're not getting any work. And in all there is a problem to solve that, yes. So to go beyond 5 years is difficult for them. Very, very few of them can't last 5 years financially, then they resign.
Yeah. Mr. Heffer, you're right, there certainly is a problem. And the problem was highlighted in 2018 when there were only 2 black women in the bar, at the Free State bar, and one of them resigned very publicly. Do you recall that, Mr. Heffer?
That is Ms. Kui, if I remember correctly, Commissioner, yes.
That's correct. Ms. Kui resigned very publicly, and she openly shared her reasons for resignation.
Yes.
And she said that the Free State Bar was so hostile to black women that they didn't feel comfortable there. She also said that after 1 year, what would often happen is that women didn't find, as you said, sufficient work, black women specifically, and they dropped out after a year or two. So in other words, you would have large numbers in intake, and through attrition, you would lose women, black women specifically, very rapidly after that, probably within the first year and then the second year. And so then the numbers that I've put to you right at the beginning, they make sense because very few women actually survive at the bar.
Yes, yes.
Now, against that background and against this big debacle that happens in 2018, where you have a black woman that's brave enough to stand on a public platform, she is one of 2 women at the bar at that stage. And she says to the world that there's a problem in the Free State and that there really is a cry for help for black women at that stage in 2018. I have to then ask you again, Mr. Hefer, what have you done in order, firstly, to make it easier for black women to stay, in other words, involving them in your work, and also to address the systemic issues that militated against black women remaining in the Free State Bar?
Commissioner, if I may say, I was sort of directly responsible, involved in regards to the Kui matter, because Ms. Kui came to see me at that stage, and she said she's unhappy about certain things. She didn't specify that at that stage. She just said she's unhappy of what she's experiencing, not as a black woman necessarily, I must say so, but as a junior, which I think she was practicing at that stage about 2 years, maybe 3. And my words to her at that stage in my chambers was to the effect that she must please put it in writing so we can rectify it in future. I was actually a bit surprised when I was informed by the members of the Bar Council at that stage that she did this publicly, because that was not my intention to do it publicly. My intention was for her to show to the Bar Council and to the bar as a whole in the Free State what can be done to rectify the problems and also to see that it doesn't happen in future. So that was my involvement as far as Kui is concerned. Then she left, and then there was a debacle, and I think it also served before and was considered by the GCB at some stage, and it was clarified, but that was the origin thereof. As far as what I personally have done, when we served on the Bar Council, when I served, I resigned last year because I thought it was time for somebody else to take over in regards to vocational training. We did everything in our best, and myself, including myself, to first of all to assist or to gain new female black members in the society. And I know, for instance, our chairperson, Neil Snellenberg, he also made efforts to negotiate with the state attorney side in regards to appearances in the magistrate court for that reason, to assist all members, not only black members, but also all junior members to receive briefs. As far as possible, as far as my work allowed it, yes, I involved juniors in my work as well, and I said it was two black female members who assisted me to me in great regard. And as far as my work allowed it, I sought assistance from such members, yes.
I'm sorry,
Okay,
Mr.
yeah.
Chief Justice, just the last
One,
question.
okay,
and I'm
all right.
Just to come back to what you've indicated now, and this is specifically one of the complaints raised by Ms. Kui, that to the extent that the Free State Bar even did introduce measures to assist black juniors, and this is black juniors generally, not black women juniors, like, for example, the creation of a transformation fund. What soon happened after that was that there was a deliberate attempt to remove race from those initiatives. So in other words, to open those initiatives up to all juniors and not specifically direct them at black juniors and black and women juniors, despite the burning problem in the Free State. Now, that reflects your answer that you've just given now, Mr. Yefa. And I just want to understand, in terms of your own understanding of the problem and the steps you took to address the problem.
Commissioner, the steps I've taken was to, well, as I say, as far as I could have input, and we also input on the Bar Council to find ways to assist the members, or the junior members, or then the female black members. We discussed that, and for instance, reference was made to the Magistrate Court appearances. The fund which was established, there was a meeting, if I recall correctly, and it was a majority decision not to throw this fund open to all juniors concerned. I myself, if you would permit me, I would refrain from indicating what I voted in that regard, because my bar might take me up on that. So I would refrain to say what my attitude was in that particular meeting. As I say, as far as I could, we can. Yes, and I can also say with the utmost of honesty that wherever I could, and there was a capable junior, which includes, and there were specifically two female black members who I recommended to firms as well, as another gentleman who started practice, a black gentleman who started practice also 2 years ago. He was for many years, he was in the employment of SARS, and I introduced him to one of the big firms, representatives of the big firms, for future purposes, if they look for somebody who might be interested in a specialist in tax matters.
Unfortunately, I have to leave it there. Thank you, Mr. Yefa. Thank you, Chief Justice.
Thank you, Commissioner Pillay. Commissioner Tsepe.
The white mask work, Chief Justice. Good morning, Advocate Yefa.
Good morning, Commissioner.
I was going to ask you two questions, but I'm worried about time, so I may just, depending on how quickly you answer my next question, I may give it up. It relates to a question that was asked by Commissioner Singh, and that is the comments that we received from the law bodies. I just wanted to be sure that you would have read all of them, because Nadel's issue wasn't just the issue of race, it was also that you have not acted enough, and given your some of the lack of experience in other areas you have, that you still require more time for acting before before the JC should consider you for appointment. I just wanted to hear your views on that, Advocate Yefa.
Commissioner, briefly, be as brief as possible. When I acted the first time I think it was for 2 weeks, somebody approached me at that stage and said, listen, then was a vacancy available as well, and somebody approached me and said, listen, why don't you go and and apply? I was very, very hesitant, but at the end of the day, I did apply for the vacancy, which I didn't make the shortlist. Through the times which I've acted since then, I've gained the confidence, and I would have not applied again if I was not confident that I think I'm up to do the job. I think in any matter or any field, it's always recommendable that you should have as much as practical experience as well, including acting as a judge. but as far as time allows it. But then the question all remains with respect how many times must you act before it can be said that you have sufficiency. I have been asked, the last time I was asked by Judge President Musi from the Free State Bar to act, that was September last year. They first invited me or asked me to act for 2 weeks, which I could do, and then soon afterwards I was asked to serve for the whole term, but because of other commitments in trials, I was not able to do so. So it was not because of an unwillingness to do that in the first instance, and in the second instance, myself, I'm satisfied that I've gained enough experience.
Just, Chief Justice, through you, just to be clear, so you saying, despite the lack of experience from your practice in some areas of the law, the number of times that you have acted almost deals with that. So you are comfortable that you have.
Indeed, so, Commissioner, yes. As I indicated, there are many, not many, but there are fields in law which I think judges come across even when they're appointed permanently, which they don't have experience and I will learn from that. And again, coming back, I'm not looking for excuses, but in the Free State we are very limited to certain fields, especially constitutional law, because there are not a lot of constitutional matters. But as far as employment law is concerned, labor law is concerned, and administrative, I can learn that.
Chief Justice, it's because of this response that I then have to ask the question that I needed to ask, which is this advocate here. As you know, Section 39(2) of the Constitution enjoins all courts when interpreting law or developing the common law and or customary law to give effect to the purpose spirit of the Constitution. I imagine you are aware of that, and what I wanted to ask you is, while acting as a judge and in some of the matters, have you done so? And if so, could you just give us examples of those cases where you have done so?
The first, yes, thank you, Commissioner. The first one I can recall is indeed the one of the Kopanong municipality regarding the pension fund money, which was not paid out by the municipality. Then I took into account the rights of the citizens of the towns concerned in terms of the Constitution and what they're entitled to. That is what I can think without looking at the judgments at this stage.
Thank you, Chief Justice. Thank you, Advocate here.
Thank you, Commissioner.
Thank you. Commissioner Baloyi.
Thank you, Chair. Good morning, Mr. Hifa.
Good morning, Commissioner.
Mr. Hifa, at page 10 of the questionnaire, and in particular paragraph 6, if you have the questionnaire in front of you, where you're asked about your appearances. Do you appear in court? And this is where the court experience issue comes in. You have ticked the box so you had the option of frequently, not at all, and then you've ticked the box occasionally.
That is correct, yes.
And maybe before I ask my question, let me first make an effort to dispel the impression that people don't get appointed because they are required to have served a certain number of times as acting judges. There's no such. The question behind that question, what it is to test your experience. That's what that question is about. Yes.
Thank you.
So it's not a number of years. Now, you've answered that you appear occasionally, and you say 2 civil trials on average and 1 opposed motion per term, right?
That is correct.
And then on occasion, once or twice a year, I appear in civil appeal. So there's very little court appearance as counsel, very, very little. And that also manifests itself in the 19 years of your practice, you don't have reported judgments, right? That manifests there.
Yes.
Okay. And to the extent that you have grown confident to apply, as I've understood your earlier answer, it is because you have now acted for a certain number of weeks.
And coupled with my experience as senior counsel as well, yes.
Okay. And as senior counsel, you mean since you were called to Silk in 2019?
And even before that, Commissioner, yes. I would say because, as I indicated, I applied for Silk when I noticed that it was more difficult matters, if I can call it like that. But as just to take it further, again, as in any other division, the number of matters which senior counsel, especially senior counsel and senior junior counsels are involved in, are sometimes very limited.
Yes. Well, the only conversation I'm having with you really is, do you accept that court appearances as counsel are very critical to gaining the experience for you to sit as a judge?
Indeed, so yes.
You accept that,
Yes.
and that you really have a positive that there's very few, on your own account, you infrequently appear in court.
Well, if I just can put it in perspective, currently, yes, it is a situation since I've taken Silk,
Yes.
but it was not the situation previously.
Yes.
It has been more.
Okay, all right. The second issue is in the comments from the bar count, your bar, they in paragraph 4 rather, on page 3, they talk about your commitment to values of the Constitution. Now, do you confirm that's a description of you?
Indeed, yes, Commissioner.
How does one see that in your judgments? You've had the conversation with Ms. Pillay about issues of transformation. I'm having a different conversation. It's about in your judgments, you've earlier on in an answer to a question, you haven't done constitutional matters. You've tried to read articles. How do we as a JSC see in your judgments that you are committed to the values of the Constitution, whatever that means? We don't have sufficient time to discuss what does it mean when you say commitment to values of the Constitution. But where do I see that in the judgments?
Commissioner, yes. If I can think of my judgment in general, I did not quite rightly said, I did not refer to the Constitution that many times, but again, I will do so. Well, I would have done so in the past, and will do so in the future as well, as far as the opportunity presents itself, as far as it is necessary with respect. If it's not necessary, and you want to, very often, if I may say so, very often we find in trials or applications, if you don't have anything else to fall back on as far as the merits or the technicalities of a matter is concerned, you fall back on the Constitution, which very often is very helpful. Now, in all these particular instances, with respect, I did. It was quite straightforward, if I must say so. I don't want to say to say that you must read between the lines that I did apply the Constitution, but as far as possible, I will do so, and I will have in the back of my mind it was still there.
Okay, CJ, if I could just clarify that what I was asking really, because I think Mr. Hifa misunderstands me. I'm not making the point. If we are to accept, as the JSC, that you are committed to the values of the Constitution, it's not anything that we can distill from your judgments.
That is correct, yes.
Okay.
But
right.
As I say, if I may, I haven't referred to that because I didn't deem it necessary.
All right. Thank you, CJ.
Thank you. Mr. Heffer, that it does also concern me that after so many years in practice, you say there is only, if I understood you correctly, only one reported case in which you were involved. I heard you correctly.
That is correct, yes, Chief Justice.
Yes, and that's after, what did you say, 32 years of practice, 31 years?
30 years, Chief Justice.
30 years of practice. We had here some candidates on Monday who were candidates for the Constitutional Court. One candidate who also appeared before us in October had been in practice for, I think, 26, 27 years or so before he went onto the bench. And the list of reported cases in which he was involved, I can't remember the number, but it was pages and pages. I would not be surprised if it was over 100 reported cases. Sorry?
It was 350.
And there are others. They may not. Their cases, reported cases, may not have been 350, but much more substantial. Even those who would have done much fewer years than yourself.
Yes.
So it's quite concerning. It's a question of what it says about you in terms of experience, in terms of maybe the types of cases that you get involved in, but the gap seems to be just too huge. You acknowledge that?
I acknowledge that, Chief Justice, yes.
Okay, all right. We have come to the end of this interview. I thank you once again for availing yourself, Mr. Heffer.
Thank you, Chief Justice.
Sorry, Chair.
Oh, is there
Chair,
another?
Yeah, I think.
Oh, I'm sorry. I'm sorry.
Commissioner Breitenbach's hand was up first.
I'm sorry. I didn't see it. I nearly overlooked you. Sorry, Mr. Heffer. I gave you hope that you are about to get out of that hot seat, but I need to give commissioners who are attending virtually an opportunity. Commissioner Barnett, I'm terribly sorry. Yes, please, you can put your question.
Thank you, Chief Justice. Advocate Heffer, would you agree that when exercising discretion, the way the court indicates to parties or the public or the reader that such discretion is not exercised arbitrarily is to indicate the actual facts on which it has relied in exercising that discretion? Would you agree with that?
I agree with that, yes, Commissioner.
Okay, so with this in mind, if we can look at that Kopanon judgment that you referred to, and specifically paragraph 52 and it's on page 45 of the marked bundle, or the paginated bundle. Yeah, so where you exercise your discretion against the punitive cost order, and then you motivate it by saying that although very similar, the facts differ from those in Tabankulu matter. Unfortunately, the reader now doesn't know in which way you say that the facts are similar and in which way you say that they differ. Would you not think that in a judgment like this, something more is required here?
Commissioner, yes, I will agree with you. It might have been more. It might have been better to refer to in which sense it differs, but I was just of the opinion because it differs, and referring to it at that stage, in my judgment, was enough.
Thank you very much.
Thank you, Commissioner Barnett. Is there another commissioner attending virtually who wishes to put a question?
Please, Chief Justice, it's Glynis Breitenbach.
Yes, please go ahead, Commissioner.
Thank you, Chief Justice. I must declare up front that I have known Mr. Heffer for many years. Good morning, Mr. Heffer.
Good morning. Morning.
Goodness is fine. I have one short question. In a criminal matter, how would you evaluate the admissibility of tainted evidence?
Of which evidence, Commissioner? Sorry.
Tainted
Evidence. Tainted evidence.
Tainted evidence in which I don't quite understand the evidence. The question, Commissioner.
In a criminal trial,
Yes.
how would you evaluate the admissibility of tainted evidence?
I will still consider the credibility of the witnesses, and then I will deal with the fact in which regard it was tainted. If I can answer you, if I understand your question correctly, Commissioner. Otherwise, if I'm convinced that it was tainted, of course it will be rejected as evidence.
Thank you very much. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Shabangu, have you got any questions? Shabangu Mdawe.
Morning, CJ. And CJ, my questions have been covered. Thank you.
Thank you very much, Commissioner. Thank you. We have come to the end of the interview. If you have 2 or 3 points, Mr. Heffer, that you want to particularly emphasize to the commissioners to bear in mind when they consider your candidature, you may do so. I give you 3 minutes to do that. But if you feel that all issues have been dealt with sufficiently, that is also acceptable.
Thank you, Commissioner. I don't have anything else to add, and I thank you for the opportunity as well.
Thank you very much. Once again, thank you for availing yourself.
Thank you.
You are now excused.
Thank you.
Thank you. Good morning, Ms. Page.
Good morning, CJ.
How are you this morning?
I'm very well, thank you, CJ, for asking.
Yes. Thank you for availing yourself and making yourself available for consideration for appointment as a judge of the Free State Division of the High Court.
Thank you, CJ. It's an honor and a privilege for me to be here.
Yes. I will ask you to raise your voice a little bit?
Sure. Thank you for that.
Yes, because I think you have a soft voice.
I will speak up. Thank you, CJ.
Yes.
Is that better?
Yes. I'm going to ask you certain questions, and after that, I will allow the acting judge president of the Free State Division to ask you questions, and thereafter, I will allow the representative of the Premier of the Free State, MEC Kabate, to ask you questions, and after that, it will be the commissioners who will get a chance then to ask you questions.
Thank you, CJ.
Okay, right. And I see that in terms of your qualifications, you hold a BA law as well as an LLB. The BA law degree you obtained from the University of the Western Cape, just as is the case with your LLB. Is that correct?
That's correct. Thank you, CJ.
And you obtained your BA in 1991 and your LLB in 1992.
I think both is in 1992. CJ, I just want to have a look at my certificates that I have present here with me.
Mm-hmm.
I remember that when I completed my BA law, I still had one semester course, which I then completed in the first semester of 1992, and I then, oh yes, it is correct. In 1991 is the BA law degree, and then the LLB in 1992. That's absolutely correct. Thank you, CJ.
Would 1991 be the year in which the degree was conferred, but you had completed the studies for BA law in 1990?
That's correct. There was one, I think, one semester course at some stage that I had to carry over. So I obtained the BA law degree in 1991.
So you completed your studies in 1991 because there was one course left, and then the degree was
CJ,
conferred
it's so long ago,
same
but
year.
let me just rectify from my memory. I completed the BA law degree within the 3 years and then obtained it.
But when was the last year?
I think I carried over one of the courses when I started with my first year LLB, and that is why I obtained my LLB in 1992, because I did carry one of the BA law subjects with my first year LLB, because the LLB is 2 years, which I obtained in 1992.
Okay,
Does that make sense, CJ?
I'm not sure if I understand.
Let me
When
rephrase.
did you complete all the requirements for the degree of BA law? Which year did you complete the last requirements of your BA law?
In 1991.
Okay, and the degree of BA law was conferred upon you in 1991 as well.
That's correct, CJ.
Was that as a result of the fact that you were supposed to complete your studies for BA law in 1990, but there was one course left which you had to do in 1991?
CJ, I haven't, it's so long ago, let me just...
Sorry?
I'm also confused now. I started my BA law degree in 1987, so it's a 3-year degree. 86, 88, 80, 90.
87 or 86?
87 I started, and then 88 and 1989 I had to complete my BA law degree.
If it's a 3-year degree and you started in 1987, 3 years would have ended in 1989.
1990.
No, 87, 88, 89, that's 3 years.
That's correct.
Yes, so you should have completed your BA law in 1989. Is that correct?
Yes, CJ, it is correct, it should be. I started in 87. 87, 88, and 89 I had to complete. I think there must have been one course that I carried over because I obtained my LLB degree in 1992, which is a 2-year
leave out
degree.
the LLB so far. Just let's finish with the PA. When did you meet all the requirements for your BA law? When was the last requirement
In
that you met?
1990, I finished, and I only received the degree in 1991.
You complied with the last requirement or requirements for your BA law in 1990.
That's correct, CJ. I think that is correct. I did not really put my mind around this, but I think that was the case, yes, because the graduation only followed the next year in 1991, as per my certificate.
Okay. Does that mean your BA law took 5 years? Or 4 years? 4 years. 4 years.
That could be correct. I carried over one subject, which I did with my LLB in 1991, first year, LLB year.
Okay, so your LLB took 2 years.
That's
but
correct.
your BA took longer than 3 years.
Yes, I carried one subject over that took longer, which I
Okay.
completed together with my first year LLB in 1991, and then completed in 1992.
Yes, okay, no, that's all right. And then you served your articles after that, is that correct?
No, CJ, I started my career initially.
As a legal advisor?
That's correct.
Yes, that was 1992 to 1994 in the city of Cape Town.
That's correct.
Yes.
CJ?
And you were then appointed as a public prosecutor in the magistrate court in Cape Town from 94 to 95.
That's
and
correct,
then you
CJ.
became a state advocate from 95 to 97.
That's correct, CJ.
And then that is January 97. From February 97, you started articles
Correct,
with a
CJ.
law firm in Cape Town, is that right?
That's correct, CJ.
And you finished your articles in July 1998, or 1999? 1999, I think.
I was admitted as an attorney on 20 April 2001. I was admitted as an attorney on the 20th of April 2001.
Yeah, but when did you finish your articles?
Oh, my articles, if you will note from my application form, there was a time I registered the first article, clerkship, with a firm, and then
Yeah,
it's only for a short.
no, Ms. Page,
Sorry.
don't worry about when you registered them. I just want to know when you finished them.
CJ, if I was admitted as an attorney in 2001, the 2-year period would have lapsed already. I think I had a leeway still to complete my examinations. So I remained an article clerk until my appointment as an admitted attorney.
So when did you say you got admitted as an attorney?
On the 20th of April 2001,
Yes. And did you practice as an attorney after that?
that's correct. After my admission as an attorney, I remained in private practice until the 6th of May 2002 when I was appointed to the District Court bench.
I see that you were a magistrate for quite some time. Is that correct? From
That's correct.
May 2002 to February 2019.
That's correct, CJ.
Was that in Cape Town?
That's correct, CJ. Goodwood Magistrates Court.
And that's about what?
17
is that about
years.
17 years?
Correct, CJ.
Okay. Did you do both civil work and criminal work as a magistrate?
Yes, I did. Both criminal and civil work in the District Court bench.
What types of civil cases did you do?
Since 2000 and I think late 2003 up to very late in my reign as a magistrate, I did mostly civil work. The types of work I did was motion court, unopposed motions, motion court, trial court, ranging on all areas of the law, delict, contractual matters, all kinds of civil work matters.
Well, share with the Commission that information because it's important to see the civil experience that you have in terms of what kind of branches of law have you been involved in that will help the Commission have an idea of what experience you have had in civil matters at district court level.
At district court level, as I've indicated, motion court, unopposed matters that ranges on covers many areas. Summary judgment, debt reviews, default judgment, those matters that are normally on the unopposed roll, on the opposed roll as well. Various applications, urgent applications, ex parte applications, opposed motion applications, trial court, many contractual matters, delictual matters, claims. I remember the specific one based on delict was a claim by a plaintiff, an elderly lady who instituted proceedings against the nearby shopping mall. She had climbed up the stairs and there was no...
No, at this stage, don't talk about the facts. I just want the branches
Yes,
of law.
I just
company law, liquidations. Did you have liquidations? Did you, that kind
yes,
of
not
thing?
company law much, insolvencies. As far as company law is concerned, we obviously on the motion court would deal with liquidations of companies, liquidation applications, etc. But all fields that I can think of that I've dealt with on the High Court level, aside from probably a few which are only High Court related matters, it was wide-ranging, all civil areas of the law. I have relatively many years of experience in adjudicating civil matters in the district court. If I might also just add, I was sitting in the regional court, civil court at the time, which only heard civil matters in Cape Town, where some of the matters were transferred from the High Court to the civil court in the regional court to allay the pressure of the High Court for matters that they were unable to hear as a result of maybe heavy caseloads. So those civil matters were also covering many spheres, commercial, delictual, opposed applications, liquidations, contractual matters, some commercial matters dealing with commercial documents, negotiable instruments, hearing
Okay, no,
interlocutory.
that's fine.
Thank you, CJ.
If you kept your judgments in the district court, written judgments,
Yes.
about how many written judgments would you say you?
CJ, I actually kept all my judgments on a flash drive, but somehow I lost it, and there's no way to recover it instead of going back to court and receive it. But it must be in the 17 years. It must be probably 100 or more written. I always furnished written judgments in most of my civil trial matters, even opposed matters, as I've done now while I was sitting in the High Court. I've obtained much exposure in the civil courts, in lower courts, which has laid a very good foundation for me. So when I entered the High Court here as an acting judge, I felt comfortable. When I walked into civil court, I was able to identify matters before me with ease, because the rules of procedure are much the same as in relation to civil applications, opposed matters, and so forth.
No, Ms. Page. My question was about how many
judgments
you have written. Yeah.
It could, if I have to guess, it's 17 years, CJ.
Yes.
There are many. If it's
that's fine. How long have you acted in the High Court?
I've acted in the High Court for 2 stints, and I counted the weeks. It could be about 22 weeks if I add the additional week that I have had to come back to finish a matter at Bethlehem Criminal Court.
Yes. And you said, did you sit both in civil matters, motion court and criminal court as an acting judge?
Yes, I have, CJ.
Yes. And how do you find motion court in the High Court?
If you're referring to motion court, unopposed motion court.
All motion court.
Sorry, CJ.
All motion court.
Unopposed?
Unopposed and opposed.
The unopposed role, I enjoy doing that because I've done that on district court level. We would deal with about 70 matters a day in the district court, regional court, sometimes more than that or less than that. So I enjoyed doing the motion court. It is a lot of work, but with preparation and before you walk into court, I was able to easily just manage to do it. I finished the role probably 1 o'clock. I had about 90 unopposed motion matters, and I was able to deal with all the applications before me. Since I prepared the court roll, I was able to identify the different areas, the different applications with quite a lot of ease and comfortability. I'm quite comfortable to do both opposed and unopposed matters. The opposed matters would be set down maybe 2 or 1 per day, and I would prepare the file, read the papers, prepare, know the law beforehand, walk into court and be able to hear arguments from counsel, and it was quite easy for me. I was very comfortable, I must say, in both in unopposed and opposed motion court.
And how many judgments written judgments do you have in the High Court?
CJ, I have not...
more or less, I don't necessarily...
I can give you more or less. It must be
number.
between 15 to 20 written judgments.
Yes.
I tried to give written judgments in all my matters
Yes.
because I was obviously acting, and I needed to deal with the judgment in that fashion. I did not really give any extempore judgments, apart from obviously when there was a settlement, and I would make it an order of court
Yes.
by agreement between the
And
parties.
did you sit in full bench appeals while you were acting?
Yes, CJ, my first case was a full bench appeal when I started on my first day, and I was
Yes.
requested by the 2 senior judges to write the judgment. Something I think is probably not common, but I took the challenge and I agreed to do so. It required of me, obviously, to delve into areas of the law and spheres of the law that I might not have had so much exposure of, but I quite enjoyed writing this judgment. It required me, if I may still continue, CJ, or have I answered?
No, just answer the question only.
Thank you.
Now, what is the test for the granting of an interim interdict?
An interim interdict.
Or what are the requirements for an interim?
There must be a clear right for the applicant, and no other remedy available to the applicant. There is a third one. If I can just want, if you will allow me, CJ, I just want to have a look at a note.
Did you write it down?
I know I've done one of those matters. There must be a clear right and infringement of that right, and no other remedy available to the applicant.
Are those all the requirements? Or I heard you mention the possibility of a third one.
Those are the elements of the interdict, CJ.
Okay, and and the requirements for a final interdict?
On the return date, obviously, you would have to establish that if the matter was then opposed, you'd have to establish on the papers whether the applicant has in fact satisfied those 3 requirements, the same requirements, and then you will grant the final order.
If it's unopposed?
If it's unopposed, you must make sure that the rule 9 has been served on the opposing side, if it was ex parte, or if the parties were present when you heard the application and the rule 9 was granted, you'd have to, if it's unopposed, make sure that there was service of the order, and make sure that everything that are set out in the papers qualifies or justifies the granting of the final order.
Okay. Why does it matter whether it's opposed or not as to what the requirements are?
If you've granted a rule 9 and it is opposed, you would have to hear on the return date the opposing parties' objections or the case that they lay before you in opposition of the granting of the interdict or the order that was granted, the rule 9. Consider all the papers, apply audi alteram partem rule applies. You need to consider both sides and make a finding as to whether the rule 9 should stand, should be granted, or should be discharged on the papers.
When you are sitting on appeal and you are asked to overturn factual findings made by the trial court, under what circumstances would you interfere with the factual findings of the trial court?
if the misdirection by the trial court is of a serious nature and not based on credibility findings or impressions by witnesses, and you find that the misdirection by the trial court is legally vitiated, or it's simply on the probabilities not correct, you may rectify that on appeal. But obviously the test is that the appeal court should be slow to interfere with the findings of the trial court.
And if you are sitting on appeal, and what's on appeal is a decision taken by the lower court in the exercise of a discretion, under what circumstances would you interfere with the order or decision?
Are we talking about a criminal matter or a civil matter, CJ?
Let us say a civil matter.
Civil matter. CJ, can you just ask me the question again?
If you are sitting on appeal, and what is on appeal is a decision made by a lower court in the exercise of a discretion, under what circumstances would you interfere with the exercise of that discretion by that court in making that decision?
I don't think that you would easily interfere with the discretion of the trial court. But if there are material misdirection and an error in law or misdirection on the facts before you on the papers, you would have to deal with that issue in the appeal judgment.
Yes, thank you. I will now allow the acting judge president to put questions to you, and thereafter I will allow the representative of the Premier of the Free State, MEC Kabate, to do so, and thereafter commissioners, and they will do so to try and see how your appointment would meet the selection criteria which this commission has agreed upon, and those include whether you are a person of integrity, whether you have the necessary energy and motivation, and whether you are a competent person, technically competent, and whether you have capacity to give expression to the values of the Constitution, and whether you are experienced in regard to the values and needs of the community, and whether you have an appropriate potential, and what message your appointment would give to the community at large, and whether you are appropriately qualified, and whether you are a fit and proper person, and whether your appointment would help reflect the racial and gender composition of South Africa.
Thank you, CJ.
Okay. Acting JP, please go ahead.
Thank you, CJ. Good morning, Ms. Page.
Good morning, Acting JP.
In the 21 weeks that you've acted in the Free State, how many times did you do motion court, unopposed motion?
Unopposed motions was only once in the second term. There were about 90 matters on the roll that day.
Okay. During the period of, during the 21 weeks that you've acted, did you do any civil trials?
I'm sorry, AJP, please speak closer to the mic so we can hear you.
Did you do any civil trials during that period?
I did. If I have to count, I think there was one road accident fund trial, about 2 of them that I actually did the trial, heard the trial, and gave judgment. There was also another matter, Khumalo was Minister of Police. It was a trial that I heard and gave judgment on. That's coming to mind. So yes, I have done trials as well. Thank you, Acting JP.
Thank you. At the time of completing your questionnaire, you had 4 judgments outstanding. Have those judgments been delivered? Were
That's
they delivered
correct.
within 3 months?
They have. Thank you, Acting JP. They have. All my reserved judgments were delivered within the 3-month period.
Thank you, Ms. Page. Thank you, CJ.
Thank you, AJP. Excuse me. MEC Kabata, do you have some questions for the candidate?
Yes, Judge President, I do have some questions for
Please go ahead.
the candidate. Thank you very much. There will be 2 questions. The first question will be to Mrs. Page Dumel.
Good morning, Commissioner.
How are you?
I'm a little bit nervous, but I'm
That you see. The question that I want to ask is, I can see that in your CV, you worked at family courts and the children's courts.
That's correct.
Now, why is it that such cases will be not necessarily the ones that you were dealing with? I'm dealing with the cases in general that are still being at family courts, and such cases will be postponed many times and be dragged to take long. Does the judiciary comprehend the emotional trauma and the financial strain on the victims and the witnesses? Remember that the first trauma is when they are violated. The second trauma is a delayed justice. What plans and strategies will you put in place to end this challenge if you could be considered?
If a matter is placed before me, then I deal with it expeditiously and grant and deliver my judgment also expeditiously. Ensure that if it is, I'm just going to speak wide-ranging, if it's a criminal matter where the victims are I think you refer to family law matters, so children's court matters and family law matters. So let me just rephrase. I deal with them always expeditiously, taking into account that there is trauma and there is a need to deliver a better service and to prevent further trauma to the victims. So the moment that the matter is before me, I would not simply postpone a matter, but rather either stand it down if there are things that can be sorted out. Sometimes there is trauma, people can't always, the witness is not able to testify now because of the condition she's in and the nature of the matter and so forth. But I would not postpone it for months or weeks even. I have, in fact, always had the practice in any court where I sat that I finalize my matters expeditiously and that I deliver judgments as soon as possible. When I left the court as a magistrate, I, in fact, had no reserved judgments. I always ensured that I deliver and finalize my partly heard matters. So I would give attention to that if I hear any matters related to family law, children, court matters, etc., and in general, all other matters that are placed before me, Commissioner. I hope I answer the question.
Thank you very much. Though I was not necessarily looking at you as a person, I was looking at you going to work within a collective and having to ensure that the judiciary in general improves its services. My second question will be on children in conflict with the law. And let me put it to you that we have met with the parents of children who are in conflict with the law, because we are having 3 secure centers that are under social development in the Free State. Now, there is a complaint that racism is at play in terms of these cases. The Black parents are complaining that when they request for children to be put under their care, it is never granted. But there are no white children who are being referred to either correctional service supervision nor secure center services supervision. They are released to the care of their parents. Whereas with Black kids, it is never granted. They are referred to either correctional service supervision or the secure center services for children in conflict with the law. So my question would be, are you aware of these complaints, or are you know of the fact that it indeed happens like that? And if you know, and you become a successful candidate, how will you change the situation?
I think to answer the question related to the racism, one of the values of our constitution is that we are non-racial, non-sexist democracy, and our judiciary is subject to the supreme law, which is the constitution, which requires that there be no discrimination based on race. I have, in my years in the district court, dealt with child justice, the child justice court where I sat. I've also done the preliminary inquiries, and I cannot say that I've come across it personally, that would be the trend, but obviously that if it is so, I would frown upon it, and if the matter should be before me, I will ensure that that situation is rectified. I think there are processes in place. If the matter is sent on review, obviously it'll have to come back from the district court for a judge to deal with that, but I do not stand for that. Children, especially in conflict with the law, that they be discriminated against based on their race, as to where they are being detained or released. The principles should be applied equally to all the children who are in conflict with the law. The Child Justice Act has very strong measures in place for protection of children in conflict with the law, related to arrests, related to how they end up in court. The preliminary inquiries are there for that specific reason, so that a magistrate can establish as to whether this matter could be mediated, and whether it should in fact be referred to a children's court, or whether it could be kept out of court. And these measures need to be applied by the police. Children not supposed to be arrested, transported in police vans. There are so much. I'm sure that there are still instances where that doesn't happen, but if it should come to my attention and I'm able to deal with the matter from the level where I'm at, I would obviously rectify this and on review or appeal, if that is possible, and if it is in that forum that it comes before me. But as I say, that is there should not be any discrimination on any level of that kind. I hope I answered the question, Commissioner.
Thank you very much, Ms. Page. Thank you very much, Chief Justice.
Thank you, MEC. Commissioner Moiman.
Thank you, Chief Justice. Good morning, Ms. Page.
Good morning, Commissioner.
Just one area that I want to bring to you. The fact that other bodies like LSSA and also NADEL, they don't support your candidature because one of the areas that they raise is that your experience is mainly in criminal and family law.
I'm sorry, Commissioner, I'm not sure whether everybody can hear you well. Maybe bring your mic closer.
Thank you, Chief Justice. Ms. Page, I was saying that what is your view with regard to the point raised by the LSSA and also NADEL about not supporting your candidature because they say your experience is a bit limited as it is mainly in criminal and family law?
With respect, I would disagree with that comment since I have extensive experience in civil court, both in lower courts as well. Okay, I only have 22 weeks as an acting judge. I have dealt mostly with civil matters and with respect to everyone and with humility, I will submit that it was quite easy for me to adjudicate civil matters of different levels of complexity in a satisfactory and potentially, I'm sure that I will be able to improve should I be appointed. My limited acting experience should also not be seen as on its own, but be seen in the broader picture. I have 17 years of adjudicating experience as a magistrate, where I have dealt with many civil matters covering many areas of the law. I'm fit and proper and capable, competent to adjudicate civil matters of complexity and less complex matters expeditiously and with competence. And I do not agree with the comment that based on a lack of experience in civil law, I should not be appointed. Thank you, Commissioner.
Thank you. The reason why I brought that those comments to your attention is because I went through one of your judgment on page 27, the Rahida and Taukubo.
Frederick King Takubong.
Yes. Can you just, as part and parcel of contesting that assertion from NADEL and SSA, just deal with the aspect of that matter?
Thank you, Commissioner. Did you say what page was that? I am still paging. 26?
27.
27. In this matter, it's like I indicated before, it was my first case when I started acting on a Monday morning with two senior judges, and I had to hear this full bench appeal matter. Looking at if you look at the judgment, I've had to delve into legislation that I probably previously haven't dealt with, and had to really delve into it and do research in the matter, in the legislation. The papers were about more than 800 pages. I stood up, I accepted the challenge to write this judgment, and I feel that this judgment is an illustration that I am competent and capable of dealing with matters, civil matters. This is a full bench appeal judgment that I've written. If you want me to, I could quickly refer to parts of the judgment which illustrates my competence. I've brought it into the contrast with the Constitution. I don't know if I should go into the facts, Commissioner, of the case more, or am I going to accept that the facts are before the commissioners?
You are the candidate, you must say yourself, because LSSA and Nadel says you are not experienced in other fields like mining law.
All right. Thank you, Commissioner, for the guidance. So in this case, it entailed the appellant, who is Rahida Investments, who bought a farm which was rich in iron ore and manganese, as per my judgment. And in this year of purchase, the farm was sold to his son. So there were some circumstances on the factual issues here that I don't want to maybe expand upon, but it required of me to look at legislation such as the MPRDA, the Mineral and Petroleum Resources Development Act, the BBBEE legislation, and Mining Charter. I found that these portions of the legislation was fundamental to, or granted fundamental context to the interpretation of a shareholders agreement, which was entered into between the BBBEE partner, who is the first respondent in the matter, and I had to delve into this legislation, which was not a field I was aware of or very au fait with at the time. It required the application. Was for an interdict against the first respondent to prevent him from acting on behalf of the applicant in the matter, Rahida Investments, since his shares had been removed by the applicant. He was also removed as a director later, and the applicant wished to interdict Mr. Takubong, the first respondent, from acting on behalf of the company Rahida Investments. So, in order to deal with whether the opposition to the application was that the applicant did not have the locus standi to bring the application, and in order for me to make the decision, the central issue in that appeal was whether the motion proceedings launched with the court of quo were properly authorized, and to establish the authority and locus standi of the appellant. It was then necessary for me to determine whether the removal of the first respondent was duly effected in terms of the shareholders' agreement, the 2016 shareholders' agreement, since there were two of the shareholders' agreements.
Thank you, Ms. Page.
Thank you.
I'm happy now.
Thank you
Thank
so
you, Chief
much.
Justice.
Thank you, Commissioner. Commissioner Klaba.
Thank you very much, and good morning, Ms. Page.
Good morning, Commissioner.
Thank you very much.
We have gone beyond 30 minutes, I just mentioned that.
Thank you very much, SJ. I just want to go back to the date when she obtained her first degree, BA. I'm doing that because initially she said she started it in 1986.
Yes, I thought I heard so too.
Yes, and then later said 87, but finished in. So I
Yeah.
just want to have
Yes.
clarity on that aspect.
All right.
Okay, so you started in 1987 to 1989,
Yes.
and then you went back to do in 1990. In 1990, you went back to do that one outstanding course.
But I also I did it together with my first year LLB. So
Correct.
I sort of carried over that one subject. I think, I'm not sure, it's so long ago, Commissioner, but it was probably Roman law. I can't remember,
Okay.
but I did carry one BA law subject over into my first year LLB.
All right. Which then meant that you completed your BA in 1990.
Yes, that's correct.
Is that correct?
That's correct.
All right. I just want to get back to your application.
Yes.
All right. And your application says you acquired your BA law in 1991.
That is the date that is on my certificate on which the degree was
So
conferred.
when you completed your BA,
The BA law.
your BA law,
The certificate or the graduation
no,
date.
leave aside the
Yes.
certificate. When did you complete? When you completed? When did you complete your BA law?
In 1990.
In 1990. So you agree with me that your entry here in your application is incorrect.
It's incorrect because I took the date on which my certificate's date is in 1991, when
Okay.
it's the day on which they
No,
bestow
it's
it.
fine. No, it's fine. It's fine.
Thank you so much,
Then
Commissioner.
I look at your CV.
Yes.
The CV attached to the application says you acquired your BA law in 1992. Can you see that?
I see that. That's also that must be 1991 when I.
So the entry here is also incorrect.
Yes, it's incorrect.
Is it fair to say that you don't pay attention to detail?
Just based on that one aspect, Commissioner, I would say no, it's not completely correct. I made an honest bona fide mistake when I entered that date on there, but I've attached my certificates to the application.
No, it's fine. No, it's fine.
Thank you.
How long did it take you to complete your articles of clerkship? I'm sorry, CJ.
Yeah, no, that's fine.
Thank you. I started in February 1997 that I moved between firms. At the time, as you know, it's very difficult with being a woman and in private practice. I had then been a prosecutor and started my articleship.
No, I'm asking how long did it take you to complete your articles of clerkship?
I started in 1997 and I was admitted as an attorney in 2001.
So how long did it take you to
4
complete?
years.
4 years. And in the period of 4 years, you moved from Van Wyk, I'm talking about
Yes.
the articles.
Yes.
You're doing articles of
Yes.
clerkship. From Van Wyk and Forchi to where you stayed for 6 months.
Yes.
And then to Mohammed and Associate, where you stayed for 5 months.
Yes, that's right.
And then to G. Duncan and Associate, where you stayed for 5 months.
Yes.
And then to Jean Stale and Attorneys, where you stayed, but you don't mention the period. For how long then?
Oh, I stayed there until I obtained until I was admitted as an attorney, and then beyond that, I was appointed up to 2002 when I was appointed as a magistrate. In other words, I was appointed as magistrate from my last firm, Gerrie and Attorneys.
Okay, thank you very much. My very last question, CJ, with your permission. You finished us with your certificate of good standing for 2020, and you undertook to finish us with an updated certificate as soon as you received it.
I have.
Have you
done so.
finally obtained your certificate, your
I
updated
have,
certificate?
And I have furnished it via email about probably 2 weeks before I came to the interview. So it should form part of my bundle, yes.
Thank you very much. Thank you very much, CJ.
Thank you. I thought I may have not heard correctly, but Commissioner Klaba has confirmed that I heard correctly. What happened when you said you started your BA in 1986?
Oh, I did say 87.
I don't think I can forget my first year at university.
No, I did say 87, CJ. I did say 87. I think maybe I spoke a little bit too soft.
Okay, all right. Commissioner Singh?
Thank you very much, Chief Justice, and good morning.
Morning,
Advocate.
Commissioner.
Just one question. I might have missed this in your submissions. I'm just trying to understand your career path.
Yes.
From being a magistrate, you seem to have left or resigned or whatever, and then you formed your own firm of attorneys. And if you could just tell us where that your firm of attorneys was formed, and then arising from that, how come is it that you were given an opportunity to act in the Free State Division? What led to that happening? Thank you.
I've been on the bench for 17 years in the district court and the regional court, acted quite a few stints. I also applied for regional court positions. I was unsuccessful at the time, probably due to demographics in the Western Cape. It was not always possible. And after 17 years on the district court bench, I mean, I had to consider many things. Sometimes in your career path, you decide to step out of your comfort zone and enter into a different phase of your career so as to empower yourself more. I was very happy as a magistrate. That was where I thought I would be and retire, but you need growth and development and you need to listen to that voice inside of you. So there were many factors that I've considered, and when I took that leap of faith and started my own practice for my own account in Cape Town, Goodwood, Monte Vista, it was a very liberating experience for me because now I could expand my field of application of the law more holistically. I had the opportunity to again appear in the High Court in matters, and it was a personal growth development dream, and just simply based on the voice inside of me to always live and not just stagnate in one space. It was a surprise to me when I received a call from the Judge President from the Free State. I think through our association, International Association of Women Judges, my CV had been floating for acting, and unfortunately I did not get that opportunity. And I think it should have been through that means that I received an opportunity in the Free State, which I appreciate has come my way, because to be appointed to a judge is my ultimate goal. And if I had to take a leap of faith and step out of my comfort zone to make myself more available or more to grow myself more on different levels, I think then that probably paid off. And I, like I say, it's all dependent on, you get invited, you don't know. I was very happy and elated when I received that call, since it has been a dream of mine for long to enter or to rise to the High Court bench.
No, thank you very much.
Thank you.
All I can say is keep the faith. Thank you, Chief Justice.
Thank you.
Thank you, Commissioner. Commissioner Matola Lepu.
Thank you, Chief Justice, and good morning, Ms. Page.
Morning, Commissioner.
No, I think my question it was asked by Commissioner Kaba, but one of the things that worried me is that as a candidate attorney, you went through 3 firms of attorneys, and I was just trying to figure out, did you seed your articles that often, or what was the reason why?
Purpose.
Because you'll want to hold on to a firm to finish your articles. Was there a problem?
Commissioner, I think, it's like I just answered, you navigate your career as a young woman in the profession, facing many, many obstacles, and I don't know if I'm still audible, yeah. But when I started, I actually left prosecution. I was prosecuting and I had experience, so I took a dip in my salary and then decided I needed to complete my articles, which was something I felt that if I completed my law degree, I wanted to do. And so when I started my articles at the firm in Paarl with Van Wyk and Forshey attorneys, I was there for 6 months. It was quite a good experience in that, but also life happens at times, and I went through personal issue at the time, so I could not stay on at the firm. And then once I was in a better space in my life, personal life, I then sought articles again and was appointed at H. Mohammed and Associates as articles. It was difficult in the sense that you, as a woman, you sometimes are facing obstacles being a woman, but at some point I was unable to stand for that I was experiencing at that firm, and I decided not even to cede my 6 months of articles and rather sought articles with somebody else. I was with Duncan and Associates, and from there, my articles was ceded to Gerry Stale, where I then stayed and completed my articleship, and I was then admitted as an attorney. So just in brief summary, it's there was a year of it that I did not cede, which I could have done, but elected not to do at the time. For no sinister reason, it just was better for me to do so, and at the time. And I hope I'm answering the question, and if I laid any fears, if there are any in that regard, I would gladly answer any fears that you still may have.
No, thank you. I think my concern is, candidate attorneys, we need to take care of them. So for me, that's why I was more worried. Why you just jumped from one firm to the other? Maybe there was a serious issue.
As I've said, I've had my challenges, and might I also just add that that might be part of the reason why during my period as a legal professional, decided to mentor female students, to reach out a hand to them and to assist them to enter into the profession better equipped, and to know what the challenges are that they might face at some point, and to push through and to stay in the profession and face your challenges head on, which is what I've done, and all on my own. So I hope that answers the question.
Just to say that when we mentor those attorneys now, please don't let them die inside. There's an LPC to report such issues so that we assist you.
Thank you.
Second question is just a comment. The MEC asked you greeted you in Sotho, but you decided to answer in English. So I wanted to find out, do you have a problem, or maybe just?
I don't have a problem, but I was a bit uncertain how to greet in the Sotho language.
Oh, okay.
But not for any reason. Now, obviously, I embrace all our languages and our rich cultures. And I'm prepared to, I mean, when I move to Bloemfontein, to connect with that side of my role as a judicial officer.
Thank you,
Thank
Chief
you.
Justice. Thank you.
Thank you, Commissioner. Commissioner Baloyi.
Thank you, CJ. Good morning, Ms. Page.
Good morning.
Yes. Ms. Page, the issue of experience has been raised with you, and you were told the bodies that do not support your candidature because they say you require more experience, and in certain areas. Now, it seems to me that one of the good qualities of coming into a new environment, or character qualities, is for one to accept their shortcomings, because then you are awake and aware of it, and you will go out to seek advice, counsel, and guidance. So your starting point has to be that you acknowledge and concede that I do lack experiences in certain parts. Is that a fair proposition to make?
That's a fair proposition to make.
Okay. Now, if you look at your form, your questionnaire, you list in paragraph 1, and that is at page 9 of the question, paginated 9. And paragraph 1 asks you to please outline your entire career in the law, giving an indication of your principal areas of legal interest and involvement. This is the time that you are completing this form. And you say prosecuting in municipal and criminal courts for 4.5 years, criminal and civil litigation as candidate and attorney for 5.5 years, magistrate in both criminal and in both criminal and civil courts for 17 years, including stints as magistrate. And then you say regional courts, family court, domestic violence courts, and children's courts. That's how you've captured your entire career in that paragraph 1, right?
Yes.
Okay. And then you go again to paragraph 625 of the same questionnaire. And this is you describing your own experience. You say criminal law 50%, which is the highest percentage that you give. The others are 0, and then you get to 625, and you say contractual 10%, and you don't give details of what is contractual, because there's so much of it.
That's right.
And then you say delictual 10%. Again, you don't give any particulars. And then we are back with family law and other civil work. So your own description, you've given your description. So when a comment is made that other than these areas, you do not have the necessary experience, that is a fair comment, right?
Yes, I would think so.
Yes. And I don't raise this in any way of criticizing, but it is to acknowledge that your journey, the journey that you have taken, it is such that for the High Court, you have many areas of learning and growth that you still have to do.
Yes, I would agree with you that that is the case, that I have only had 2 stints in the High Court.
Yes.
And yeah. So,
Okay.
Well, I'm sorry, I just want to make sure I understand. Did you say you agree with the proposition put to you by the Commissioner that there are still many areas of law where you need to grow?
CJ, the work that I have encountered in the lower courts, I've also encountered in the High Court, similar matters. And obviously, should I be appointed on the High Court bench and be faced with matters which I haven't dealt with before, be that maybe more administrative matters review, administrative reviews, and so forth, then yes, I would obviously be able to prepare myself and to be in a position to...
Hang on, Miss
Sorry,
Page.
I
Hang
am
on.
going off the point.
Hang on.
I
Listen, please.
Okay.
Listen. Commissioner Baloyi put a question to you. You responded, but I did not hear what you were saying. So I've put the question to you again so that I understand what your answer was to her. So I put the question again. Did you agree with Commissioner Baloyi's proposition that there are still a number of areas of law in which you still need to grow? I hope I've captured the question correctly.
You have.
Yes. Did
And-
you agree with her? Did you not agree when you responded?
I acknowledge that you always have to learn. It's a journey of learning forever. I feel that I am competent and having sufficient experience in civil and criminal, family law, and other matters, sufficient so to be appointed to the bench, on the High Court bench.
Does that mean you disagree with the proposition she
Yes,
put?
I do disagree to an extent.
Sorry?
That I do disagree to the extent that I acknowledge that judicial education is for any jurist, you're still learning every day. But I would say that for me to be appointed, judged on my experience so far over the 28 years in the profession, that be taken into account holistically, and that I am confident in saying that I am sufficiently experienced and competent to be appointed to the High Court bench.
But when you responded to her, did you disagree at that time before I intervened, or did you agree?
I agreed that it would be a proposition in general, but I wasn't sure if she is putting it straight to me to say that that is applicable to me specifically.
But she was asking you. You are the candidate.
I think I might have not really seen the question in that way, so I disagree with her.
You see, Ms. Page, one of the things that is quite important for anybody who wants to be a judge, as is reflected in the selection criteria that I read out earlier, is integrity. If you are asked a question, it's important to answer it with integrity and honestly, even if it's against you. You understand?
Yes.
In other words, a candidate shouldn't want to be a judge by all means, to the extent of not giving honest answers to questions that are put to her. You understand that?
I understand that,
So
CJ.
why I wanted clarification was because I understood you not to be disagreeing with her when you responded. And yet there is an answer that you had given earlier on which made me expect you to disagree with her. So that's why I sought clarification. You understand?
I understand. Thank you, CJ.
Okay, all right. You were not done.
I wasn't. Thank you, CJ. Well, I think, Ms. Page, I'm going to put something to you from one of your judgments,
Yes.
still in my theme of seeking to get you to accept that you have room for growth. You still have to grow, and you
Yes.
may not necessarily be ready for appointment at this stage. But let me preface it by saying that I think I accept that the number of years that you have spent in the magistracy is not in itself a qualifier for you to be recommended for appointment, right? It's not what makes you.
No, I agree with that.
Okay. Now, if you could just look at your judgment, and this is in the matter of Buckhazen, NO, it starts at page 51, paginated. 51, Buckhazens, a number of them against First Rand. And this was a simple, it was a simple application of condonation and lifting of the bar.
That's right.
You remember this matter?
I do.
Okay, all right. So this invokes the rules, not even questions of law at this point. Now, you say at paragraph 4, and I'll make a proposition to you at the end. At paragraph 4, you're dealing with condonation. You say, during argument, this is the last sentence. Paragraph 4 is at page 52. You say, during argument, this is considered by the respondent, and it is not necessary to deal with condonation, with the condonation aspect. Maybe for context, let me read the whole paragraph. It's a short paragraph. It says, the application for condonation and upliftment of bar is supported by an affidavit by Jan Andries van Aswagen. The reasons for the delay in delivering the plea are attributed mostly to the complications caused by the COVID-19. And then you say, during argument, this is considered by the respondent, comma, and it is not necessary to deal with the condonation aspect, right?
Mm-hmm.
And yet, in all the following paragraphs, you deal with condonation. You deal with factors that are relevant for condonation to be considered. And here's how you then conclude this. You go to paragraph 24, which you find, paragraph 24, no, there's no paragraph 24, Chair, I've lost my references. Well, maybe I can still make my simple point. So the rest of the body, you're dealing with condonation, the requirements for condonation, and then you say, in paragraph 10, I am satisfied that good cause has been shown by the applicants, okay? And the application for the removal of the bar may succeed. You say that. Now, nowhere in the body do you say, I grant condonation. You just discuss the requirements, even though you started off by saying it's not necessary. And then in paragraph 10, you say, I'm satisfied good cause has been shown by the applicants and the application for the removal of the bar may succeed. I'm not going to deal with that. And then your order is the application is granted, and that's all you say.
All right.
Right? The point I'm making to you is there is so much defect in the body of this judgment, and I can only attribute it to lack of experience and growth, that with time, the kind of errors that are in this judgment would not have occurred with time. Are you prepared to make that concession at least?
May I respond to your summary of the judgment first, Commissioner?
Yes.
So this was an application brought by the applicant to uplift the notice of bar, and part of the affidavit deals with the reasons for the delay in delivering the plea. When I mention the fact that during argument it was conceded, what I meant there is the concession was made that it was in agreement, the parties were in agreement that the delay in delivering the plea within the prescribed period was due to COVID-19 complications, and it was that fact that was that the respondents have conceded, that as a result of COVID, the reasons of COVID, or COVID being the state at the time, that was the reasons furnished for the delay which the respondents experienced. And if one has the application before you, which I probably did not find at the time to deal with, it was those specific reasons given, the courts were closed, etc. So it was that fact that was conceded by the respondents, that both parties have conceded. And then when I deal with the requirements of the upliftment of the notice of bar, I deal with further in the judgment with the way and the manner in which the matter then proceeded. That the plea was then finalized on the 5th day before being ipso facto barred. It was then emailed to the respondents. and the attempts made for them to serve the plea on the respondents, etc. So those reasons were granted not for condemnation, but for the reasons that were given in the application as for the upliftment of the bar, which I then found that the explanation for the delay was bona fide and not made with the object of delaying. So what I'm trying to say is that the notice of bar, the upliftment of the notice of bar is a specific procedure that needs to be, an application needs to be brought, and the court needs to evaluate on the papers.
Ms. Page, can I please
Yes.
can I please interrupt you?
Yes.
The point that I'm making to you is, do you concede that in this judgment, what you do is you set out the law as it relates to condonation? That's what you do. And yet you started off by saying that it's not necessary to deal with condonation. You then go on to discuss condonation, and then you conclude, just before you make the order, you then say, I'm satisfied that good cause has been shown by the applicants, and the application for the removal of the bar may succeed, which is completely incomprehensible what it is that you're doing there. And then you say, I make the following order, the application is granted. And I'm not criticizing you about this judgment. I'm merely making the proposition to you that the errors in this judgment, right, how you get to your order, this order, the errors in it are further evidence that you would benefit from either further training, which may come with you serving on the bench as an acting judge, or mentoring. If you were to be appointed, you are one candidate that, in my opinion, seems would require mentoring. That somebody looks at your work and guides you. You are not ready to sit on your own right judgments and distribute them if this is an example, if this is used as an example.
Thank you. May I respond? The condemnation is not the application that was before me. It was an application for the upliftment of the bar, which required different considerations.
Sorry, Ms. Page.
Thank you.
Shouldn't all of that be clear from your judgment?
All right.
Should you have to be explaining that? Shouldn't that be clear in the judgment?
I would accept that. Obviously, anyone and myself too, I'm always open to be taught and to be guided and to be mentored as mentioned by the Commissioner. I accept that.
Yes. CJ, thank you. Perhaps just to make a last statement, not a question. The first sentence in that judgment says this is an application for condonation and lifting of the bar. Thank you, CJ.
Thank you, Commissioner Baloyi. We have taken quite some time with this candidate, but Commissioner Pillay did raise her hand. Other than her, I propose to look at the commissioners who are attending virtually. I'm not aware that there is another hand. Yeah.
Thank you, CJ. I was going to ask questions, but I think I'll just confine myself to making just one comment, Ms. Page, and that's when I was looking through your judgments. It struck me that the bulk of your judgments were in matters where you sat as one of a number of other judges, either as a full bench or as a two-person bench.
Yes.
And that you had selected judgments in matters where you sat on your own, which were really either interlocutory matters, and I think there's really just one full substantive judgment. That's in the unlawful arrest and detention matter. So speaking for myself, I struggle to get a good sense of your judicial philosophy and your reasoning, and I really was looking for that, to be honest, because I would have liked to favor you as a candidate. I struggle to find that because I was hamstrung by your choice of judgments that you had included in the bundle. So I just want to make that comment, and you can deal with that. Right.
Do you want to say anything? You might not have anything to say. It's up to you.
With the choice of the judgments that I forwarded, there were other judgments as well, which I wrote later on and had to submit for delivery after I'd already sent the judgments in. So also from district court judgments I've sent later when I saw the comments. But I accept, yes, the comments are fair.
Yes. Okay, commissioners attending virtually. Is there anyone who has a question for the candidate?
Yes, Chief Justice.
Yes, Commissioner Barnett.
Yes. Ms. Page, if I may ask, just to refer you to the judgment of State versus Molefe, where there's an automatic review. And once again, it was you and I think Judge Danisa that where you set aside a conviction and sentence regarding a housebreaking and theft. There are two encouraging paragraphs on page 75 and 76 of the bundle where you refer to a judicial officer's duties in terms of section 35(3) of the Constitution, and you quote from the Ramalifa state judgment of the SCA. I just want to ask you, and eventually this was set aside, this judgment in the magistrate's court. My question to you is this: what is your attitude or approach towards descending into the arena?
I do not agree with that. Whenever how I adjudicate all my matters is to give the parties the opportunity to place their case before me, to give strict compliance with Audi Alteram. I do not enter into the arena only for questions of clarity and to maintain the decorum of the court. I would proceed to say something to a witness, a party. I strongly frown against in our democratic state today with the judiciary. That should not be allowed in, or should not have been a problem any longer. And with specific reference to this case, seeding into the arena was really very serious and flagrant breach of the right to a fair trial of the accused person at the time. He wasn't allowed an opportunity to even cross-examine the manner in which that the witness was addressed by the presiding official. It is something in a court where I sit, I am always respectful, dignified, and I appreciate that parties come, litigants come before the court when accused, expecting a fair trial, and this is a clear example of how it should not be done in any court. I hope I answered the question.
Thank you.
Thank you, Commissioner Barnett. Any other commissioner attending virtually who has a question?
No, thank you, Chief Justice.
Thank you, Commissioner Breitenbach.
None from my side.
Thank you, Commissioner Shabangu Mdawe. We have come to the end of your interview, Ms. Page. I take this opportunity again to thank you for availing yourself to be considered for appointment. I'll give you 3 minutes if you have any 2 or 3 points that you want to emphasize to the commissioners to especially bear in mind when they consider your candidature. But if you feel that all issues have been adequately dealt with, that would be fine as well.
Thank you. I just want to thank everybody for the opportunity and for the nomination. from the International Association of Women Judges. It was an honor for me to have been here and to come so far. So I thank you all very much.
Thank you very much. You are now excused.
Thank you.
We are at 12 o'clock, commissioners. I think we should take the tea break and then come back and interview the third candidate. Let's come back at 12:15. We adjourn.
Recording stopped.
Commissioners, I will ask that the candidate be brought in. Good morning, Ms. Van Rijn.
Progress.
Good morning, Chief Justice.
How are you? Well, it's actually good afternoon now.
Good afternoon.
I didn't realize. How are you this afternoon?
I'm well, thank you, Chief Justice.
Yes. Thank you for making yourself available for consideration for appointment as a judge of the Free State Division of the High Court. We appreciate your making yourself available.
Thank you.
I am going to ask you some questions and will then later on allow the acting judge president to ask you questions, and then the representative of the premier, who is MEC Kabate, to also ask you questions. And after that, I will allow other commissioners who may wish to ask you questions. Is that fine with you?
Thank you, Chief Justice, I understand.
You don't mind being asked questions by so many people?
I don't have any choice at this stage.
Because you want to be a judge.
I do.
Okay, no, that's right. That's all right. I see that in terms of the questionnaire that you have filled, you hold 2 degrees, a B. Juris degree, which you obtained in 1984 from the University of the Free State, and an LLB degree, which you obtained in 1987 from the same university. And then in addition to that, you have an advanced diploma in labor law, which you obtained from the University of Johannesburg. Is that correct?
Recording stop. Recording in progress.
That is correct, Chief Justice.
Where does that come from? It's not going to come back again. Okay, all right. Thank you. And you started your working life as a candidate attorney in 1986, is that right?
That is correct, Chief Justice.
And you finished your articles in November 1989?
Yes, Chief Justice. The period at the other attorneys included, yes. The second firm of attorneys, yes.
Yes. And did you get admitted as an attorney in 1990, January 1990? When did you get admitted as an attorney?
1989. I'm correct?
You were admitted
No,
in
1990. I apologize, 1990, the next year.
Yeah, well, if you ask me when I got admitted, I wouldn't make a mistake. It was a big day to be admitted as an attorney.
Yes.
Okay, all right. Anyway, you then spent some time with Symington and de Kock, attorneys in Bloemfontein, is that right?
That is correct.
Was that 1992 up to 1993?
Yes, I left Symington de Kock in December 1993.
Yes. Did you then do pupillage in 1993 and got admitted as an advocate?
I did. Yes, yes, Chief Justice.
Why did you leave the Society of Advocates, the bar, and went to the independent bar by any chance?
That was in 1999. I resigned as a member of the Free State Society of Advocates, and the main reason was financial reasons. At that stage, as a junior member of the bar, we all started off with pro deo work.
Yes.
That is when the state appoints counsel on behalf of an accused in a criminal matter, and at the end of each week we were paid by the state at the registrar's office, and the next week you would submit your next account. At a certain stage, I'm not sure exactly when, after 1994, it changed, and the Legal Aid Board took over those instructions, and then problems ensued with payment. And at the stage when I resigned at the bar in 1999, I didn't receive any payment for more than a year, and I just had so many financial issues that I didn't want to encounter further bar accounts and the responsibility of paying bar fees with those financial problems. And that is the main reason and the only reason why I resigned. It's for financial reasons.
You spent about 11 years or so as a member of the independent bar. Is that right?
Yes, that is correct. I only rejoined the bar in 2011. At that stage, I was already married and decided to continue with practice at the bar.
Yes. Why would it matter? Why would your problem arising from pro deo work make a difference in terms of your financial situation, whether you were in the independent bar or with the Society of Advocates?
The reason is the bar account, the financial responsibility while you're a member at the bar to pay your monthly fees due to the bar.
And if you are a member of the independent bar, you don't have to pay anything?
You didn't? No, we did pay, but it's a minimal fee.
It's minimal fees?
Yes.
Oh.
Just to be a member of a society. I practiced from home. I didn't have the expenses of rent of an office and bar fees, which includes the personnel at the bar.
So you practiced from home?
Yes.
For about 11 years?
Yes.
Okay.
Yes, Chief Justice.
And members of the independent bar, they get briefs from attorneys?
They do.
Yeah.
Yes, I did. I never had a trust account. Those provisions only started later, and not at that stage. No, it was, you had to take instructions from an attorney.
And then you went back to rejoin the Free State Society of Advocates in 2011, and you have remained a member thereof to date.
Yes, indeed so, Chief Justice.
All right. This means now you have been in practice as an advocate for close to 30 years?
actually started in the beginning of January 1995, and until presently it's 27
Well,
years.
I'm looking at your questionnaire where it says you became a member of the Society of Advocates in 1993. On page 5 of
Yes,
your questionnaire, or page 3 of your questionnaire.
But that is the year that I did the pupillage.
Hmm?
That is the year, 1993, that I did the pupillage.
Yes, but pupillage at that time was like 6 months or even less.
Yes,
But after pupillage, you started practicing immediately, didn't you?
yes, I did.
So that means you have been practicing as an advocate for about 29 years?
28.
28.
Yes.
That's quite a long time. Eh?
Indeed so, Chief Justice.
Yes. Have you taken silk?
No, Chief Justice, I haven't. How it works at the bar is that the most senior member on the junior list is the next member to take silk. That is the procedure that we follow, the tradition that we follow. It does happen that a member who's not the most senior on the junior list will apply, and currently I know there's 2 applications that we're waiting for the whether they will be appointed as silks. But currently, and I do have the list with me, I'm currently the 13th member on the junior list from the most senior on that list. So I've not been under pressure to take silk.
If you are not appointed as a judge, how long would you still have to wait more before you get your turn?
It's difficult
to be silk.
It's difficult to say because, as I say, there's two
There are
of my
two-
colleagues who's now waiting. So then it's 11, and it depends on what happens with the other 11 members then above me on the list.
There are 11. Are there 11? Did you say 11?
Well, if
Above
currently, yes, currently I'm number 13, but I know there's 2 that's waiting for their latest patent.
When you say there are 2 waiting, is it 2 of
2 of the junior members?
Yeah, but did you say that there are about 11 ahead of you who are more senior to you that you have to wait for?
There's currently 13 members. I'm number 13 on the list.
You are the most senior.
No.
Junior.
No.
You are the most senior of the juniors.
No, definitely not.
What are you? How many members are more senior than you?
Chief Justice, we currently 70 members at the Free State Bar. I've got the seniority list with me. There's 70 members in total. The senior list is separate. They are 11. Just make sure about my stats. 11 members on silks. No, 12 members. I've counted them. 12 members are senior members. Then there's the junior list. I'm number 13 on the junior list.
There are 12 above you.
Yes, but
Yes.
there's 2 who's currently waiting to hear whether their applications will be successful. If they if they've been successful, their applications, and be appointed as silks, then I will move up 2 places. But I'm not sure whether that will happen.
What is your experience in terms of how many take silk in 5 years, more or less on average? Or per year, whichever is easy to work out.
Maybe 2 per year, because it takes time. Sometimes members wait for 2 years before they receive the answer. A further aspect, if I may elaborate on that, is taking cognizance of the number of members at the bar, the Free State Bar. We're 70 members with 12 seniors. That is a good ratio between seniors and members, because this decision to take silk may have an impact on your income, of which the outcome is not certain. So I haven't been pressurized at this stage to consider that option. I'm comfortable with the situation. And a further aspect, if I may say so, is since 2018, I've been acting for approximately...
Continuously?
No, for approximately...
Intermittently?
Yes, 2 terms every year approximately. So I haven't been at my practice.
Well,
that's also a factor that I take into account.
Well, I would have thought that acting should enhance your prospects of taking silk.
Yes, I agree, but my work at the bar has diminished because I was not available for many months.
You see, part of my concern about you are the second candidate we have interviewed today who took silk after more than 2 decades. Well, the first one has taken silk, but he took it, I think, around the 28th, 29th year of practice. And you said 28 years now?
28 years.
Yeah.
But
I mean, I know some members of the bar who took silk after 11 years of practice, 12 years of practice. I even know somebody in Durban who took silk, I think, from what I was told, after 7 years of practice. He was terribly busy and was considered very good. He was very busy. So when I look at 25 years, 26 years, 27 years, it just seems...
Strange.
Strange, yes.
I understand.
Yes.
If I may
okay.
add another point, Chief Justice, it's the seniority list at the bar is according to the number of years practicing at the bar. So the period that I was not a member of the bar has also been has to be taken into account. So,
yes.
If I can explain it.
So according to them, your seniority is minus 11 years.
Yes, exactly.
Yeah,
exactly.
Which would mean you, according to them, you have about maybe 17, 18 years of practice.
Yes.
Okay, all right. Anyway, you have been practicing for many years by any account as an advocate. Tell the commissioners, the branches of law, that the cases you have been doing fall under.
Initially, as an attorney, I started with litigation, but more delictual claims, motor vehicle accidents, medical negligence claims, RAF matters. It was even before the RAF Act. Then my mentor at the specific firm of attorneys left, Sandton, and he went to the bar, and he convinced me to also join the bar. And that was the main reason why I went to the bar. And at the bar, we usually start off with pro deo work, as I've explained already. That was my bread and butter initially, is to do criminal work also in the magistrate's court, And then the other aspect in the beginning is also the motion court, unopposed motion court. Those days, the judges assisted us a lot by allowing the junior members of the bar to do the pro deo cases, the criminal cases, and then on Thursdays to take unopposed motions, do the unopposed motions first, and then continue with the criminal case, even if we start an hour late. But the work in the unopposed motion court was very important to start your practice in civil litigation. You get exposure and you meet the attorneys while appearing in the unopposed motion court. I would say it's the stage where you get exposure. So that was initially, I continued with criminal work for a long period, and that's where the financial problems ensued, which caused my resignation at the bar in 1999. After that, when I was practicing from home, I continued with the criminal work, but it was possible for me to wait for a longer period to obtain payment, because I didn't have the responsibility of a bar account every month. And with further experience, you tend to get more civil work. So with time, I did less criminal work and more civil work. Opposed motions, Rule 43s, divorce matters, those kind of cases, and also delictual claims, medical negligence matters. I appended one of my judgments in a medical negligence matter, because those are the matters that I started off while being an attorney.
Did your practice involve administrative law cases?
Yes, at the bar I did a few review matters, and then even more so since 2018, when I was appointed as an acting judge. We do our review matters on a Monday. So,
and in your practice, do you have constitutional law cases?
Not that many constitutional law cases.
Commercial
out
law?
And out, I beg your pardon.
Commercial law, do you also
Commercial
have that?
law in the sense of
in your practice?
contracts, yes, contract law, and also regarding insolvencies and liquidations, actually, but not specifically in commercial law as such. Regarding the constitutional law in the Free State, there's not that many cases which consists of constitutional law out and out. But it doesn't mean that I did not get confronted with constitutional issues. For example, in a criminal matter that I did during the last term, I had a situation where the accused put up his hand the second day of the trial and indicated that he's not feeling well. That was not, it was a murder case. The case didn't involve constitutional matters, but at that stage, the accused's right to a fair trial, the accused's right to obtain medical assistance. So I'm trying to explain that we get constitutional issues daily. You're confronted with those issues, but at the end of the day, the trial or the application does not involve exclusively constitutional issues.
Yeah, well, you are the second candidate to tell us that there is not much constitutional litigation in the Free State, so maybe
then I'm
the Free State provincial government is very compliant with the Constitution.
Chief Justice, I have to explain that in the list of reserved judgments, the one judgment that I listed, I think it's the last judgment on the list, that matter was out and out a constitutional issue. It was for an interdict, but it involved constitutional issues. But at the end of that matter, and that was the arguments on behalf of the respondents, the applicant didn't have locus standi to bring the application, and that my judgment involved that aspect.
Yes, okay, no,
So
that's
we
fine.
do get confronted with constitutional issues, but thus
Yeah.
far I'm actually glad to hear that I'm not the only one.
Yes. Now, how long have you acted in the High Court if you put together, add up all the acting stints that you have had, more or less?
The terms, I indicated the terms in my questionnaire. The first appointment for acting position was on during April 2018 to the 27th of May. That was a period for 6 weeks. It was when Justice Molamela requested me to accept the appointment during 2018.
Well, you do set it out there, but I
Yes,
hope...
exactly. 3 weeks thereafter, and then...
Hang on. You do set it out there, but I was hoping you could give
In total.
a total amount, whether in
Total.
terms of months or weeks,
Chief.
even if it's not exact, just to give the commissioners an idea of how much exposure you have had
Yes.
as an acting judge.
Yes, understand. What's not included
You didn't work
here,
it out.
This, understand, Chief Justice, I apologize. What's not included in my questionnaire is the first term also this year. All in all, because there were several periods with part-heard matters that I had to...
It does look like...
8.5 terms.
It does look like on the face of it, it would be more than 6 months to say the least, but probably much more than that.
No, definitely more than 6 months.
Maybe it's close to a year if you put all the periods together.
Yes, I've calculated 8.5 terms, so
Yeah.
that's actually
Okay.
close to 2 years.
Yes. No, that's fine. So when you are acting in the High Court, when you were acting, did you sit in criminal trials as well as civil trials and motion court, all of that?
I
Both
did.
opposed and unopposed motion court?
I did all the aspects that a judge
You did everything.
get confronted. Yes, I was. All the matters were allocated to me. Also, tax law matters, but that matter didn't proceed.
Yes. And how many written judgments have you been able to produce as an acting judge, more or less?
Chief Justice, I inquired yesterday from the Registrar's Office at the court in Bloemfontein, and they informed me, according to the reserved judgment list, because that's the only statistics that's been kept at court, there's approximately 70 judgments.
17?
No,
Or 70?
70.
Okay.
And according to their statistics, it's 7 or 8 criminal matters and the rest civil matters, and also appeals. But it's only those appeals that I penned, not that I...
Yeah, no, that's fine.
So it's about 70.
Yes.
That does not include the extempore judgments.
Yes. And when you have sat on appeal and you are asked to set aside a factual finding of a trial court, under what circumstances would you set aside a factual finding, or would you interfere?
With a factual finding on an appeal. A court of appeals powers to interfere in a factual finding is limited because it is presumed that the court of quo's factual findings are correct. It's only when the record shows that the presiding magistrate or the judge made an error regarding the facts and that the factual finding was clearly wrong, which amounts to a material misdirection. I think the aspect is to decide whether an error made was material or not. For example, if in a criminal matter, a magistrate found that the deceased died due to bullet wounds when the accused fired 5 shots with a pistol held in his right hand, and the record shows that the deceased died due to 4 bullet wounds due to the accused firing a pistol held in his left hand, that would not amount to a material misdirection. So it depends on what is evident from the record.
And if you were sitting on appeal and you were considering whether to uphold or set aside a decision made by a lower court in the exercise of its discretion, under what circumstances would you set aside such a decision?
When a presiding officer has a discretion concerning a certain aspect, often in practice it's regarding costs, it will be necessary to ascertain when sitting on appeal whether the judicial officer or the magistrate or the court of quo came to the decision not arbitrarily, but based on the facts, the issues, the relevant legal principles. For example, regarding costs, the general rule is that cost will follow the result. So if the applicant is successful in his application, then if the magistrate said no, the applicant must pay the cost. That will be a reason if there's no other reasons or for the conclusion reached by the presiding officer. So it depends on whether the finding was based on the principles and the reasons for this particular decision to decide whether the discretion was exercised judicially.
And what is the test for granting an interim interdict? Or what are the requirements for an interim interdict?
The requisites for an interim interdict is whether the applicant has a prima facie right, whether there's an injury actually committed or a reasonable apprehension of an injury, whether the applicant is able to obtain substantial redress by any other means, and the last of the 4 criteria is whether a balance of convenience favors the applicant.
And what are the requirements for the granting of a final interdict?
For a final interdict, there's 3 requirements. That's the Setlogelo versus Setlogelo matter. The first requirement is now it's on a clear right, whether the applicant has a clear right, not a prima facie right, and then the next 2 are the same, whether the applicant has substantial redress in any other means, by any other means, and whether there's an injury actually committed or reasonable apprehension of injury, and all three of those requisites must be present.
Are there any reported cases in which you appeared over the years as a practitioner? In other words, cases in which you appeared which resulted in reported judgments?
Chief Justice, I know of 2 matters, and I've listed them in my
in the questionnaire?
Yes. I don't know of any other.
And the judgments that you have written as an acting judge, are there any that have been reported in the South African law reports? Or no?
No, not as far as I know. I haven't heard anything.
Yes.
No.
Okay, I will now allow the acting judge president to put questions to you, and she will do so, and the MEC will do so, and the commissioners will do so with due regard to the selection criteria that are used by this commission in considering candidates for various positions. They include whether or not you are appropriately qualified, whether you are a fit and proper person, and whether your appointment would help reflect the racial and gender composition of South Africa, and whether you are a person of integrity, whether you have the necessary energy and motivation, whether you are competent technically, and whether you have capacity to give expression to the values of the Constitution, whether you have, you possess appropriate potential, and what message your appointment would give to the community at large. I didn't mention all of them, I just mentioned some of them. So they will ask you crisp questions, and I would urge you to try your best to give crisp answers and deal with the questions as briefly as possible. AJP, please go ahead.
Thank you, Chief Justice. Good afternoon, Ms. Van Ryn.
Good afternoon.
How are you?
I'm well, thank you, Deputy Judge President.
Thank you. You've already indicated that you acted for about 8.5 terms.
Yes.
How did you find this period of acting? Has it prepared you for the position that you are applying for?
Without a doubt. I've gained a tremendous amount of experience through my acting stints. I learn every day. No, it's definitely prepared me to apply for this position and for hopefully obtaining such a position at the bench. Different matters were allocated to me during this period. Initially, I didn't do any motion court work with my first acting stint in 2018. As time progressed, I did motion court almost every term. The last term, 2021, I did motion court the first week of the term as well as the last week of the term.
So, how many times did you do motion court?
During this period since 2018, according to my calculations, 7 or 8 times.
Thank you. At the time you completed your questionnaire, you mentioned that you had 5 reserved judgments.
Yes.
Have they all been delivered, and have they all been delivered within 3 months?
Yes, they've all been delivered within the 3-month period, the one on the last day. It was an appeal regarding the last term when I also acted. I've got 1 reserved judgment, and it will be delivered soon, next week.
And that judgment you picked up during the last term?
During the
first
last term,
of
yes.
the-
I've got no reserve judgments for the time stated in this application, in this questionnaire.
Thank you, Ms. Van Ryn. Thank you, Chief Justice.
Thank you, AJP. MEC?
Thank you very much, CJ. I'm going to have just one question, but I want to make a statement before that. Dumela Mme Van Ryn?
Dumela, Commissioner. Likai.
Ha monate le kae?
Kgotso.
Ke a leboha. Advocate
leboha.
Van Ryn, let me start by thanking you for making me to understand something that has been bothering me for so long. I've been asking myself, why should lawyers be taking a period so long, as ancient as the dinosaurs, before they can be senior counsels and before they could be judges? Your explanation and that of the other candidate has made me to have some sense of this glass ceiling that we are trying to break. What is the cause? It was an eye-opener. Thank you very much. The question for you will be, you know, when you apply for a position, you research about it, you sit and think about it, dream about it, all the challenges that are there, and try to have a plan on how to then resolve the challenges that you know that you are going to meet. And
Yes.
you have been serving in the Free State benches. Now, you, can you tell me about 3 main challenges that you know about the Free State Division, and what would be your plans and strategies to resolve those challenges? Thank you very much. Thank you very much, CG.
Thank you. Maybe just one aspect regarding the question of taking silk. It's not, practicing as an advocate is not like going to school but never reaching grade 12 by not taking silk, a senior status. It doesn't work that way. There's different considerations to take into account when taking silk, because your practice will differ completely, and also your income. Regarding the challenges at the Free State bench, I haven't encountered that many challenges at present. I would say that the problems with the RAF, Road Accident Fund, seems to be an issue. It also has a direct bearing on payment for junior counsel at the bar, because they, for years, haven't been paid their fees while appearing in court on behalf of the RAF. So that is a challenge. The problem will have to be solved within the RAF, within the Road Accident Fund. Because if you have a look at the court rolls at our division, I would say approximately 80% of our trials, which usually start on a Tuesday, is RAF matters. And often there's just no appearance on behalf of the RAF, or the RAF concedes the merits on the day of the trial. So there have been several steps and procedures put in place to regulate and to try to speed up trials and cases on the trial rolls. But presently, I think the the most urgent matter is the RAF matters. I hope that answers the question.
MEC, I heard you say something that suggested that might have been your only question, but I'm not sure. I'm checking with you.
Yes, CJ, I was intending to ask that one question, but I think that MEF and Ryan didn't capture on many of the challenges that are known that we are having. The issue of cases that are being postponed and dragging for long.
Or you want to ask a second question?
Yes, yes.
Okay, all right, go ahead.
Advocate Van Rijn, in the Free State, there are complaints about cases that are dragging too long and that are discouraging victims to continue with their cases. Hence, they would drop them along the way and not continue with the case. Particularly cases that are on gender-based violence and femicide, and cases of families where one of their members would be murdered. So they suffer a double trauma of being victims, but also victims of a delayed justice. So I was asking this question because you would be now at a very senior level. You'll be part of the people who are taking decisions to transform the judiciary system and make it to be effective and efficient to respond to the cases. One other thing that has been raised as a concern is the cases that are to do with children in conflict with the law. There is a complaint that there is racism at play in such cases because the white children are always referred to be under the supervision of the parents, whilst black children will be referred to either correctional services or the social development secure centers. Now, those are challenges that are there. The last one that has to do with that we are struggling with as the Department of Social Development, working together with the magistrates courts, is the issue of the foster care cases, where at the moment we are sitting with a backlog of 5,943 cases. And when I inquire, it is said that it is because we also rely on the dates that we are supposed to receive from the courts. So should you be considered, how will you deal with all these challenges that we don't experience them? Thank you very much.
Thank you. Firstly, there's pressure on the judges. I felt the pressure to finalize the matters allocated to me. Not pressure that I couldn't handle, and I'm sure the other judges as well, because it is our duty to do that, to finalize the matters allocated to us, and that includes criminal matters, but there's different considerations at stake. It's not only the victims of a crime. You also have to take into consideration the rights and privileges of an accused, and that is how you arrive at a fair trial for an accused, because an accused right is enshrined in our Constitution. What I've done, practically what happened to me in the motion court during the last term, last year, was a matter was enrolled on the unopposed motion court, and when I prepared for the matter and when the matter was called, it appeared that there was another application in the same file, and that application was not enrolled on the court, on the list. So what I did was I asked not just to say what the matter is not in the court roll, I'm not going to hear the matter. So I asked that the case stand down, and that at the end of the roll, I quickly went through the second application that was also on the same case number. I prepared on that, asked the counsel, because they were both of them were there, for the applicant and the respondent, because it concerned two different applications. They addressed me on the matter, and I finalized both those applications on the same day. I do believe that the other judges of the Free State Division has the same philosophy to finish the matters allocated to them. Regarding the issue of the children, the white children and the black, I think it's more a matter or problems at the magistrates' court and at the district's court. I haven't encountered any of those problems. Yes, there's problems to finalize the criminal, also civil matters, but it depends on the rights of all the parties before the court. And you have to be fair to all the parties.
You are done, MEC, is that correct?
Thank you very much, Chief Justice.
Yes, thank you. Commissioner Kane, well, I was going to say you haven't raised your hand, but I wanted to give you a chance because sometime earlier I thought you wished to say something, probably in connection with the issue of silk, if I'm not mistaken. So I'll give you a chance before I go to Commissioner Njesi.
Thank you very much, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
What I really appreciated about your application was the report back from your colleagues at the bar who reported how thoroughly prepared you were and that you raised specific issues for debate in court, and you engaged so well with counsel. And that's, of course, as you know, what counsel always welcome from a judge. The aspect of your answers, though, that caused me some concern pertain to the question of silk and whether or not you had applied, why you hadn't applied. You've been at the bar for a long time, and even just counting the years with the Free State Association, it's now about 18 years. And my question is, it seems to me from your answers that you are ignorant of the Free State's process in relation to silk. And it seems that you've made no investigation in that regard because you don't want to apply. If I'm not correct, then you need to correct me, please.
Yes, it's not that I do not want to apply, but at this stage, and considering the fact that my work at the bar has diminished since my appointments as acting judge. You have to remember that while at the bar you have a private practice. If I'm not there, I do not earn an income, and the attorneys do not contact me while I'm at the bench when I'm acting. So for 6 months each year, my door's closed and my light is off. Taking that into consideration, I do not feel comfortable at this stage to apply for silk. Chief Justice remarked, and I do agree with that can be an attribute to say in my application, but I've attained more experience while acting as a judge. The further aspect is, if I do apply to become a silk now, I am jumping the queue of all the members above me on the list.
Well, let me engage with you on that issue, because the impression you've given now in this interview is that taking Silk and Free State is just a long service award. In other words, when you finally make your way up to the top of the junior list, on which you now stand 13th, then you just wait about and Silk may happen. That's the impression you gave me anyway. Yeah. And the procedure which I have obtained from the chairman of the Free State Bar says that a person who is a member may apply for Silk at any time. Yes. Your duty is to collegially advise colleagues who are senior to you that you intend to do so. And we know the policy behind that is so that you don't leapfrog somebody who says, well, if you're going to apply, then so will I. Yes. And you respect that seniority. Exactly. But if the more senior colleague declines to apply, there's absolutely nothing preventing you from applying.
Exactly. That is exactly the correct procedure that we follow, or it depends on your own practice. If I feel that I've got a good practice, I'm actually doing senior work now, there's nothing that bars me from applying to become a
So you would agree then your previous answer to the Chief Justice was not a correct reflection of the practice in the Free State?
No. As I indicated in my answer, there's two applications pending. Both of them are not the most senior on the junior list. Both of them.
Have you actually read the policy document that pertains to applications of taking of Silk in your bar? Have you had a look at it?
No, I haven't had a look at it.
And that must be because you don't intend to apply.
I do not intend to apply at the moment. I've concentrated for the past 4 years now on the reason why I'm here today.
I'm sorry to intervene, Ms. Kane. Just on your last question, you don't intend to apply now, but it also means you have never intended to apply in the past.
No, I haven't. Prior to 2018, I did not consider applying for Silk.
Yes, so your not applying for Silk was not because there were so many people ahead of you. It was because you did not intend to apply. You didn't want to apply.
That's one of the reasons, yes.
Okay, please continue.
It's still a personal decision to make.
Thank you, Chief Justice. I think I should defer to other questions now.
Thank you. Thank you. I think you have certainly helped me, because I thought there was something not right about this hindrance that I had. But before I go to Commissioner Nochesi, let me put this to you. My understanding of how you explained the position before was not that, or did not include saying that you are allowed to apply even if there are others who are more senior to you. My understanding of your explanation was simply that
I'm not the most senior.
There are X number of people who are more senior to you. No. You have to wait for them.
Definitely not. Chief Justice, then I apologize for creating the wrong impression. The tradition is that the most senior on the junior list applies. But it happens, and that's why I explained that the two other members, who applied during, I think, last year, they are not even the most senior, the second or third on the list. They are more junior. So it's indeed, it's possible. It's your based on your own decision.
Well, let me say I might not have heard you saying that the two who have applied are not the most senior.
No, they're not.
I heard that you said two have applied, and maybe I assumed that they were
No.
the most senior, but I didn't hear you say they've applied, they are not the most senior. But certainly the way you explained it on what I had didn't appear
Could
to
be
leave
correct.
room for somebody
no.
junior to say, well, I'm ready. If they are not ready, that's their business. I will apply and I'll just tell them and they can decide whether they want to apply or
No,
not.
the tradition at the bar is if you are not the most senior, you will inform those above you on the list of your intention to apply, and they can decide whether they want to apply with you or.
Yes.
But I've got the list with me, the seniority list, and the one member who applied is the seventh.
No,
from,
that's
from the-
fine. Commissioner Jesse.
Thank you, Chief Justice. Actually, my questions were a follow-up to the Chief Justice's question, but I did not know how to deal with that. On two questions. In fact, before that, I must first commend you. Your judgment are well-reasoned, well-written. I've read through. You kept me alive even in this interview.
Thank you.
Now,
Thank you. Appreciate.
two questions from me. They relate, the first, to the reported judgments. I took time at one stage to look. There are even judges who were more than 10 years as judges. They don't have the written judgment. Who decide on this reported judgment? Do you know what is the criteria? Who decide that a judgment must be reported?
I'm not exactly sure who decides, because it will be at Butterworth's or Judicial, who will decide whether a judgment should be published in the law reports. But because many of the judgments that we write as judges are quite similar to other matters.
Yes.
It's nothing new. It's just a judgment for a particular litigants that you provide. But it's not something of interest or important concerning the law for other legal practitioners. So there obviously will be more constitutional court judgments available in the law reports than judgments from Western Cape or Northern Cape. If it's a matter of specific interest on a specific subject, then it will be published.
Okay. So it's obviously it's not your fault that judgments are not.
No.
Now, the second question is this silk issue. From my perspective, in any way, this is a colonial concept which was limited to mainly male white in the profession for many, many years. Yes. That is, and it was intended it's more related to fees in most of the time. Now, if you don't have a client base that is strong enough, would it be advisable for you to apply to be silk?
No, because taking silk has certain responsibilities. It usually entails that your practice will change dramatically. You don't get the normal matters. It's difficult matters, not only regarding the facts, enormous amount of facts. It usually files and files and files of leverage files containing evidence. And that's why when it's a senior counsel, they also employ junior counsel, maybe more than one, to assist them. So it has a huge implication on your fees as well. But it doesn't bar a junior member, I'm a junior member of the bar, to do more difficult work. I did a matter, I was instructed by the State Attorney's Office in Bloemfontein, a medical negligence matter. I received instructions to appear with a silk from Durban. We consulted, we did opinions, we did the pleadings, and at a certain stage, I received information, or I was informed, that the senior is not available anymore. And I was asked, do you want another silk to assist you, to lead you in this matter, or are you willing to proceed with the matter on your own? And I finalized the matter on my own.
Yeah.
So in actual fact, I did the work that the senior was supposed to do.
Thank you very much. That's the question, and I'm done. Doesn't matter that you are 50 years in practice, 60 years, not applying for SIG. Doesn't really matter in any way.
I agree, and that's why I try to explain that it's not like going to school, but you never reach grade 12.
Okay. Thank you, CJ.
CJ,
Thank you, Commissioner Nochesi.
CJ, I was going to say, let us close on the issue relating to the Bar Council's rules and all those, because I don't see the extent to which it might be relevant.
No. Commissioner Pillay, I don't know whether you are raising a hand or not really. Oh, okay. Please go ahead.
Thank you, Chief Justice. Good afternoon, Ms. Van Ryn.
Good afternoon, Commissioner.
May I ask, in relation to one of the questions posed by the CJ around your reported cases,
yes.
You referred to 2 cases. Am
Yes.
I correct? That's listed in paragraph 6.4 of your application.
Yes.
That's the Van Zyl versus Engelbrecht matter and the
Yes, criminal matter.
The criminal matter,
Yeah.
that's correct. Now, in both of these matters, if I understand it correctly, please you must correct me if I'm wrong. Let's take the first one, the Van Zyl matter.
Yes.
You were led in that Van Zyl matter.
No, I was not led in the matter. I appeared in court in that matter on my own. There was a senior advocate, I believe from the Eastern Cape. He passed away in the meantime. But when I appeared in court, I was on my own. My heads of argument was only my work.
Okay, so you drafted the heads? And
I did the heads and I appeared in the matter.
Okay, so the law reports are incorrect.
They're incorrect, yes.
All right. And then let's look at the second matter. That's the criminal matter.
Yes.
That's the matter where you were approached at the last minute by the Bar Council.
Indeed so, yes.
And you filed heads.
Yes,
and appeared.
Yes.
Did you appear in that matter on your own?
Yes, I appeared on my own in that matter.
Because again, the judgment refers to another advocate, I forget the name, but from
yes.
the...
I was the amicus curiae in that matter, so there was counsel on behalf of the other parties as well.
No, I accept that. I accept that you were an amicus. What I'm putting to you is that the judgment refers to 2 counsel appearing for the amicus.
No.
I just wanted to be clear about that. Someone from the DPP's office, and then they list you as the second counsel appearing for the amicus.
No, I was the only one.
All right. Now, in relation to that matter, let's start there, because this is one of my crucial questions that I have for you. Did you choose to bring a junior into the matter?
No.
You had this
I wasn't the senior, so...
I'm sorry, now I'm really confused. So you were in the matter, right?
Is that now the criminal matter?
The criminal matter.
Yes.
In the matter, you have been requested by the Bar Council to make submissions on a pro bono basis.
Yes.
It's an important matter, and possibly a matter that would be a precedent-setting matter, right?
Yes.
Because they're figuring out the mechanics of the Act.
Yes.
Now, when you get the request from the Bar Council, do you decide to bring in a junior in that matter? That's my question.
No. You have to remember that was a long time ago that I appeared in that matter. And it will actually mean that there's 2 juniors then appearing as amicus curiae in the same matter. But it wasn't that complex that I felt the need to even ask a silk to appear with me in that matter. because that would have been more appropriate to ask a silk to lead me in the matter, not another junior.
All right, let me ask a question related to that then, Ms. Van Rijn. Have you led juniors in your practice?
No.
You've never led any juniors?
No.
All right.
I apologize for interrupting. It depends on instructions from your attorney and from financial implications. So it depends on instructions from the client.
But with respect, Ms. Van Rijn, here you have a perfect opportunity. You have a request from your bar counsel to appear in an important matter.
Yes.
The request is a pro bono request, so there's no financial implication one way or the other.
Indeed so.
It's a perfect opportunity for you to bring in a junior. Firstly, to get exposure on the matter, but also then for you to transfer skills to that junior in how you put together the submissions and then present the submissions before court. So your explanation doesn't explain why you wouldn't have brought a junior into this particular matter, and that's all I'm putting to you.
I understand. At that stage, it was, as I indicated, it was on short notice. I had to go through the work to decide thereafter, listen, I need assistance in this matter. It wasn't enough time. It didn't even cross my mind. I just needed to prepare to appear in court.
Yeah. You see, Ms. Van Rijn, I don't want to open up a topic I dealt with one of the earlier candidates, because I have a very substantive issue I need to turn to now, and I know the CJ is going to give me a look, but it's an important issue which I need to get to now.
Yes.
But earlier I raised with one of the other candidates the plight faced by black women juniors at the Free State Bar. So in that context, it strikes me as, with respect, difficult to comprehend why, when you're presented with an opportunity to get involved in an impact-setting matter, that you don't even consider bringing in a junior, whether it's a black junior or another junior. I can't reconcile the two.
I understand, because that is a challenge to empower women at the bar. The circumstances in that matter is different. That will be my answer. It was on short notice. It was a pro bono matter. I had only a few days to prepare for the matter and then appear in court.
The last thing I'm going to say is, because it's short notice and you've got little time to prepare, there's more of a reason to bring on someone to assist you. But I want to go to the Nkuna matter. Can I ask you to open up your judgment? It's at page 100. CJ, with your leave, I promise you I won't be long.
Okay, last one.
Last one, page 100 of your bundle.
Can you please repeat the page?
100. It's the Nkuna matter. Now, while you're looking for the page, let me just set the background. This is a matter in which 3 applicants were arrested by security firms, private security firms, and they claimed to have been assaulted, they were detained, and they were eventually imprisoned. And they brought this application for, amongst others, damages for unlawful arrest, unlawful detention, for damages for the assault, and then for malicious prosecution.
Dana, where's page 100? I apologize.
No problem. You recall the matter, though, while they're finding your page. It's one of the judgments which you've put up.
Yes.
The Nkuna matter. So I just want to, while you're looking, cover the dates, because that's important. The assaults, the arrest, assault, and detention happens around the 16th of April 2012. The 3 persons are then detained. They get released on the 24th of June 2015. Some of them on the 24th of June 2015 and others on the 21st of June 2017, right? Yes. And then they institute this action on the 21st of May 2018. So obviously from those dates, the big issue that you have to deal with in your judgment is prescription. Yes. Right. Now, I just want to go through your reasoning on the prescription, because you know that what transpired in this matter is that the plaintiffs, or the applicants as you call them, the applicants claimed that prescription was interrupted by virtue of a number of facts, right? This was the incarceration, We know that they were indigent persons, so they claimed that they were in a dire financial position.
Yes.
They also claimed a lack of knowledge, correct?
Yes.
Whether or not there was a valid interruption of prescription. All right?
Yes.
And ultimately, before I get to ultimately, I want you to go to page 107 of your judgment at paragraph 17. And I just want to draw your attention to this crucial fact. The applicants tell you, and it's reflected in your judgment in the middle of paragraph 17, the applicants tell you that the Legal Aid Board refused to assist them. And without financial means, they were not able, before they eventually secured legal representation, they were not able to secure any legal advice. All right?
Yes.
We know that the legal aid steps in to assist them with a criminal matter, but never really with a civil matter until they enter into a contingency fee arrangement with a private attorney.
Yes.
Right. When you assess all of this, which is what you see from paragraph 18 of your judgment, all right, you go through the Lombard decision, which was distinguishable because it relates to facts where the person was outside of the country, incarcerated outside of the country.
Yes.
But if you turn to paragraph 22, you then do refer to a judgment which is directly relevant. And in that judgment, the SCA says, and they're guiding you on interpreting section 13(1) of the Prescription Act, right?
Yes.
And the SCA says to you, the word impediment therefore covers, sorry, I'm reading now the fourth line from the bottom of that paragraph.
Yes.
The word impediment therefore covers a wide spectrum of situations, ranging from those in which it would not be possible in law for the creditor to sue, to those in which it might be difficult or awkward, but not impossible to sue. In short, the impediments range from the absolute to the relative.
Yes.
So what the SCA says in this judgment is that you've got a wide discretion to consider, taking into account all of the relevant factors, whether or not what is presented to you constitutes an impediment for the purposes of section 13(1).
I understand. Yes.
Let's go to how you apply it then. You say the applicants in the replying affidavit stated that their detention restricted their movements, restricted their contact with family and friends. I've already shown you paragraphs in your judgment where you recognize that they were in dire financial straits, that they had lack of knowledge, that they weren't able to access legal aid. All right?
Yes.
And you then conclude that, you say that at the bottom of that paragraph, they were not able to.
I'm sure you are wrapping up.
Yes, I'm wrapping up.
Pillay.
I'm almost at the end.
Okay.
That the only other reason they proffer was their financial position. Despite all of this, you conclude in paragraph 24.
24.
That 24.
Yes.
You conclude that their claim is prescribed.
Yes.
And you say it's because they were not detained outside South Africa. So in other words, you're applying Lombo.
Yes.
And the circumstances did not prevent them from personally pursuing an action. Now, all I want to understand from you is we have the SCA judgment that gives you this broad discretion, right? You have indigent litigants before you who say to you that they have absolutely no access to legal assistance, all right? Despite all of these factors, you still apply section 13(1) in such a way that you close the door to these applicants.
Concerning
So I just
those
have-
claims, yes.
Yes. So I just have two questions. The first is whether, in your view, you properly applied APB, the SCA decision. Right, that's the first question.
Yes.
And secondly, whether, when interpreting section 13(1) and considering the facts, whether you properly applied section 39(2) of the Constitution.
Understand.
Yes.
My answer is yes, I did properly apply the principles in that case referred to, and concerning the prescription, and regarding the issue whether I should have taken more consideration due to the fact that the applicants were incarcerated. The facts of that matter was that the real issue was those, the accused in the criminal trial was presented by an attorney and a counsel during the trial. So they had access to legal advice. That matter went on appeal. There was an application for leave to appeal. I granted the leave to appeal. The matter went on appeal, and I have with me the judgment of the matter when it went on appeal. It was a judgment heard on the 3rd of February 2020. It was delivered on the 20th, a judgment by Judge Daffew, at that stage the acting DJP, and he considered, the court considered my judgment and found that it was not faulted with my judgment. I've got the judgment with me. I can refer to the specific paragraphs regarding prescription, findings made on appeal. So I'm confident that my judgment was correct on all the aspects in that judgment.
I think let's leave it at that.
Just to point
I can
out
see
that-
you don't agree.
No, because an appeal an appeal against an exercise of a discretion is different from whether or not the exercise was correct in the first
Yeah.
place. But
Okay, all
no
right.
further. Thank you.
Thank you. I'm going to go to the commissioners who are attending virtually to see if they have any question. We have taken quite long. Commissioners attending virtually, is there anybody
No
who has a
questions.
question?
Thank you, Chief Justice.
No questions from you?
No
Thank you.
question, fine.
Thank you. Commissioner Barnett, no question from you as well?
Yes, no questions, Chief Justice. Thank you.
Thank you very much. I think we have come to the end of the interview then. In case there are 2 or 3 points that you would like to emphasize and ask the commissioners to particularly bear them in mind as they consider your candidature, I give you 2-3 minutes to emphasize them, but if you say you are satisfied that all issues have been
all the members of the Commission, I truly believe that all the matters have been dealt with. My questionnaires here, I've made myself available for questions, and I trust that
Yes.
concerning the criteria for appointments, it's my honest belief that I fulfill all the requirements.
Yes. Thank you very much. You are now for availing yourself.
Thank you, and thank you to the
Thank you. Commissioners, we are at 22:02. Should we not go for lunch and deliberate when we come back? I think let's do that. Let's go to lunch and then come back and deliberate when we come back. Shall we take less than an hour? Is it fine if we come back at 2:20? That gives us about, 40 minutes? Yeah, okay, let's come back at 2:20. Thank you. We adjourn. You may bring the candidate. Welcome, JP. Yes, and welcome to, is it Advocate Singh, who represents the Premier?
That's right, CJ, and thank you very much.
Thank you very much. Good afternoon, Advocate Murta.
Good afternoon, Chief Justice.
You may take off your mask because I think there is sufficient distance.
Thank you.
Will you confirm whether, yeah, I see I didn't pronounce your surname correctly, did I?
It is actually a Holland Muter, but I'm used to it that people pronounce it in different ways.
But the correct way is Muter.
Holland Muter.
Holland Muter, yes. Thank you. How are you this afternoon?
Nervous, but well.
Yes. Thank you very much for availing yourself to be considered for possible appointment to the bench in Limpopo. We appreciate it very much.
Thank you.
Chief Justice, I'm
yes.
sorry.
Before we proceed, I'm going to allow Commissioner Pillay to say something. She has something to say. Yes.
I'm not sure, does this happen in front of the candidate or not, Chief Justice?
Oh, well, because you are not going to leave us, maybe you can, yeah.
Should I just go ahead?
Yeah,
All right.
because you'll leave us, yeah.
Okay. Chief Justice, I just want to raise that I may be potentially conflicted in relation to these candidates in this batch because I represented one of the candidates in a disciplinary infraction we had with the bar. So I think it's probably proper that I withdraw from this section of the interviews.
Yes. She has discussed it with me. She's represented one of the candidates, and the matter is such that she believes it might come up here. And obviously, if she can't sit in regard to that candidate, she can't sit in regard to the rest of the candidates. Okay. Thank you.
Thank you, Chief
I think
Justice.
some of us envy you for having this afternoon off.
Lucky her.
Okay. We will then start now. Advocate Holland Mutter, you obtained your B.Juris degree from the University of Pretoria in 1978, is that correct?
That's correct.
And you obtained your LLB from UNISA in 1993, is that correct?
That is also correct.
Yes. And you then worked as a clerk in the Department of Justice from 1975 to 1978. And you did national service in 1979 to 1980. You were then a prosecutor from 1981 to 1982. You were a magistrate from 1982 to 1988. and you were a law lecturer at the Department of Justice College from 1988 to 1998. Is that right?
That's correct.
Yes. And you joined the Society of Advocates in Pretoria in 1998. Is that correct?
That is correct as well.
And you have been in practice as an advocate and as a member of that society since then.
That's correct.
Yes. And you obtained Silk in 2018.
I was nominated in 2018, but it was confirmed in August 2019.
Yes. That was like 10 years after you started practice as an advocate? 10, 11 years?
16 years, more
16
or less.
years.
Yes.
Oh, okay. 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 Tell us about your practice as an advocate at the Pretoria Bar. What branches of law are involved in cases that you have been doing?
Chief Justice, if I may refer myself as a general practitioner, medical-wise, excluding tax matters, I did about everything. I did criminal law, I did civil law, personal injuries, insolvency, company law, so the wide spectrum.
Yes. And have you still been doing criminal matters in recent years, or did that cease to be part of your practice after you had attained a certain level of seniority?
No, I still do from time to time criminal law, particularly when representing people in unlawful arrests. So yeah, but the criminal law has become a lot less as the practice grew.
Yes. When you were a magistrate, which was for about, was it about 10 years? 8 years?
It was actually from 1992 to 1997, 82 to 87. It was about five and a half years.
Yes, okay.
And the predominant layoff was in the civil court. My head of the office thought it well when there was a vacancy to transfer me straight into the civil court.
Yes. So you say your practice is basically a general practice?
Yes.
Yes. And you have acted in the High Court?
Yes, I started in 2015. Up until January this year, it totals up to around about 78, 79 weeks.
About 78, 79 weeks?
Yes.
Yeah, so that's quite a lot of acting.
Yes.
Yes. Now, what can you tell the commissioners that would reflect that you embrace the values of the Constitution?
Chief Justice...
About yourself and what you do and whatever. What can you tell them? Because one of the criteria that they look at is whether candidates are people who subscribe to the values of the Constitution.
Well, if you have my nomination letter by my esteemed colleague Mpaga SC, who's now the chair of the Tshwane Society of Advocates, you will see that even around about 1988, when he came to the Justice College as a second-year student, so one of the first black students which were allowed there on the B.Juris course, that I embraced him and I made it for him. I accepted him and helped him to go through the system, where it was a predominantly white male dominion there at the Justice College. So from there on, I made it my task to see to that everyone is treated equally. irrespective of color, irrespective of race, irrespective of creed. He also states that in 1993-4, after he completed his studies, I was the instigator, if I may call it like that, who headhunted him for the Justice College to become the second black lecturer at the Justice College. The first lecturer was, he's now a judge in the Eastern Cape, the Honorable Tokota. He came a year before Mpaga to the Justice College, and we were since then close friends. And ever since then, I made it my task to see to, because that was part of the oath which we took as magistrate, is to see that the law is equally applied to everybody in the country. And I know one of the questions maybe is that my pre-constitutional situation, have I not been contaminated by that? I can unequivocally say no. If I take where I come from, rather humble beginnings, my mom was a single parent as the year after I left school, and I worked during my school vacations to assist with my school fees, etc. I tried to make a difference. Like I set out in my application, like Mpaga states it, and when we were together on the Pretoria Bar Council, where I served for 10 years. Now, the Bar Council since 26 in Pretoria consisted of 50-50 management between AFT and non-AFT. And more than once, on most occasions, it was basically blocks votes against one another. And Mpaga vouched for that in many instances, I played a reconciliatory role to get the two parties together in the interest of the bar. One of the aspects, and one of our former chair is now Judge Norman Davis in Pretoria, we were from the people who made it our mission to fight to expand our pupillage at the Pretoria Bar for especially students from previously disadvantaged backgrounds. And we started gradually to increase our black students and colored students and decrease white students or pupils because it is, in my view, a constitutional imperative that we make it as open as possible for all candidates. Then, as a member of the Pretoria Bar, one of my tasks was to sit on the I was the chairperson of the personnel committee, and when people applied for membership at the Pretoria Bar, to screen them and to interview. And in that, I went to great lengths to make it possible for previously disadvantaged members to join the Pretoria Bar. With the bursary applications, which I've done, I did it now in January again for the bar. I've done it for the past 14 years. To investigate whether it is possible to assist almost every previously disadvantaged student, pupil to be assisted by the general bar. Because in my view, and there are at this stage people like Advocate Manala, Advocate Tipe in Polokwane, who would not have made it if it was not, and I don't want to pat on my shoulder, but for the efforts which I made to have them qualify for bursary applications so that they continue with the pupillage. So I made it that. Apart from that, you would have seen in my application the role I played in the transformation of a white primary school in a predominant white area to a dual medium, and it's now an English medium, with about 90% of the students, which are black students, coming from Mamelodi and Eersterust. Because there's facilities which can be used for these people who don't have it in the townships. Why must we hide that? I was not the favorite of many people in my community, but that was my conviction, to open up the facilities of Rietfontein North, to transform it from a white small school with about 250 pupils, where it is now in excess of 800, of which 90% are black pupils. So all along, it's been my mission to see there that we can assist people and uplift the people of this country. I don't know if you want to know anything else, you're welcome to ask me.
Yeah, no, just the important ones.
Yes.
Yes. And how many written judgments have you produced, more or less? You don't have to be exact, as an acting judge in the High Court.
Reserved judgments, there's a list in which I mailed, and I assume the...
Not reserved, written judgments that you have produced as an acting judge.
Well, the last time I acted, now in January, I was in it was in the unopposed court, so there was not one. But in 2021, at least 5 to 6 judgments which were reserved, which I, within 3 to 4 weeks, completed, and that was handed down. So, yeah, quite often, if you sit in the post-motion courts, about at least 50% of your motions applications, you reserve judgment and you give a judgment in 2 to 3 weeks' time from that. It's difficult for me to say, and I don't, please explain to me what you mean by recent.
No, I didn't say recent, I said written.
Written.
Yes.
Well, there's 59 written judgments, which are reserved, yeah.
Yes, okay, no, that's fine. And when you have acted, obviously, having acted so many weeks, you would have sat in full bench appeals, you have done a lot of motion court, you would have done, I guess, a lot of civil trials as well. Is that correct?
That is correct.
And you would have sat in some criminal matters as well?
I did one full term in Johannesburg in 2019, where I did 3 full trials, murder trials, but I sat in criminal appeals and full court appeals a number of times.
Yes.
The only aspect which the JPF Pretoria did not use me for is for tax court applications or motions.
Yes. And in motion court, did you have occasion to deal with matters where you were asked to declare some legislation unconstitutional?
No, but I was involved in matters where constitutional issues were raised. I remember the one matter in 2020, it was between Solidarity and the Minister of Tourism, which I granted a temporary interdict because, in my view, the publication of the notification was in terms of Section 9 and not Section 10 of the BBBEE Act, and it stopped about 2 billion rands of funds to be distributed before it could be proper heard by a full court. In my view, the wrong vehicle was used in declaring that system available to people. So no, I haven't had opportunity to declare or to refer matters to the Constitutional Court for invalidity, but I've worked with issues where matters where constitutional issues were raised.
Does that apply also when, in terms of matters in your practice, namely, you haven't had matters in your practice too, apart from those that you may have come across as an acting judge? So in your practice, you also didn't get those matters?
I was involved in one matter in the Constitutional Court, part of a team where the Jager SC was my leader, and it was about the consolidation of Department of Justice Acts after the new dispensation came about. It's reported as Es versus Tunzi, 2009. In the Concord. It originated from the Eastern Cape because it was about dangerous weapons. In certain jurisdictions, there was specific legislation, in others, there were not. And there was a constitutional issue which was raised in the Eastern Cape, and De Jager and myself were briefed by the Department of Justice to act on their behalf. And I had to, for my leader, I had to investigate all the publications in the former republics or Botswana and all these, where some of them just took over the existing legislation from the then RSA. In Venda specifically, it wasn't done. So there was a difficulty with regard to the application of minimum sentences with regard to dangerous weapons at that stage. So yes, I was involved in a practice in that instance.
And have some of your judgments that you have produced during your acting stints been reported?
Yes. In my application, there is a list.
Yes.
I can also say that only 2 of my judgments were reversed by the Supreme Court of Appeal. One was in my first stint in 2015, and one was in 2020. But all the others, the SCA confirmed, and all the petitions were refused, where I refused to grant leave to appeal.
And are there any cases in which you appeared as counsel which have resulted in reported judgments?
Yeah, yes.
Yes.
In 2005, there was 2005 or 2007 of Van der Merwe versus the RAF. It was about section 17.4 of the Act with regard to the claims of medical supplies, whether they can go straight forward to the fund or where they have to issue. It was reported. Then there was a matter reported. The late Judge Patel was the presiding judge. It was a murder case on the Circuit Court in Middelburg. And then there was a matter not recently, in which the SCA confirmed it of Patel versus the RAF. So yes, the list is in my application.
Yes.
May I just say that the recommendations made by Mkari SC on behalf of the Polokwane Society, on the last page he lists 7 judgments. It purports to be judgments which I gave. It's only 2 is mine. 5 are from the Western Cape, and I never gave judgments in the Western Cape. So I just want to let the Commission know that you take note of that. That probably he just got it mixed up.
Yes. Okay. I'm now going to give the opportunity to the Judge President to ask you questions. Judge President, I just mentioned, Judge President, that we have agreed to limit the commissioners to 2 questions, but I give the Judge President more leeway because it's your division and you know the needs of your division. So I'll give you some more leeway in asking questions.
Thank you, Chief Justice. Good afternoon, Mr. Holland-Mitter.
Good afternoon,
Thank you.
Judge President.
Is it so that you did avail yourself for interview by this commission in respect of Gauteng?
In the past, yes.
In the past, what was it, October 2021?
October 21 and also October 2019.
So on 2 occasions?
2 occasions.
All right. Right. Now, I would like to have your comment with regards to what the Limpopo Society of Advocates say in respect of your candidature. In fact, they do recognize your experience as counsel and also as an acting judge, of which I also share their view in that regard, your experience. But what they are concerned about is the following. They say the candidate is 65 years old, which is not an ideal age to go to the bench because the appropriate retirement age is 70 years of age to the maximum of 75 years, which by any standard is an overstretch. The candidate's age should count against his permanent appointment to the bench. An opportunity should be given to the young and middle-aged candidates who still have more to offer to the judiciary and the country. Before you answer that, you recall that early this year, after you made yourself available, you did approach my office to introduce yourself, as you did not in the past in Limpopo Division. I also raised the same concerns
Yes.
about that. Now, what's your comment on this issue?
Judge President, and if I can refer to what the esteemed Deputy Judge President Roland Sutherland said during his interview when he was appointed at the age of 70, that age of 70 is a number. If we look at 70, 20 or 50 years ago, it was a total different aspect. We have it that in our generation, especially in the professional field, jurists, medical doctors, architects, etc., that they go far beyond the age of 65. In many instances, people reach maturity when they're in their mid-60s or early 70s. So I can't see that as a factor to be a negative factor in my view. I may just add that in terms of the Judges' Remuneration and Conditions of Employment Act, there's provision there for that a person can stay on until the age of 75. There are certain limitations with regard to your remuneration afterwards and your gratuity, and there are formulas built into that. But if the legislator deemed it, in my view, that it is not fit to proceed beyond 70, then they would have had another provisions in the Act. So no, in my view, there's nothing wrong with me. With my vast experience, I think I can play a very, very meaningful role there in your division.
Thank you. That will be all, Chief Justice.
Thank you. Advocate Singh, I give you the opportunity.
Thank you very much, Chief Justice. Good afternoon, Advocate Wallen-Muta.
Good afternoon.
I too want to refer to some of the comments submitted to the JSC by Nadal. There's two comments I want to put to you, and the first one I'll put to you as information. The second one I'll require a response for. The first one is at 18.4 or 184. It says the applicant has also displayed his commitment to serving the community by offering legal services on behalf of indigent clients and rehabilitating formerly incarcerated individuals, which is commendable. I don't need to comment on it. I was just putting that to you. However, at 185, they go further to say, although Advocate Muta SC, as a legal practitioner, has a wide range of experience as an advocate, senior advocate, and acting judge, we do, however, believe that his appointment will not help in balancing the demographics and representativity in this particular division. Perhaps your comment on that, on that remark.
You want on what the 185?
Yes, 185.
On 185, it is so that in appointments, the racial demarcation, demographics must be taken into consideration. And unfortunately, I cannot change the fact that I'm a white male. But it needs to be balanced that my vast experience and what I can, the role which I can play in the next, if I'm appointed 8 to 9 years there, that should not be just, as they say, with the water being thrown out of the door. If we look at the Limpopo province, then if you want to apply it strictly with the greatest respect, then at the moment there are no colored or Indian judges appointed there. So it is, in my view, necessary to balance it countrywide. Because in the Western Cape, you will there have more people of color. In KwaZulu-Natal, you will have more people of Indian origin as judges. So all in all, I think it should be a balanced situation, and that I take notice of that with respect. I don't deem it that it should bar me for being appointed. Are you satisfied? Anything else?
No, I'm satisfied. Advocate Muta. Thank you very much. Thank you, Chief Justice.
Thank you. Commissioners, Commissioner Singh.
Thank you very much, Chief Justice, and good afternoon, Advocate Holland.
Good afternoon.
One sing following another.
We will sing along then.
No, then everybody will leave. One of the criteria that's listed that we consider, and I'll read it to you, is the proposed appointee an experienced person? Right. A is technically experienced, which certainly you are. B, experienced in regard to values and needs of the community. Now, I would just like to know, what are your links to the Limpopo community? Because you're born in Gauteng, you've applied in the Gauteng bench. What can you say about your links there that can convince us that, yes, you will associate yourselves with the values and needs of that particular community? Thank you.
I don't have direct links with the Limpopo community, but the links which I have in Gauteng, in Pretoria, those are links which you can transfer. That is my involvement, particularly with old age homes, with at the moment the Jacaranda Children's Home where I'm involved. They have in Nelstroom, Modimolle, there is also Abraham Kriel house for discarded youth, and I can just shift my involvement from the Jacaranda Children's Home to the one in Modimolle, which is basically the same organization.
Just to follow up, have you had any other social interaction where you are with communities, NGOs, etc.?
In my community?
Correct.
Yes, I have. In our congregation in Valeria, we have what is called, specifically the Echo Youth Development. It is a non-profit organization under the umbrella of our church. It was started 16 years ago by Pastor Jaco Strydom, who started with one house. There are at the moment 15 houses, of which 5 is in our community. The furthest is in Cape Town. In our community in Valeria, we have 84 kids, of which about 75% are black kids, which are housed in this. Some of them are still school going, some of them are youth just out of school, but which are to be rehabilitated and to be helped into the society. One of our black girls, about 7 years ago, she was a matric in Oostmoed High School in our proximity. But she comes out of a very, very sad background, and her parents could not afford her further education. And by means of bursaries, which Echo Youth Development procured, she completed the studies at the University of Potchefstroom, and in her third year, she ended up on the student council there. So, yeah, we do that. My involvement is specifically at house 15 of the 20. There are 20 houses in the Jacaranda Children's Home in Eastland and Pretoria. My wife and myself, we are the representatives of our church in house 15. We were there yesterday afternoon, and 7 of the 12 boys in our house are black. So we want to see that these kids, when they reach the age of 18 and they can no longer stay there, that they just don't go out back to the gutters. The one guy, a chap who's a matriculant at the FH Oudendal School.
Sorry, Chief Justice. Through you, no, thank you very much. I think you've convinced me. But will I be correct in saying that you do not have any direct links with the community of Limpopo,
no,
but you have links by association?
By association.
Okay.
And I may just say is that by association also with some of the council in Limpopo. And as what I'm doing at the moment in Pretoria, I can also become involved there in the training, ongoing training of pupils there at the Limpopo Bar.
Thank you, Chief Justice, and thank you.
Thank you. I'll go to the commissioners who are attending virtually in the meantime, because I don't see any hand. Yeah, okay. Okay, but I'll go to the commissioners attending virtually in the meantime. Anyone who has a question, commissioners? Commissioner Barnett, do you have a question?
Yes, I have no questions, Chief Justice.
You have no question, thank you.
No questions, Sir.
No question, thank you. Okay. Justice Betze.
Thank you, Chief Justice. Good afternoon, Mr. Holland Multa.
Good afternoon, Commissioner.
I'm having in front of me comments from the Limpopo Society of Advocates, and it is paragraph 51.3 that I want to focus on.
Paragraph?
51.3.
Thank you. Yes, I'm there.
Which reads thus: furthermore, the candidate does not appear to have attempted in his application and subsequent interview to engage in detail with his involvement in the apartheid criminal justice system and how it may have influenced his outlook of the country and its people as a judicial officer. And my question to you is, could you please enlighten the members of this commission as to what your judicial philosophy is?
Thank you. Can I just say, if you look at the paragraph, it refers to a subsequent interview. I think that is a printing error because this is the interview after my application. There was not an interview in between. So I had difficulties to see my application and subsequent interview. I don't know if you follow me.
Could you
But I can...
Could you simply just respond directly to the question? And
Yes,
leave
I
it at
can.
that? Thank you.
My attitude towards the judiciary is that as any magistrate or judge who takes the oath, that you will apply justice to every person before you, influenced by color, race, creed, or gender. My philosophy has always been is that the person who stands there must, whether I represent him or whether I'm a judge or whether I was a magistrate, he must receive the best possible legal assistance. And if, as a judge, there must be justice. It has to be seen to be done towards that person. I am adamant that I was not contaminated in the pre-constitutional situation as a prosecutor. I know that there are instances where magistrates and prosecutors travel together to periodical courts or regional courts. I never did that because I felt it was wrong that you must separate it there on the lowest level. So my attitude is, no, you have to be equally fair to each person.
Thank you, Mr. Holland Muller. I'll leave it at that.
Thank you.
Thank you, Chief Justice.
Thank you. I didn't see any other hand. Commissioner Mapisa Ngakula.
Thank you very much, CJ. Good afternoon.
Good afternoon, Commissioner.
Good afternoon. Advocate Holland Mutter. Advocate, and please bear with me. I'm not trying to.
Don't be too far from your mic.
Oh, sorry. I'm not trying to. I'm not wanting to dig deep or trying to open wounds of the past unnecessarily. But I am interested to know, because from what I have read here, I've read that you were a prosecutor during the period
1981-82.
19 years. I'll be interested in the nature of the cases you were dealing with.
Well, I was a prosecutor in the district court, and the normal cases we heard there was the normal shoplifting, assault cases, etc., etc. In the early 80s, when there was unrest starting to, those cases were heard in the regional court. I wasn't a regional court magistrate, prosecutor, so no. I was not involved as a prosecutor in any matter which can be related to previous unrest under those circumstances, no. It was normal cases, shoplifting, theft, housebreaking, etc., which is normal in the magistrate court.
Okay, thank you very much. Then there is someone here. I'm sorry, CJ, because the bundle which I have here is very confusing as compared to what I had earlier on, where I have 7.1, which
Was that on the questionnaire?
on the, I think somebody was trying to summarize what is in the questionnaire, or maybe minutes of the last meeting, I don't know. But it talks to the extent and breadth of the candidate's professional experience. Then it goes on to say, the candidate, however, indicated in answer to question 5 of the JSC's questionnaire that he only acquired his B.Proc qualification in 1988, 3 years after he claims to have been employed as an appointed prosecutor.
No, I never obtained a B.Proc degree. I obtained a B. Juris in 1978 and then my LLB in 1993.
Okay. Can you
Is it
please?
possible you might have confusing it with another candidate?
No, not at all.
Oh,
This is, yes, advocate H.L. Mota.
okay.
And then it goes on to say, as a prosecutor requires a law degree as a minimum qualification, and as the candidate did not have such a qualification in 1981 to 1985, it is unlikely that the candidate was appointed as prosecutor during that period. What I am reading here is what is written in this file. So, and therefore, the candidate's work experience for the period between 1981 and 1985 is accordingly disregarded for the purpose of assessing the candidate's relevant experience, and he ought to be given the opportunity to clarify this apparent contradiction.
No. That's with the greatest respect wrong. The qualification in those days to be a prosecutor and or magistrate was a B. Juris or Diploma Juris qualification. I had my B. Juris, which I obtained at the end of 1978, so I was qualified in terms of the Magistrate Court Act to be a prosecutor, in terms of the Criminal Procedure Act, and in terms of the Magistrate Court Act to be a magistrate. That was the minimum qualification, and I had it since 1978.
Okay. Thank you very much, Sir. Thank you.
Thank you. Judge President Lekodi will ask a follow-up question.
I think somehow the commissioner spoke about unraveling the healed wounds of the past. And you are aware that 85 and 86, everything was on fire. First, because of the first state of emergency in 1985, and the total state of emergency in 1986. And if I understand you correctly, you were a prosecutor at that time, am I right?
No, I was a prosecutor 81 to 82, and at the end of 82, my head of office made me the civil magistrate until 87 when I left for the Justice College.
Okay, let me put it differently this way. 81, 82, there were still lots of public violence matters, am I right?
Yes, you're right.
And I understood you to be saying at that time you had nothing to do with those matters because they were tried in the regional court.
That is correct.
But their first appearance would have been in the district court, and I'm talking from experience. In those circumstances, the district court public prosecutor will oppose the release of those people on bail with force. Would I be right?
That is right. If there were reasonable grounds to oppose their release, it would have been done. But I recall none of those which I dealt with. I was not involved in that.
Yes, but your problem is that you're saying, as far as the public violence matters were concerned, you had absolutely nothing to do with them because they were tried in the regional court.
Yeah, but If I can, sorry?
Yes, you may proceed.
If I can say that in Witbank we had 3 district courts. So the cases which appeared there and which were clearly earmarked to go to the regional court, they were, at that stage, you had to obtain a regional court date within 1 to 2 months. The matter would come back to your court as an ordinary prosecutor maybe once or twice, and then it's referred. If there were applications for bail and so on, there would have been formal bail applications or applications to release, and I can unequivocally say I was never involved in such an application.
Okay, thank you. I wanted to make a follow-up, but I'm not going to do that.
Okay, thank you. Commissioner Badoy.
Thank you, Chair. Thank you. Thank you, CJ. Good afternoon, Mr.
Good
Mann.
afternoon, Commissioner.
Yes. You became a member of the Pretoria Bar in 1998.
That's correct.
And you were called to Silk in 2019.
Yes.
Right? And yet you say you had only 1 pupil.
No. I had 4 pupils while I was an ordinary member.
Well, you mentioned a pupil. You don't, I've looked at your application, and I'm trying to find that page. You mentioned only 1 pupil.
On what page is that? Because
But anyway, you say you had 4.
yes, I had 4 pupils.
And that is 4 in 18 years that you were at the bar.
The situation is that when I became a member of the Bar Council, you were relieved of that duty and of the training committee because you were daily involved in the training of all the pupils. So they allocated the new pupils to council who were not on the Bar Council or on the training committee.
So you were on the Bar Council for how long?
10 years. And I was on the training committee since 2005, so it was about 4 or 5 years after I joined the bar.
Now, you've got a letter of support here from Mr. Mpacha. Now, Mr. Mpacha is no longer a member of the Pretoria Bar, right?
He's the Tshwane Society of Advocates.
Yeah, and how does that come about, that Society of Advocates?
The Tshwane. Yes. They broke away during the national lockdown towards the end of 2019, beginning of 2020. There was turbulence in the Pretoria Bar with regard to the lease agreement of the office in town. And they were a group who went to the east where they formed a new society.
What is the racial demographic of that group?
Group?
Yes.
It's basically, but for one, it's a black group.
So black members left the Pretoria Bar to go and set up somewhere else?
Some of the black members, yes.
And the reasons were what?
The reasons was because there were difficulties between some of the other buildings and High Court chambers in town about the lease agreement which existed there. It left, with all the groups who had previously left to the east, it left High Court chambers with a burden of empty chambers, a long-term lease, and most of the junior blacks who remained behind. And you will read further that I refused to move to the east because I said somebody has to stay in town with these young black council. They need to have, and we were 3 silks who stayed behind up until when the lease agreement was finally terminated.
So if you do get appointed, in fact, you are saying these black juniors will now be left without your support?
Well, the lease agreement has been terminated with the lessor, so there's no longer lease. They have vacated the building at the end of February, and they are now in other buildings.
Okay. And we know now, and I raise this because you do speak to it, and not everybody in the room understands the politics of the bar. There was, at least let me say, in Johannesburg we still have, but in Pretoria as well, you had the co-governance model,
yes.
where you had 50% AFT, Advocates for Transformation, and you had what we call the main bar, right? And the Advocates for Transformation were overwhelmingly black members.
Yes.
You accept that? Okay. What has happened to that co-governance arrangement?
The co-arrangement came to an end of 2020, middle of 2021, when the majority of the bar, I was not present there because I didn't want to go to such a meeting. The Constitution was amended, making provision for new buildings which were created in the East, and the termination of the High Court lease. And then the whole restructure took place. There are still people in what is called New Court Chambers, which is adjacent to where High Court Chambers is, which is predominantly black.
Okay. Can I just ask you, just to assist the members who are not members of the bar, what is the co-governance model? What is its purpose? What was its purpose?
The purpose was of co-governance of 50-50, because at that stage, when it came about around about 2007, after the then chairperson of the GCB, Norman Arends, met us at the general meeting, it is to enhance the young black, because they were far in the minority. And transformation would not play a role if you have a governance by a simple majority, because they will every time be voted out. And that is why it was part and parcel, and I fought for that with Davis, the Honourable Judge now, and with the previous chairperson, Francois Boertes. We fought to have this 50-50 governance, as suggested by Norman Arends, so that we can protect the interest of a minority group.
Yes, and now that protection is no longer there.
That protection, unfortunately, is no longer there, but they have a similar protection in the new constitution, where in each building, depending on how many chambers are there, they must have at least one non-white and one white representative representing each building. So in fact, it is basically still a 50-50 governance, but there's no longer a formal AFT in Pretoria.
Well, there is no...
Try and wrap it up. I
am wrapping up, Jim. There is no formal AFT, but the Constitution of the Pretoria Society of Advocates
guarantees
does not provide for a 50% AFT that represents overwhelmingly black advocates. That's what I'm establishing with you.
No longer, yes. You're correct.
And you didn't attend, you chose not to attend the meeting where the decision was made to collapse that 50% arrangement, because you didn't agree with it, but you made a decision not to attend.
Because they knew what my stance would be, but we were outvoted, and that is why it was a waste of time, and that is why I have alliances, although I'm not a former member of the Tshwane Society there where Mosampaga is, but I underwrite what they do.
All right, thank you, Mr. Holland. Thank you, Chief Justice.
Thank you. I don't see any other hands. I have already gone to the commissioners attending virtually. We have come to the end of this interview, Advocate Holland Mutter. Thank you once again for availing yourself. I will give you 3 minutes. If there are some points you want to particularly emphasize that you would like the commissioners to bear in mind when they consider your candidature, but if you feel that issues have been dealt with adequately, that is also fine.
Thank you, Chief Justice. I just want to say is that my track record is very clear, and Mpaga, my good friend, speaks about that, and my application speaks about that, is that where my heart lies with regard to transformation, with regard to the development of our country. If I can use the simple example which I normally use when I talk about this, if we take the Brazilian national soccer team, they are from lily white to dark black, but they're Brazilians, they're one team. And I pray for the day that when the Bafana goes onto the field, that they also have the support of the majority of people in this country who support rugby and not football. We took a hiding against the French last week. Percy Tau wasn't there, but it was a good learning experience for our guys. My heart is that I'm pro-transformation, that every person in this country, irrespective of color, race, gender, must have equal opportunities. But there are vulnerable groups, such as women, such as children, which needs extra protection. And that is what each and every one of us, judges, Each and every commissioner, every person in this country has that obligation to see to that we protect the rights of these people who cannot stand up for themselves. And that is why I'm involved in the Jacaranda Children's Home, where we can try and make a difference in those castaway kids' life so that we can make them useful citizens of this country. As the judge, if I'm appointed, I can get involved, and I want to get involved at the Limpopo Society, like what we had before lockdown in Pretoria. From time to time, retired judges Bertelsmann, Cynthia Pretorius, once a month they held informal information sessions with counsel who wanted to attend it, and aspects of the practical implications of the court was discussed. That unfortunately died, something which can be revived. Thank you.
Thank you very much, Advocate Holland Mutter. You are now excused.
Thank you, Chief Justice, and all the commissioners. Best of luck for the rest of the evening.
Thank you very much.
I'm retiring. You're not. Some of will sing along. Thank you.
Thank you. Bye-bye. Are there some commissioners who? Yes. Only one. Okay. Two. I'm sure they'll be here. That's right. Yeah. No, the one is recused. You remember? Yeah. Good afternoon, Mr. Ledwaba.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm okay, Chief Justice.
Yes. Thank you for availing yourself for consideration for appointment as a judge. We appreciate that you have made yourself available.
Thank you, Chief Justice.
I will ask you some questions, and after I have finished, I will ask the Judge President to ask you questions, and after that it will be the representative of the Premier of Limpopo, and then the commissioners will come after that.
I understand, Chief Justice.
I see that you have 4 degrees behind your name.
Yes, Chief Justice.
It's a BProc degree, it's a LLB, and 2 master's degrees.
That's
Is that
correct,
right?
Chief Justice, yes.
And you got your BProc degree from the University of Limpopo, and your LLB from the University of Pretoria, and the LLM, the 2 LLMs from the University of, one from the University of Pretoria and the other from UNISA. Is that right?
That's correct, Chief Justice.
Yes, and your BProc you got in 1988, your LLB 2002, LLM, first LLM 2003, and second LLM in 2018.
That's correct, Chief Justice.
Yes, and you started your working life as as a private teacher, is that right?
It's just correct.
Yes, and but in 1989 you started your articles with a law firm called Ramotipa and Makobe, is that right?
The first one was Ramotipa, and then the contract was ceded to Makobe Attorneys.
Yes.
Yes.
But you also worked for the Lawyers for Human Rights from 1991 to 1993.
That's correct, Chief Justice.
Initially as a legal officer and then later as a coordinator, is that right?
That's correct.
Yes. And then when were you admitted as an attorney?
I think it was 1993, I believe.
It was 1993.
I think so, yes.
Okay, and in 1994 you were a director in Moima Lidwaba Incorporated up to 2006.
That's correct.
That's about 12 years?
That's 12 years that I was a partner there. Yes, Chief Justice, yes.
That was about 12 years, is that right?
Yes, I think it's 12 years, yes.
Yes. And then from there you moved to the Society of Advocates in Pretoria. You were admitted as an advocate in 2008, and you continued to practice as an advocate, is that right?
That's right, that's right, Chief Justice, yes.
Yes. But do you practice both in Limpopo and in Gauteng?
Yes, that's correct. I hold
You have chambers in both?
No, I hold a door membership in Pretoria.
Yeah.
And now I've got a chamber in Polokwane. But I started in Pretoria before I moved to Polokwane.
Yes. I see that you are also a part-time commissioner at the CCMA.
Yes, I did that. I no longer, but I was there until I think 2014, somewhere there.
Or up to 2008 to 2014?
I think so, yes.
Okay. And you are a member of the BLA?
Yes.
Right. Now, your practice when you were an attorney, did it involve appearing in courts and conducting trials on your own without counsel?
Yes, I got right of admission as an attorney then, but we could apply to have a right of appearance at the High Court. I did that.
Yes.
Yes.
And what types of branches of law did the cases you did as an attorney relate to?
Well, as an attorney, we were doing mostly criminal cases then.
Yeah.
Yes, mostly it was criminal cases as an attorney.
And you appeared both in the district court and regional courts?
Yes, I did.
Yes. And then you moved to the bar, and you have been a member of the bar now for, what is it, 14 years?
Yeah, I think it's 14 years, yes.
It's 14 years.
It's 14 or 15 years, yes, somewhere there. I thought the country said 15 years, yes.
And what types of branches of law are involved in the cases that you do in your practice, or have been doing during your time as a practitioner, as an advocate?
I do a variety of cases, but the one thing that I didn't do is a criminal case. I didn't do a criminal case as an advocate, but I did commercial cases. I did constitutional law cases, but the criminal cases I didn't do, but I did that. I do a lot of cases there.
So you don't do criminal cases anymore?
I haven't received a brief to do a criminal case since
Not that you don't want to do them.
I do want to do that, but I don't, I just didn't receive the brief here.
Yeah.
I would like to do that.
But the ones that you have been doing, did you say some of them are constitutional law cases?
Yes, some of them are constitutional.
Administrative law as well?
Yes.
And what other types of cases, what other branches of law?
Well, I also did matrimonial law cases. Also, I did also matrimonial cases as well.
Please raise your voice.
Matrimonial cases, contract laws, I also did those cases.
Yes.
Yes.
Okay, and Have you acted in the High Court in the meantime?
Yes, I did from 2019.
Yes.
Yes.
So if you combine the years that you have been in practice as an advocate with the years you were in practice as an attorney, how many years have you been in practice?
I think they were around 28 or so.
Around 28 years?
Yeah, 13 plus 15 is 28, yeah.
Yes, okay. Okay. And how long have you acted in the High Court?
I acted from 2019. When I count the weeks, I think it was 49 weeks.
Sorry, 29 weeks?
From 2019, yeah.
Okay. Have you 49?
49 weeks,
Oh,
yes.
I'm sorry.
Yes,
49 weeks,
yes.
okay. Round about how many written judgments have you produced as an acting judge over the period?
Well, I never counted them, but there are many. I never sit down and counted them.
About 50 maybe? Or more than 50?
I don't think they reach 50. I don't think so.
Maybe 20 or thereabout?
Maybe 20 or so, yes, yes.
Okay, all right. And when you have acted in the High Court, you have sat in full bench appeals.
Yes,
You have done motion court, opposed and unopposed. You have done criminal trials. You have done civil trials.
I never did a criminal trial, but I
Yes.
did civil. I did a criminal appeals, but never a trial in criminal. No, I never did that.
Yes.
Yes.
Okay. Are any of the cases that you have appeared in, either as the attorney or as an advocate, have any of the cases in which you have appeared been reported?
Yes, I have one case that was reported that I listed, this case of Pasha versus Pasha. It was
Yes.
reported, yes.
Okay. And the judgments that you have written as an acting judge, has any of them been reported?
Yes, they were reported. some of them.
Do you remember about how many?
Now I can remember two, sitting
Okay.
here, but there may be more, but I remember two now.
Yes.
Yes.
Okay, all right. What can you tell the commissioners that can show that you are somebody who subscribes to the values of the Constitution?
Well, to start with, I did a master's in constitutional law. I did a master's, one of the masters, the first master's that I did. It's a constitutional law related, the first master's. But then from there, I was involved with the Lawyers for Human Rights, where we're doing most constitutional law related cases, and also some of the cases that I dealt with as a judge. The most constitutional related, yes, most of them, they've got some elements of constitutional in them. Yes.
Okay, I'm going to now give the Judge President the opportunity to put questions to you. He will do so, and after that, I will allow Mr. Singh, Advocate Singh, to also put questions to you. Judge President.
Thank you, Chief Justice. Good afternoon, Mr. Ledwaba.
Good afternoon, Chief JP.
Just on your acting stint, you mentioned an overall total of 49 weeks.
Yes.
Were you in a position to sit in both divisions of the High Court Limpopo, that is Polokwane and Toyando?
Yes, I did.
Now, over and above the 49 weeks you have acted, did you, over and above this, ever acted pro bono? If so, for how long in that,
Yes,
in that division?
I didn't count the weeks, but I remember two terms that I did, that I can recall now, that I did matters on pro bono basis.
Thank you, Chief Justice. That will be all.
Thank you. Advocate Singh.
Thank you, Chief Justice. Good afternoon, Advocate Ledwaba.
Good afternoon,
Nice to see you
Commissioner.
again.
Nice to see you as well.
Okay. I want you to respond to a comment submitted by the Limpopo Society of Advocates.
Yes.
At point number 35, 35.1, and I suppose emanating from section 174 of the Constitution, it says the candidate's appointment will help to rate the racial composition, but not the gender composition of the bench.
Yes.
Given the current composition of the Limpopo division,
Yes.
how would you respond to that comment?
Well, I know that we've got only one female judge there, but there are 2 positions that have been advertised. So having that in mind, in terms of Section 174(2), in terms of the gender, I will be contributing to the gender profile.
You mean the racial aspect and then the gender?
Yes, I'm black, and I'm talking about race, and then I'm a male. But if they're talking about gender and racial. So if it's a gender, as a black, I'll be contributing in that respect.
No, thank you very much. Thank you, Chief Justice.
Thank you. Commissioner Nyambi.
Thank you, CJ. Afternoon, Advocate Letwaba.
Afternoon, Commissioner.
If you can just share with us something that you think it's very significant that we have to consider today that has happened between the last time you were interviewed and now, that you think now you stand a better chance?
I've never appeared before this commission. It's my first time.
It's your first time?
Yes, that's my first time.
No,
I've
so
never appeared before this commission.
Okay.
That's my first time.
If you can share with us your understanding of judicial accountability.
Well, judicial accountability, as a judge, you account to the. You account to the client, you account to the attorneys. The people appeared before you. You account also to most often to the Constitution. You account also to when you take an oath, you take an oath in terms of Constitution and to be loyal to the Constitution and the Republic of South Africa. That's accountability. I'll describe it in that way.
Your understanding of the doctrine of the separation of powers?
Yes, the separation of powers, where we're talking about judiciary, we're talking about the executive, we're talking about parliament. Those are separate. There are mechanisms built in between, so that none of the other stray into the other's territory. So they must be separated.
Thank you, Advocate Letwaba. Thank you, CJ.
Thank you, Commissioner. Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Advocate Letwaba. I'm here. Yeah.
Good afternoon.
Just 2 questions. One relates to the fact that you were born in 1953.
No, I was born in 1961.
1961. Oh, am I looking at the wrong person?
1961.
I made you much older than you are.
No.
All right. So 1961.
Yes.
I wonder where I got that from.
Yeah.
1961, I'm very sorry.
No.
So I'll pass that one. Sorry, Chief Justice. The second question
Yes.
relates to your disclosure, I think it's on page 27, section 3, financial and proprietary.
Yes.
And I hope I've got this one right. So I'm on the right track.
Yeah, that's the right track.
Then you are a sole member of Turana Properties and Leisure Close Corporation.
Yes.
And thirdly, you are a sole member of Letamaga Transport Close Corporation.
Yes, that's correct.
What I'd like to know very briefly is what are the activities of these different companies? And also the part B will be,
yes.
You say here, if I'm appointed to the bench, I'm supposed to resign from my positions.
Yes.
Now the positions you hold in all of these are sole members, sole shareholders.
Yes.
So I don't know if you're going to resign from your positions, what happens to these businesses? So if you can just deal with the 2 parts. What activities, and then what do you mean by you resign from the positions?
Well,
thank you.
One Torano was meant to deal with properties. But That has been dormant. There's nothing there. There's only one property that I have, which is owned in Sepulokwane. These other ones, the Germain is my name. I just reserved it for the purpose of my name. It's also not active. The Tamar as well is my client name. I just reserved that name, but they're not active. So it's easy for me to resign from them.
And sorry, the transport close corporation is not a taxi owner? No.
No, the Tamara is it's a Tamara Transport. The Tamara is my client name. So I just reserved it. I thought I would use the transport, but it's been dormant. There's nothing's happening there.
So USs are active in any way?
No, anyway, not.
So you say you want to resign from the position?
No, I just resigned from them.
I mean,
yes.
Why do you have them if they're dormant?
Well, like I said, the first one, Germain is my name. That's why I want to reserve that name. The second one, Torona, is my father's name. I want to reserve that name. And the third one is my client name. I just want to reserve those names. But now they're not active.
Okay. Okay, Chief Justice, thank you. First time I hear of somebody wanting to form CCs or companies to reserve names. But anyway, I'll accept your answer. Yes.
Thank you. Commissioner Teodoro.
Thank you, CJ. Good afternoon, sir.
Good afternoon, Commissioner.
I was like Commissioner Nyambi,
Yeah.
that you came here the other time.
No, I think you're confusing me with the Deputy Judge President.
No, it's
of
okay.
Gauteng.
It's okay. It's okay.
Yes, I think
I want to link the second question that he asked you, the separation of power.
Yes.
Do you think that, what is, in your own understanding, judicial overreach? And do you think that there is something like that in our country?
Well, judicial overreach, it means when the court stray into this separation of powers territory. And I don't think, I mean, my dissertation dealt about that, but I don't think that in practice that's what's happening, because if you understand the role of the court, it's not that the intention is to get into the shoes of the executive or legislature. No, that's not them. The Constitution does not allow that actually.
Will I be correct when I say the issue of, or the so-called judicial capture,
Yes.
is linked to judicial overreach?
But I don't know judicial capture. I don't know about it.
You don't know it?
No, I don't.
You haven't heard about it?
Judicial capture? No, I don't.
Sure.
No.
Thank you, CJ.
Thank you. Thank you. Commissioner Moimang.
Thank you, Chief Justice. Good afternoon.
Good afternoon.
Mr. Ludawa.
Good afternoon, Commissioner.
Thank you. My question relates to 1.8 in the questionnaire.
Yes.
1.8 that speaks to your recent appointment to the Compensation for Occupational Injuries and Disease Act 1/3 of 1993.
Yes.
Is my reflection correct?
Yes, that's correct.
I'm trying to avoid the slipping into the terrain that my fellow commissioners have done. So, are you aware currently of the amendment that are being proposed to the bill that was passed by National Assembly and is currently before the National Council of Province?
No, I'm not aware of that.
Okay. No, I think let me then stop there, because I wanted to assess as to whether your recent appointment probably might have prompted your excitement to look into the new changes that are brought to COIDA.
Oh, okay. No.
Thank you, Chief Justice.
Thank you. Commissioner Baloyi.
Thank you, Chief Justice.
Not more than two questions.
No, it's just one topic. I'll try and make it one maybe
Okay.
two questions out of that. Good afternoon, Mr. Ludoba.
Good afternoon, Commissioner.
Yes. Mr. Dwaba, you were asked a question about judicial accountability or accounting.
Yes.
And one of the things you said was that you account to the parties before you.
Yes.
Can you just explain, before I ask you my question, so that I make sure we are on the same page about what you said?
Yes.
What does that mean and how do you do that? How do you account to the parties?
The parties, when they appear before you, they expect fairness. But more than that, they expect that when you have had the matter, you will deliver the judgment as soon as possible for the interest of their clients.
Okay.
That's what I mean when I said you are accountable to them, because they look up to you to see, once you've done what we've done, it's left upon you. They don't expect you to spend a year or so without delivering the judgment.
All right. Would you accept the proposition that accounting to clients should include what you say in the judgment, how you explain your
Yes.
decision in the judgment?
Yes.
Is that a proposition you're prepared to
It's very
accept?
important that when you write a judgment,
Yes.
it should convey what you want to tell the parties.
All right. CJ, if I can just then ask my question.
Yeah.
Now, if you tend to, you have a judgment, one of your judgments, and it starts at paginated page 45, and this is the matter of Dinkwanyane Muhuba versus the University of Limpopo.
Yes.
Does that ring a bell?
Yes, I know that matter.
Okay. Now, this is a doctoral student
Yes.
who seeks to be conferred a degree,
Yes.
right?
Yes.
And there was a debate about whether he's entitled to place his claim on contract,
Yes.
or as the defendants here, the university was insisting, it should be by way of paja.
Yes.
Am I correct to
Yes,
summarize it
correct,
that way?
yes.
Now, you actually summarize, and it's necessary that I refer you to this. At page 45, you set out the defendant's special plea.
Yes.
And you say that, CJ, if you would just bear with me so that I'm correct. You say that the special plea raised by the defendant is that he should have proceeded by way of paja. That's the special plea.
Yes.
Okay.
Yes.
Now, I'm completely confused by the reasoning in this judgment, because what you do is you discuss that the plaintiff is, and why you say the plaintiff is entitled to choose by what course of action he asserts, right?
Yes.
In this case, he was asserting specific performance.
Yes, yes.
And you say, well, he doesn't have to review. He's quite entitled to proceed
Yes.
the way that he did.
Yes.
But then explain how that is a special plea, we agree on that.
Yeah.
And you do the analysis you do, how you get to the order that you do, because it seems like it's unaccounted for, your order, because suddenly you seem to do an unexplained somersault as if there were some other considerations that came in which are not accounted for in the judgment. I'm trying to get you to the order.
Okay.
If you would go to...
Yes, let me explain that.
No, hold on. Let me I just want the other commissioners.
The order is page 68.
Chief Justice, just as a matter of information, I'm aware of this matter. The matter is subject to appeal now. Is it proper to go on it? I know the parties may not be aware of that, but I'm aware of that the matter is subject to appeal. Is it proper to discuss it then? Just guidance there.
Let's reflect on it. The matter you say is on appeal. That's point one. Point two. What does this body do if, for example, or what does a commissioner do if he or she thinks, for example, and I'm not saying that's what Commissioner Baloyi is thinking, if he or she thinks, for example, we have been given a judgment by the candidate, and this judgment, for example, if he gave this judgment and this order in these circumstances, it means it is not qualified to be considered to be a judge. What do we do? What does a commissioner do? I'm just thinking aloud. I'm not.
Chef, maybe some more information.
Yes.
The candidate gave this information some time ago. Subsequently, then there's an application for leave to appeal.
Yes.
Judgment. He's supposed to come next week, I must say. I know the matter, I put the matter on the roll.
Oh.
To come and hear application for leave to appeal in that matter. I don't know whether we can discuss it. But I'm in your hand.
Yeah.
My duty just to inform you of the situation.
Yeah, no.
Yeah.
You are doing right to inform us. One, I would like to hear what other commissioners say about it. And two, maybe the candidate should not be in the room while we talk about it. And then we would call the candidate once we have had a discussion. Is that fine? Yes. Mr. Ledwaba, can you excuse us a bit and then we'll call you back?
And the public as well?
Oh, and the media, yes. Thank you.
Can I start? And I've
hang on.
just signaled to her that I will start, if it is possible.
Hang on, no,
Yeah.
hang on. with the interview. Commissioner Baloyi will be able to put questions to you on the judgment she wanted to put questions to you
Okay.
on. Okay, all right. Commissioner Baloyi, I just remind you about the limitation on time and, yeah.
It's probably just
Okay.
one question, CJ.
Okay,
Thank you.
okay,
It's
but
probably
I
just one question.
understand that sometimes when you ask about a judgment, it might not be so easy to
Yes.
just do it, but try your best.
I will. Thank you, CJ. Thank you. Mr. Lidwaba, the question that I'm asking you about this judgment, I'm not asking you to get into the merits
Yes.
of your decision,
Yeah.
right? I'm testing with you the flow of reasoning
Yes.
of how you get to the order.
Yes.
Now, you've agreed with me that the special plea that was taken
Yes.
was that the applicant, or the plaintiff in this case, was bound to proceed by way of PAJA, seek a review of the decision.
And the
right?
special please understand it was that there is a decision by the university to terminate the registration. Now, the special plea was to this effect. For as long as that decision to terminate his registration stand, and the use extent, you can't get a situation where you get a court order to confer a degree on that student. So what they're saying, in their view, the deregistration was done was done by the university in terms of administrative actions. They will say that administrative actions have got consequences. And the consequences of that is that this person is no longer a student of the university. So he can't come to court and say, confer a degree on me while he's not a student. That was special plea.
Okay. Can I just read, because what you've done in the judgment is you've helpfully set out what you say was the special plea. And you do that under the heading defendant's special plea. So this must be very close to, even your paragraph numbering, must be very close to what was pleaded. You say, in the first paragraph, you say the defendant is an organ of state as defined in PAJA. And then you say the plaintiff alleges that the defendant was obliged to award him a doctorate after he completed the work. And then in 3, you say on the plaintiff's version, the defendant's refusal, this is the special plea, to award the plaintiff the doctorate degree in issue constitutes administrative action. So it's the decision to refuse.
Yes.
Constitutes administrative action in terms of PAJA, and the plaintiff was accordingly bound to review the defendant's decision in accordance with PAJA.
Yes.
After the plaintiff exhausted all internal remedies, right?
Yes.
And then you go on sub-paragraphs. But what they do is you say the plaintiff applied and was registered. 2, pursuant to an investigation, the executive of the Senate took a decision to terminate him. The decision to terminate the plaintiff's registration is valid and extant and has not been set aside. The defendant is prohibited from awarding the doctorate degree until decision to terminate his registration taken on the 5th of October has been set aside. The defendant's refusal to award the plaintiff the doctorate degree is in issue constitutes administrative action. That's the special plea.
Yes.
You then say, you have the discussion in the body of the judgment. You say, well, the plaintiff chooses what course of action to assert.
Yes.
He has decided
Yes.
to assert a course of action on the basis of contract.
Yes.
And he claims specific performance.
Yes.
You say that.
Yes.
And you say there's nothing wrong with that,
Yes.
with him proceeding
Yes.
by making that choice.
Yes.
You say that.
Yes.
And I follow your reasoning
Yes.
as you do that, why you say that.
Yes.
And then you get to the order. You say, I uphold the special plea.
Yes.
That's what you do. You
Yes.
uphold the special plea. Now,
Yes.
it seems to me that, or at least I think there's a need to explain the incongruency in reasoning, in your reasoning and the order that you give. Because your reasoning is he's entitled to proceed by way of contract. And then you say the special plea succeeds, that he's obliged to proceed by way of PAJA, because that was the special plea.
No, what Commissioner was reading was the version of the defendant. They were saying, he approached the court in terms of the administrative law. Now, he approached on the basis of a contract. So there were these two versions. One was saying, I'm here on contract and I want the specific performance. I must be given a degree. The other one, the respondent, was saying, no. The Senate, whatever Senate was doing, was not a contractual relationship. They were administrative in nature. So there were these two versions. Yes. And they were saying, our special play is this. Because the university has deregistered you, you can't leave this consequence of your being deregistered and then ask the court to confer a degree on you. That's why I said I'm upholding the special plea. One is prayer number one. Number two, the prayer for the conferral of the doctorate comments on the plaintiff is dismissed because I could not confer a degree on a student whose registration has been dismissed. So what Commissioner was reading was the two versions. So I was faced with these two versions.
Yes.
And there was a special plea that I had to deal with. So I was not dealing with the merits. The question was whether there is a valid special plea. That's why I held the special plea.
All right. Can I just, lastly, CJ, just this, can I raise another difficulty from what you have just said? You dismiss the prayer for the conferral of a degree. You dismiss that even though you are seized with a special plea. Because you say in the judgment, the parties agreed that the special plea raised by the defendant should be decided. So I have the problem with the congruency or the coherence of your reasoning, how you get to dismiss the special plea, but assuming you're correct in your explanation, you've now dismissed the prayer for the conferral of a degree when in fact what was before you is a special plea raised. Now you're dismissing on the merits. Isn't that problematic?
Well, otherwise, I don't know what will, because there's a prayer before me that says to me, confer a degree on me. Otherwise, then I'll have to leave that prayer. Then what do I do now? Because if I dismiss it, if I uphold a special plea, and then I leave the prayer from the applicant, what then? Because it's gonna be questions that, okay, now we came to you, we're asking for it, and you say nothing about it.
All right.
Commissioner Baloyi, I'm going to allow you to follow up because I can now understand quite clearly what your issue is. So, and I think you have reached the point where you want to, I think one more question should do.
Yes.
Or comment or proposition.
Yes, in fact, it's a proposition.
Yes.
Mr. Ldoba, do you not see a problem, the problem that I'm putting to you, that there's the papers, the plaintiff has got papers, as you correctly say, in which he seeks all of this relief, right? And then the defendant, they plead over, but they also raise a special plea.
Yes.
The parties agree that you will deal only with a special plea. That's what you say in the judgment.
Yes.
That's the parties' agreement.
Yes.
And the special plea is that he should have proceeded by way of Paja.
Yes.
Right?
Yes.
So what you do is, and I've canvassed with you the reasoning, the problem I have with your reasoning, that you accept that he's entitled to proceed by contract and yet you uphold the special plea of Paja.
Yes.
But secondly, you now are dismissing one of the prayers sought, which is conferral of a degree, even though that's not what is before you. At that point, you are dealing with a special plea, not the merits of the plaintiff's claim. That's a simple proposition I'm putting to you. In fact, what I'm putting to you is, do you not see the difficulty?
No, now that you're explaining to me, I understand you're saying, I went into the merits beyond special plea. That's what you're saying to me.
Yes.
Yes. But that I thought about it, but I said, okay, if I'm going to leave it like that, and I say, I dismiss special plea, and I leave number 2.
Uphold special plea.
Yes, uphold state
Not
special plea,
dismiss.
and then I leave number 2. Then I had this question of saying, all right, but then they were going to say to me, what did we come with? Well, they're going to say to me, they say, okay, then we can go on the merits for the dismissal. That I understand what you're saying to me.
All right. Thank you, CJ. Thank you. I think I can't take it any further.
Thank you.
Yes.
But I think, Mr. Dutoba, that's the very point
Yes.
that Commissioner Baloyi is saying.
Yes.
She is saying, you, in terms of the agreement between the parties which you recorded in the judgment,
Yes.
they did not contemplate that you would deal with the merits.
Yes.
After all, the special plea wasn't like prescription.
Yes.
Okay.
Yes.
But what you did, instead of simply upholding the special plea or exception, you did that, and then you went to the merits and closed the door on the merits. That's the proposition she was putting. But I think you do understand it now.
Yes, I understand. That's how I explained. I thought she say, instead of dealing with special plea and leave it there, you went to the merit and dismissed the application for conferral. But I was faced with that difficulty to say, now they want a conferral. Well, what do I do with it? But we understand that she say, you should have left it because it's not before you. That I understand.
Yes, thank you.
Yes.
Were there other questions? There seem to be no questions. I am not sure whether I'd gone to the commissioners attending virtually. Commissioners attending virtually, have I given you a chance?
Not yet, CJ.
Or do you have any question?
I have a question, if I may ask it, please.
Yes. Go ahead.
Advocate Ledwaba. Thank you. Advocate Ledwaba, I'd like to take you to the Marathon judgment, paragraph 66 in particular, which is on page 107. There's two numbers on the page. It's either 106 or 107, but it's paragraph 66. Now, do you have it there?
Sorry, paragraph 66.
Yes.
Is it paragraph 66 or page 66?
No, it's page handwritten page 106.
Oh,
page 66.
Paragraph 66 on page 106. 106.
Sorry, page 66.
Paginated page 106, and I think it said paragraph 66 on that page.
106.
Yeah, paginated paragraph 106 at the top. Yes, at the top.
It's the paragraph that starts with the words "on behalf of the first defendant."
It's the same judgment that we're dealing with now.
The Marathon judgment.
Have you got paragraph 66? No, the paragraph is 66 and the page is 106. 106, the one written with a marker, not the typed one, at the top.
Yes, page, yes, I'm there.
Yes, he is
Right.
there, Commissioner.
Yes.
Now, in this style of judgment writing, one is sometimes unsure who's speaking. Is it the party referred to, or is it the court making a conclusion? So the first sentence is clearly the first defendant's case, because it says on behalf of the first defendant, it is submitted, etc. But the last sentence in that paragraph, is that a conclusion of the court, or is that said on behalf of the first defendant? So it's the sentence that says, in the premises, there can be no doubt that the municipal manager does not have the ostensible authority, etc. Is that the court speaking, or is that still the defendant's version?
Page 106, it was my assessment.
Paragraph 66, are you there?
Yes, page 106, where it starts, the plaintiff's case is that in a capacity.
No. Is the page you are looking at marked with a marker 106 at the top?
Yeah. No, at the bottom or at the
No,
top?
look at the top.
At the top, okay, yes.
Have you got the 106?
Yes, I've got that.
Can you see paragraph 66?
Yes, I see that one, yes.
Okay. What Commissioner Barnett is saying to you is this. That paragraph starts with, on behalf of the defendant, it is submitted that.
Yes.
But the last sentence of that paragraph says, in the premises, there can be no doubt that a municipal manager does not have the ostensible authority as proffered on behalf of the plaintiff.
Yes, and
His question is whether that last sentence reflects what you were saying, your conclusion, or whether it was recording what was being submitted on behalf of the first defendant.
Yep, that is, if you look at it, the last is, it says the footnote 19. Now, on footnote 19, if you look at the bottom, it's paragraph 57, 88 to 88 of the heads of arguments.
Or of argument.
Yes.
So you are recording
yes.
one of the submissions made by counsel for the defendant.
Yes.
Okay, all right.
Yes.
Commissioner Barnett?
Okay, that to some extent addresses my concern because there's a sentence in the center of that paragraph which says, any person in his right mind should know that no municipal manager has the power to take a decision, etc., etc. And I was concerned about that wording, person in his right mind. So you're saying that, is that the court's word? That's not the court's wording, that you're saying is the party's wording.
That was a submission by the party. And I mentioned the page there.
Okay.
Yeah.
Yes.
Okay, I just thought that was a bit harsh if it was in any way the court speaking, because it makes it sound as if someone who disagrees with it is then someone of unsound mind, or that's
It was
some
not,
other
it was,
problem.
no, it was, no, it didn't come from me. That was the submission, yes.
No,
Thank you very
well, I
much.
guess the only point that you can take from this, Mr. Ledwaba, is that it is quite important when you write a judgment to make sure that what is being said by a witness or counsel should be clear, and what you are saying as the judge must be clear. So the reader must be sure, which otherwise they attribute to you something that was said by counsel.
Yeah.
And maybe counsel said something quite terrible.
Yeah, that's why I specifically said, refer to page 87
Yes.
of the heads of arguments.
Yeah,
Because
no,
I didn't
no,
want
that-
it to be like, it comes from me.
Yeah, no,
Yes.
that's fine. That's
Yes.
fine. Is there any other commissioner attending virtually who wishes to ask some question? Nobody. Okay.
CJ, if you are done with the commissioners, can I do the sweeping? There's a comment.
Yeah.
that I
Okay.
think
All
we should-
right. One question for sweeping.
It's just that. Mr. Ledwaba, the GCB in its comments, they have a note there that you declared that in 2000 when you were a director.
Yeah.
Oh no, if it's those,
Yes.
you need to put to him.
Yes.
All that needs to be put to him.
All right.
Yeah.
This is the only one,
Oh,
CJ.
okay.
This is the only one. You were director and the Law Society fined the firm for late submission of their books of account.
Yes.
What is that? Just so that the commissioners and the public knows that you have responded to it.
Yeah, in 1999, coming 2000, there was a problem of our machine being able to capture the following year. And there was this thing, and then they explained it as Y2K. There was a talk about it that our machines that we had then was not going to be able to capture numbers beyond 2000. So that happened to us. I'm not sure if I could. So when we were supposed to to capture for the following year, 2000. Our computers could not capture because that computer was made only for up to 1999.
You're saying that's the explanation for the late submission of the
Yes.
books to the Law Society?
Yes, the submissions are done in February.
Okay.
So in January, when we opened to want to capture for 2000, and we had a problem because that machine could not capture 2000. And then we started now doing these things manually. And February came and passed, and then we were late to submit the documents. That's why we were fine. We were not the only firm then, because it affected many firms then.
All right. Thank you, Chair.
Thank you. We have come to the end of this interview. Thank you very much, Mr. Ledwama, for availing yourself. I'll give you 3 minutes if you have 2 or 3 points that you want to emphasize as points that the commissioners must bear in mind when they consider your candidature. But if you are satisfied that all issues have been dealt with adequately, then that's fine as well.
I don't think any.
You are satisfied?
No.
Okay.
Yes.
Thank you very much for availing yourself. You are now excused.
Thank you very much.
Okay.
Is it on? Thank you.
Good afternoon, Ms. Naude Ordendal.
Good afternoon, CJ. Are you well, CJ?
At least one candidate wants to know how I am. I am well, thank you very much, and the commissioners are very well too.
Thank you, CJ.
Yes. Thank you for availing yourself. We appreciate that you have availed yourself for consideration for appointment as a judge in the Limpopo Division of the High Court. I'm going to put certain questions to you. All the questions that will be put to you are aimed at establishing how your appointment would comply with the selection criteria that this body has agreed upon. I think there is a document that should be here that is not here. I'm sorry. I will ask you questions, and after I'm done, I'll ask the judge president to ask you questions if he has any. And after that, I'll ask the Premier's representative, Advocate Singh, to do the same. And after that, commissioners who wish to ask you questions will get a chance to ask you questions. All questions will be directed at seeing how your appointment would comply with the selection criteria that have been adopted by this commission. I see that you have an LLB degree which you obtained in 2007?
Indeed so, Chief Justice.
Yes, and you got it from the University of Pretoria.
Yes, Chief Justice.
And then same year you obtained, what is it called, an IPSA diploma in insolvency law.
Indeed so, Chief Justice.
And then you served articles from 2006 to 2007.
Indeed so, Chief Justice, until I was admitted in September 2007.
So you were admitted in December 2007?
September 2007, Chief Justice.
Yes. Okay, on the questionnaire, it looks like it was in 2008. But I think it's just the way the words are arranged there. And then you practiced as an attorney for a few years, and then you went to the bar, is that right?
Indeed so, Chief Justice. I went and did my pupillage at the Pretoria Bar in 2010.
Yes.
I started on the 25th of January 2010, and I was admitted as an advocate on the 16th of March 2010.
Yes. And you have been practicing as an advocate since then?
Indeed so, save for the periods when I was acting as a magistrate or as a judge.
You acted as a magistrate from March/April 2015 to December 2016. So that was a year and a few months, or was, a year and a few months?
Yes, indeed so, Chief Justice. It was about
No,
20...
actually not a year and a few months, close to 2 years.
It was 21 months, 3 months short of 2 years.
Yes.
Chief Justice.
And then you went back to the bar in well, here it says 2015 to end of 2016, but you were acting as a magistrate at that time, so...
Chief Justice, while I was acting as a magistrate, I wanted to retain membership at the bar. So at that stage, I was a member of the National Bar Council of South Africa, the NBCSA. But I didn't practice, I just retained my membership.
Is that permissible?
Yes, as I'm acting now as a judge, I'm also still a member.
Oh, because you were acting, you were not permanent?
Yes, I was acting.
Okay. Okay. You wouldn't do it if it was a permanent appointment?
No.
Yeah. Okay. So that's why it's a little confusing, because you were an acting magistrate for close to 2 years, but then it reflects that you were an advocate, but that's because you retained membership.
Yes, indeed, sir.
Okay. And then you have had a chance to act as a judge, and you were an acting judge from 27 July 2020 to 30 September 2020, and 5 October 2020 to 30 April 2021, and 21 July to 30 September 2021, and 1 October 2021. Is that right?
Indeed, sir.
So,
Chief Justice.
All in all, how long was that period? Those periods of acting on aggregate? If you put all of them together, do you know how
Chief
many
Justice-
weeks or how many months?
Chief Justice, at the time of submission of my nomination and application, it was 58 weeks, but since then, I have acted further, and currently, actual time that I have sat on the bench is 60 weeks, almost 15 months.
Almost 15 months?
Yes.
Okay. Okay. What types of cases or branches of law did cases that you did in your practice or that you continue to do in your practice relate to?
Chief Justice, my practice was a very general practice. As I grew in maturity and experience, it developed in a different direction from when I first started. At first, I did criminal law and civil law. Apologies, Chief Justice. Right at the beginning, I only wanted to do conveyancing and estate planning. Then I was introduced to civil litigation and criminal litigation. Then I started to do more civil litigation and criminal litigation, and the conveyancing and the estate planning became less. And then later on, my practice developed more into a civil practice, and the criminal work became less. I also had some experience in labor law matters, a little bit of experience in land claims matters, mostly commercial law matters, family law matters, insolvency law matters, evictions, mining law, banking law. Chief Justice, there's almost no area that I don't have experience in. If there's, I think it might be easier to mention an area that I don't have experience in than giving the areas I do have experience in. And the one area I do not have experience in Limpopo is maritime law. That's,
Yes.
I don't have experience in that.
I see that in your questionnaire under legal background, you described yourself in these words: I'm a jack of all trades and a master of none.
That's accurate, CJ. I'm a jack of all trades and a master of none, but I do know where to get the law.
Okay. Now, the matters that you have done in your practice, are there any that have resulted in reported cases in which you appeared?
No, unfortunately not.
Yes. And judgments that you have produced during your acting stint, are there any that have been reported?
Yes, indeed so, Chief Justice. I'm not sure whether they were reported on the law reports, but the matter of the Director of Public Prosecutions, Limpopo Province, Mrs. Ramesh Patel, was reported in LexisNexis online reported judgments system, as well as Utastats online reported justice system. If this CJ will, and the commissioners will just bear with me, then I can quickly go through the list, if I can just get that.
Well, you don't have to go through it.
I have it, CJ. Then it's on page 9 of the handwritten 9 of the bundle.
Yeah,
In the corner, I
yeah.
indexed the pages. Then on Utastat, they also have, like I said,
These, none of these are reported in the usual South African law reports and Butterworth law reports, but you say they are reported anyway under JDR and JOL.
Indeed so. Indeed so. Chief
Yeah.
Justice, and then under Utastat, there are 10 matters that was reported.
Yes. Okay. And now during your acting stints, have you sat in full bench appeals? Have you sat in motion court, opposed and unopposed, as well as have you done civil trials and criminal trials?
Yes, Chief Justice, and in addition to what was mentioned by Chief Justice, I think it needs to be mentioned that I have done special civil trials, special criminal trials, which is complex in nature and long in duration, as well as high profile. And then I have been appointed to do only special motions in our division the last term last year. Chief Justice, in our division, special motions is not your normal opposed motions. It is both complex motions as well as extremely voluminous motions.
What can you tell commissioners that suggest that you have embraced the values of our constitution? You know, there are some within our country who reject the Constitution. So we need to know that anyone that we recommend to be appointed, we need to know if they embrace the values of the Constitution. But it might be helpful if they are able to refer to what they do or have done to show that they embrace the values of the Constitution rather than just telling us, I do embrace it.
Chief Justice, I believe a judge should enhance the values of the Constitution in both their professional as well as their personal lives. In my instance, I cannot tell the JSC commissioners that today I have went out and I have specifically went and treated somebody with respect. For me, it is something I do every single day of my life, in both my professional as well as personal capacity. I treat all people alike with respect and with dignity. When it comes to equal opportunity for all in South Africa, commissioners, I have assisted many pupils with, it started at university already. I have mentored many students during my time at the university. As a counsel, I have mentored pupils. I have assisted many pupils with referring work to them once they are admitted. And in this instance, it's both Black, Indian, and coloured. As counsel, I have referred many briefs to Black counsels, women, and men. I have helped many article clerks to obtain article clerkship at attorney's firm. Article clerks struggle to get contracts of articles clerkship. And then I would pick up a phone and phone a few attorneys, arrange interviews, and in all the instances where I helped, they got their articles. And once again, it was for all colours, all races, and all genders. Then later on in practice, I stayed involved with pupillage training and mentoring. I assisted the Black Lawyers Association with their moot court exercises over the recess period in 2020. Last year, I assisted the Limpopo Society of Advocates with their moot court training, and I am currently also assisting the Limpopo Society of Advocates by giving class to the pupils. And I have been honoured also by the Limpopo Society of Advocates to specifically give the pupils class in ethics, ethical behaviour. And for me, that is a great honour to specifically be asked to lecture ethics. I do not know if I should go on with the list, but I can go on.
I will now allow the Judge President to put questions to you if he has got any.
Chief Justice, apologies. Just before the Judge President puts questions to me, there is one aspect in respect of enhancing the values enshrined in the Constitution that I would like to bring to the attention of the Commissioners.
Yes.
During the period of 2007 to 2010, when I was with Coxwell and Steyn, Vice and Nudea attorneys, our branch of the litigation branch, where I was part of, received a special honorary award from the then President Kgalema Motlanthe for services rendered to the people of Limpopo. And I was, together with the senior attorney, the recipient of the award. Thank you.
Thank you. Judge President.
Thank you, Chief Justice. Ms. Nadir, you were interviewed by this commission last year in October. After your interview in October, is it so that you proceeded acting as a judge until the end of the year, December 2021?
Yes, indeed so, JP.
Right, and over and above the period of an aggregate of 15 months as an acting judge, there are periods when you availed yourself as a pro bono judge in my division. When I count the period, I come to a figure of about a 2 months period as a pro bono judge. Do you confirm that?
JP, in fact, it was a little bit more. It was more about 2 terms, not just 2 months,
Okay, yes.
JP. Yes, it was 2 terms, JP.
Thank you, and thank you, Chief Justice.
Thank you, Judge President. Advocate Singh.
Thank you, Chief Justice. Good afternoon, Advocate Nadir Odendaal.
Good evening, Mr. Singh.
I'm just going to read, there's a common thread in the comments regarding, well, let me say it how they say it. The candidate is still young, but has garnered experience in varied fields of practice.
Advocate Singh, don't speak too far away from your mic.
Okay. Sorry, CJ, I'll repeat that.
Yeah.
The comments from the GCB state that the candidate is still young, but has garnered experience in varied fields of practice. And then similarly, from Nadal, it says at point 164, Advocate Odendaal is a young female legal practitioner. At your relatively youthful age, do you think you would make a good judge?
Advocate Singh, thank you for asking me the question. I have read the comments and I have noted that it is a general view that it is quite extraordinary for somebody to be appointed at such a young age. But I am not the first and I will most definitely not be the last. I know, if I'm correct, our Chief Justice was also only about 37 or 38 when he was appointed, first as a judge. Then there is Justice Stroon, who was only about 33 or 34 when she was appointed as a judge. Judge Madlanga was the first youngest judge ever to be appointed at the age of 34. And there's quite a number that followed. What the history has shown us is that people appointed at a young age add value to the judiciary and many years of good service to the judiciary. And they grow and mature within the judiciary and on the bench. And according to history, they, in the end, elevate to the Constitutional Court bench. The fact that I am only 38 years old is to the advantage of the judiciary, because there are a lot of energy in me, a lot of motivation, and many years of service to the judiciary, the people of South Africa, and more specifically, the people of my province, Limpopo province. Then, in respect of my qualifications, my experience, my ability to deal with technically competent matters at my young age, I have earlier indicated that I have been appointed specifically to deal with special motions. Special motions in our division are normally reserved for the judge president or the most senior judges. Now, considering the fact that I have acted for 60 weeks, over the period of 60 weeks, I have written 105 judgments. Of the 105 judgments, only 5 judgments of my own was taken on appeal. The other 4 was either full court or full bench judgments or review judgments. As I sit here, I am privileged to say that none of my judgments have been set aside. The 3 outstanding judgments that was listed on my list, of which the outcome was still awaited, 2 of them, the appeals were dismissed with cost. In other words, my judgments were upheld. And in the 3rd one, the appeal was never prosecuted. So that would give me, at this stage, a 100% success rate. Now, I think that says something about my understanding of the law, interpretation of the facts, and application of the law to the facts. If one considers my judicial temperament, I am a strict person, but I am also a person who goes into a matter open-minded. I am also patient and allow the parties to ventilate the issues before me properly. I have the necessary leadership, although as a junior acting judge, I'm not necessarily in a leadership position, but as a judge of my court, I am held responsible and accountable, and I need to do that with leadership. Now, when it comes to leadership, I strongly believe in the principles of Ubuntu. I am because we are. And in this instance, I can give an example. During the time that I was an acting magistrate in Zastron, the Zastron Magistrates Court was number 98 in terms of the NPA ranking, in terms of performance. After the first quarter of 2016, ending June 2016, it's when I started acting there, the performance of the court improved from number 98 to number 6, which made that court the best performing court in terms of the NPA statistics ranking in South Africa. I could not have done it on my own. What I did is I immediately held various meetings with the different interested parties, the police, the social works, the correctional services, the prosecuting authority, legal aid, and so forth. And we all pulled our part and worked very hard. But then at the end of the hard work, you also have to reward. So I organized at my expense a thank you and celebration braai for all the stakeholders one Friday afternoon at the Magistrates Court, and everybody enjoyed it very much. And it gave that little motivation to do even better the next term. But then I was transferred to Thohoyandou thereafter. So in respect of my personality, my experience, my capability, I have a lot to offer to the judiciary. And if the judiciary appoints me as a judge, I swear that I will serve the judiciary, the people of South Africa, and the people of Limpopo with dignity and honor.
Thank you, Chief Justice. That will be all.
Thank you. Commissioner Kane.
Good afternoon, Madam. I'm seated in this direction. Ordinarily, a person practicing at the bar with your ability would, at about this stage of her career, apply to be recognized for senior counsel status. And that also contributes to the bench because you take with you, if it's granted, that peer review endorsement. Do you not think that that would be of value in your circumstances?
Commissioner, I think any counsel aspires to become a senior counsel someday. We work for something. But in my instances, since I was 27, and I can still remember the exact court we sat in during our pupillage moot court training, I looked at the judge that addressed us that evening, and there and then I decided that's where I want to be someday. So I aspired more to becoming a judge than obtaining my senior counsel status. At this stage, I have 12 years of practice as a counsel and 3 years as attorney, so it's 15 years. I will only start to qualify for my senior counsel status from this year onwards. But ever since I was 27, I worked towards being appointed as a judge, and that is where the acting census magistrate, commissioner of the small claims court, commissioner of the tax board, or rather chairperson of the tax board, and the acting census judge came in.
One more question along those lines then. Since you are now exactly at the point where it would be appropriate for you to apply for senior counsel status, would you do so if for any reason this commission didn't recommend your appointment at this stage?
Yes, I have considered it, and I have in fact discussed it with senior counsels to apply. But in order to become a judge comes from the academics field, prosecutors, attorneys, magistracy, and counsels. It's not a requisite to be a senior counsel to be a judge. And having obtained my senior counsel status won't make me a better or any lesser judge. It will put me in a different category as a counsel, but it won't make a difference as to the judge I am compared to the fact that there are many magistrates who are appointed as judges and attorneys who never have the option of becoming a senior counsel.
CJ, may I ask one more question, please? Thank you. You didn't answer my question. You see, I didn't contend that you had to have senior counsel status, and this body may well recommend you without it. But I asked whether, if for any reason you're not recommended, whether you would apply.
Advocate, I think I answered it at the introduction of my answer. I said, yes, I have already considered it, and I have already discussed it with other senior counsels to apply for my senior counsel status. I have also already received the form. I think, if I'm correct, the closing date is in May of this year. So I have already considered it.
Thank you.
Well, have you considered it and made a decision that you would apply, or have you considered it but not yet made a decision? You
Chief
would apply
Justice,
if you are still at the bar at the time, at some stage this year. That is, if you were not appointed as a judge.
Chief Justice, my decision that I made is I want to be appointed as a judge. That is where my heart lies, and that is what I've worked for my entire life. If I am not appointed, then I would consider applying. But at this stage, I have not applied because tonight I am here to be interviewed to be appointed as a judge.
Okay, all right. I don't think it can be taken any further. Yeah. Well, you must just know that nobody is saying you must apply if you don't want to apply in case you are not appointed. I think it was just, it may well be that Commissioner Kane thinks that if you don't get appointed, you would be a good candidate. I don't know, but she was just wanting to know whether if you are not appointed as a judge, you would apply. Okay, Commissioner Singh.
Thank you very much, Chief Justice, and good evening, Advocate Odenda.
Good evening, Commissioner Singh.
One of the roles that I play in Parliament, and I've been there for a number of years now, part of the furniture, is a member of the Portfolio Committee on Environment. And I'm going to ask you an environmentally related question arising from your answer to question 9 in the questionnaire. Furnish particulars of community and other organizations of which you have been a member in the past 10 years. And you list there, and forgive me if I pronounce it wrong, Bosveld Jagters en Wildewaringsvereniging and the Soutpansberg branch, which I understand is the Hunters and Game Wardens Association.
Yes, Commissioner Singh.
Now, one of the criteria that we have to look at is your capacity to give expression to the values of the Constitution. And I think you have told us about how you give expression to that and about the award, and congratulations for that. One of the Section 24 of the Constitution speaks about an environment, and it says everyone has the right to have the environment protected, and then subsection 2, promote conservation, secure ecologically sustainable development and use of natural resources while promoting justifiable economic and social development. Now, the reason I'm mentioning this section of the Constitution Because in our activities or in our work as members of the committee, we've come across the issue of captive lion breeding. And we've come across the issue of tigers and cheetahs, etc., that are bred and kept in captivity. And in fact, there are about 350 such facilities in the country, with Limpopo having a number of such facilities. Have you in any way made any pronouncement or statements on the issue of captive lion breeding? How do you perceive it, given that the Minister, Barbara Creasy, recently banned the sale of lion and lion products? And I see you are a hunter as well. I saw that in a picture somewhere. So I just want to know, what is your view on captive lion hunting, keeping these cats in captivity, and your role in this Bosveldjagters and Wilde Bewaringsvereniging?
If I may, Commissioner Singh, start with the last question first and then do the first question last. My role at the Bosveldjagtersvereniging is I'm a member in order to have a firearm license. It is indeed so. I like hunting, fishing and camping. Annually, I go hunting with my family, and we enter the various competitions that the Soutpansberg Jagtersvereniging has. So that is my role as far as it goes in respect of the Soutpansberg Jagtersvereniging. Then in respect of my view of, if I can call it the canned lion hunting, because that is what it is. The fact that I am a hunter makes me an even bigger protector of nature and animals. We only hunt what we can utilize and eat. The canned hunting lion business is outright wrong. I do not have a problem with lions that are bred and grown in an environment that is conducive and which does have the necessary permits for them. But the moment it does not give them a proper standard of living anymore, I do not condone that at all. Have I done anything about it actively? No, unfortunately, I have not had the opportunity and I have not gone to those lengths yet.
Thank you for that. There have been calls because of the serious numbers of rhino poaching, particularly in the Kruger and in KZN, and this captive lion breeding or the canned lion hunting, for a wildlife court to be established, specialized wildlife courts. Do you have a view on that?
Except that I think I love it. I think it's absolutely necessary, considering not just the rhino poaching, but also elephant tusks trading. Poaching ranges over a variety of animals, especially in the Kruger and closer to our borders. If such courts are established, I would not say it should be a permanent court, but rather a circuit court that goes around and does a day, a week at a certain area, because these areas are wide and far apart, considering the Bizimbi on the western border of South Africa and the Kruger National Park on the eastern border and Messina on the northern border. And these are areas that are vastly affected by unlawful poaching of animals. And it's not just the animals affected, the farmers in the areas and the communities and the South African fiscus is affected by it as well.
Thank you, Advocate Odendaal. Thank you, Chief Justice.
Thank you. Commissioner Nyambi.
Thank you, CJ. Evening, Advocate.
Good evening.
From my side, it's only one question. I'm happy you are being interviewed for a position where you are very clear that that's where your heart lies. The last time you were here, I can see a sense of serious preparation from your side. Probably you have done some reflection about the last time you were here. And if you are aware that no one was appointed, with the reflection and hindsight out of what was said then and coming here today, probably anything that you think getting a chance, you might have said it differently then, that you think might have made it impossible for us to have an appointment, so that once and for all today it can conclude and have you where your heart lies?
Commissioner, thank you for asking the question. Yes, indeed, I did reflect a lot. I went over the interview and my experience. What I would have done differently is the way I answered the question posed by Commissioner Malema back then. I think in a sense I misunderstood the question, but what I would have done differently in my answer is I would have approached the answer as a judge. And as a judge or an acting judge have answered the question and given a more firm and definite answer.
I'm more than satisfied. Thank you, Advocate. Thank you, CJ.
Thank you very much. Let me go to the commissioners attending virtually. Is there anyone who has a question among the commissioners attending virtually?
No questions, Chief Justice.
Thank you very much. Okay.
No question, Chief Justice.
Thank you. No question,
satisfied.
Commissioner Breitenbach and Commissioner Lucas.
No, no questions, CJ, thank you.
Okay. Okay, Commissioner Muimang.
Thank you, Chief Justice. Good evening.
Good evening, Commissioner.
Advocate Odendal. Just one area that I want you to address from my side.
Would you please just speak up a bit, Commissioner?
Thank you,
Yeah.
Chief Justice. Just one area that I want you to address from my side. The GCB raises a point at para 5.1 of their comments that from the 9 judgments that they considered, they noted that there is no indication of the candidate's experience in matters of great significance. That's the point that they are raising. And they, at paragraph 11.2, they say also the only concern remains that the candidate's youth and lack of exposure to matters of great significance. So if you can just address us on those concerns, so that at least as we deliberate, we have the benefit of your response to that. Thank you.
Thank you, Commissioner. Commissioner, I do not equate a matter of great significance to a matter of complexity. A matter of great significance is not necessarily a very complex matter, and a very complex matter is not necessarily a very significant matter. But as I have said earlier, I have dealt with special motion court in the last term. I have dealt with several matters of great significance, and the GCB must have missed it by error. The Ramesh Patel matter, thereafter followed the S versus Saroka matter, which was a follow-up on the Ramesh Patel matter, which is used in the Magistrates Court in respect of bail applications. There's also the matter of Maria Baloy versus the Minister of Health in respect of who to cite when it comes to vicarious liability. Do you cite the Minister or do you cite the MEC of the province? Then I have also dealt with several liquidation matters that were quite high profile, amongst others the VBS matters. I have recently dealt with a high profile criminal case, S versus Herman van Tonder, the Bella Bella murderer, which was also all over the news. In both my time period as an acting judge as well as counsel, I have dealt with various matters which made news headlines and were quite high profile. But were they significant to me? No, not at all, because a significant matter, in my view, is a matter where principles are laid down. A Ramesh Patel matter is a significant matter. But the other matters, a significant matter equates for me to a matter where a rule or a statute was declared unconstitutional. Principles were laid down that is followed in practice for years to come. Those are significant matters.
Thank you, Advocate. Thank you, Chief Justice.
Judge President Lekhodi, thank you.
Counsel, is there anything that you want to say to the chair in Chivenda, and you can translate it to him? What is it which you wanted to say? Just in one sentence.
Thank you. Thank you, Judge President. Yes. Enezonaga shumani, hoyemu shumani, ga himbire yote.
Translate to him.
What I say is, I really would like to do this job with my whole heart.
Thank you. Thank you so much.
Thank you.
And then before it seems as if the interview has come to an end, there's one outstanding issue. Minister Lamola, Masiari uvuani.
Anorovozowood.
No, vuozavudi mara heli juduro kufisa gamanda.
Hi, Rekatemori.
Thank you.
Okay, thank you very much. It looks like,
CJ?
were there still some questions? Oh,
It's not a question. It's
oh,
not a question, CJ.
Yeah.
It's my sweeping
yeah.
responsibility.
Oh, you're sweeping, yes.
Yes. Good evening, ma'am.
Good evening, Commissioner.
One of the comments from the GCB is that despite you indicating that 10% of your litigation practice comprises constitutional law, there's no indication that, in fact, you have experience in constitutional law. What do you say to that? What's your comment?
It is not exactly correct. In fact, if one really considers your general practice, you have more than 10% experience in constitutional law. Have I ever appeared in the Constitutional Court? No. But Constitutional Court does not only relate to appearances in the constitutional law. You deal with constitutional law in your everyday general practice. For instance, the best interest of a minor child, emergency medical attention that a person must be afforded. I have dealt with two such urgent matters where in the one was in the Free State on an urgent basis where emergency medical attention was refused to a person and where a child had to get emergency transplant of a kidney. These are constitutional matters. A child that is refused to go to school or write an exam. When it comes to eviction matters, the constitutional issue plays a role and you have to consider the right to housing. So there are different aspects of constitutional law. Then when it comes to constitutional law, it's not generally only when a section or an act is declared unconstitutional. It also has a bearing to when an action or conduct is declared invalid and unconstitutional and set aside, such as reviews. And I have done many reviews. So in that regard, I have experience in constitutional matters.
We should understand you to be saying that you, in your matters, in litigation, because it's raised in particular with reference to litigation, that in matters that you've litigated, you have had to place reliance and invoke the rights in the Constitution or issues arising from the Constitution.
Yes, indeed, sir. Indeed, sir.
Thank you, CJ.
Thank you. I think we have come to the end of the interview. I must thank you once again for availing yourself. I will give you 3 minutes if there are 2 or 3 points you want to emphasize for the commissioners to particularly bear in mind when they consider your candidature. And after that, I will excuse you. But I know that earlier on, you went to town on certain issues, so it may well be that you have addressed issues adequately, in which case it will be fine.
Thank you, Chief Justice. I think I am covered. I would just not to let the Pedi or Sotho people feel left out. In Sotho, greet you. Sala Gabotse.
We are clever now.
You are now excused. You are now excused.
Chief Justice, you are clever, Minister.
We are getting what we deserve for not knowing this language, other languages. I didn't allow you afternoon tea break, but I do need to take a break, so we can either take a 5 minutes break or we take a tea break to be 10 minutes or what? 10 minutes. Okay, let's do that then. And then we'll come back and try and finish the 2 candidates.
I left my pen somewhere. Let me borrow my pen. Thank you.
Good afternoon, Mr. Nkosi.
Good evening, CJ.
How are you this afternoon?
I'm well, thanks, and how are you all?
All right, you may take off your mask because there is enough distance
Thank you
between
very much.
yourself and the commissioners.
Okay.
Thank you for availing yourself for consideration for appointment as a judge. I'm going to ask you some questions. Then I will allow the JP to ask you questions and the Premier's representative, Adwait Singh, and then any other commissioners who wish to ask you questions. I see from the questionnaire that you have a B.Juris degree, which you got from the University of Zululand in 1990, an LLB, which you got from Wits University in 1993, and an LLM that you say you got from the University of Pretoria, and an LLD that you got in the USA. Is that correct?
That's correct, CJ.
Under LLD, you wrote USA in brackets immediately after LLD.
Yes.
Normally, one writes there after the degree the name of the university from which he got that degree. But I see that you didn't write the name of the university, you wrote the name of the country. But after B.Juris, you wrote UNIZUL, which is the abbreviation for the University of Zululand. After LLB, you wrote Wits University. And after LLM, you wrote Pretoria. So in respect of 2 degrees, you wrote the names of the universities. And in respect of your LLM, you wrote the name of the city, of a city. In regard to LLD, you wrote the name of the country. What is the name, or is there a reason why you wrote the name of the country after LLD as opposed to the name of the university from which you got it?
Thank you, CJ. There was no specific reason why I just changed not to follow the sequence. I just did it for the sake of letting anyone reading about this to see that it's not within South Africa. I rather quote the country, but I don't mind disclosing it. For the sake of being open, it's Atlantic International University, which has got branches in New York and Hawaii and Honolulu.
I'm sorry, just repeat the name of the university.
Atlantic International University.
Atlantic International University.
University. It's a correspondence university or online university.
Oh, I see here that you write that you got it in 2021, the LLD.
No, I graduated last week, 27 March, but I passed it last year.
Sorry?
I passed it last year,
The graduation was just 2 weeks ago.
Yes, so, but I'm saying on your questionnaire, you wrote 2021. So that may be when you completed
When I completed
the studies.
when they confirmed that I've met all the requirements.
Yes. Your LLM, was it a dissertation only, or was it a coursework, or was it a combination of coursework and dissertation?
It was dissertation plus coursework where I had to write examinations for that.
It was a dissertation and coursework?
Yes.
Okay. What did you write on your dissertation?
It was human rights and constitutional practice.
Was that the topic?
Yes, the examination was based on human rights and constitutional practice, and a little dissertation supporting the views that we were reading about.
Yes, no, what I'm looking for is the title of the dissertation. What is it?
The new dawn of South African human rights studies.
The new dawn?
Yes.
The new dawn of South African human rights?
Practice, yes.
Hmm?
Practice.
Oh, the new dawn of South African human rights practice?
Yes.
Oh, okay. That was the title of your dissertation for your master's?
That's correct.
Okay. What other courses did you do for the master's?
We were based on interpreting the new constitution by then as to how is it going to be approached, how are we going to implement it, and do the interpretation for the sake of understanding how human rights are dealt with in the new dawn.
Yes, but what I'm asking is, what were the other courses that you had to pass apart from the dissertation that you did for your master's?
The topic that I had, it was all about human rights practice and constitutional rights and human rights practice in South Africa. That was the topic, though it was covering different subjects, but we were based and focused on human rights practice in South Africa.
Well, I want to try and understand. Earlier on, I asked you whether your LLM was based only on a dissertation, or whether it was based on a dissertation plus courses, or whether it was based on courses only. And I understood you to say it was based on a dissertation plus courses. Is that what you said?
Let me put it again for the sake of making it much more clear.
Yeah, but I want what you said.
Yes.
Is that what you said, or is that not what you said?
No, that's what I said.
Okay.
Yes.
Is it correct what you said?
Yes, it's correct.
Okay. So what do you call the courses that were part of what you needed to pass?
The way the course was done was presented by different lecturers on different topics having to do with human rights and constitutional practice in South Africa. It was new on its own, and it was taught by different people who were coming on different occasions at the University of Pretoria.
Well, was it not like this? Because I think this is what most universities do when they offer a master's course degree that combines a dissertation and courses, that it tells you that these are the courses and gives you the names. If there is labor law, there is labor law. If there is banking law, there is banking law. If there is commercial law, there is commercial law. It tells you these are the courses that you must pass. And then it tells you, in addition, you must do a dissertation maybe they will say the topic you must agree with your supervisor or whoever, but you know in advance these are the causes, you know what they are. Is that not how it was done in your case?
No, it wasn't like that, CJ. Let me just put it in a different way. Various lecturers were invited to come in and offer different topics on human rights and constitutional practice. I'll give you an example also by, if I'm permitted to quote names of our lecturers. Professor Davis could come and present studies on tax law in the New South Africa. Because the constitution was new by the time, 1996, even before it got adopted by the time. But each and every lecturer was presenting a different topic.
Okay.
Anyone who deals with issues to do with science will come and present the issues of science. How does it relate to our constitution? Because it was a new dawn on South African constitution, which was new in South Africa. Yes.
Okay.
So different subjects were presented by different lecturers. A week we'll have a different lecturer who deals with a separate topic, but relating to the issues of human rights and constitutional practice as to if there's a challenge on constitutional issues, how are you going to challenge it? How are you going to present it in the Constitutional Court?
Yes.
Yes.
Okay, all right. And your LLD, what was the topic that you researched?
It was a continuation of human rights and legal studies based on...
Just repeat, confirmation? Or
sorry?
The topic or title of the thesis?
What I'm saying is the LLD was based on the continuation of the human rights and legal studies on different topics. Mine that I dealt with, which I had to write my dissertation, was based on the UNESCO, the Sustainability of Development Goals 2030, which has got a target of 2030 as to when is it going to be rechecked again, if whether there is sustainable development on the specific topics, different topics of the Constitution.
Yes.
Yes.
Okay, and what conclusions did you reach in your thesis?
Well, we are in the process approaching 2030 as the target for the sustainability of all these rights that have been covered on different topics of the Constitution, or comparatively speaking, with other constitutions from other countries.
And how long did it take you to research and do the dissertation and complete it?
It took me 2 years in full.
3 years?
2 years.
2 years or 3?
2.
2 years, okay, all right. Thank you. You were admitted as an attorney, is it 1996?
1995.
1995.
Yes.
And at some stage you worked in the office of the state attorney, is that right?
After my admission in 1995, I was employed at the office of the state attorney as an assistant state attorney.
Yes.
Yes.
Okay. So you have been an attorney for, what is it, close to 27 years, 28?
Almost there.
Almost 30.
Almost there.
Almost there.
27 years.
Yes. Do you, in your practice, do you do trials yourself, criminal and civil, without counsel sometimes or all the time?
When I started, CJ, I was on my own.
Yes.
And I grew up in the process.
Yeah.
I had to get candidate attorneys and PAs who were coming to help me. But the first few years, I was running on my own.
Yes. Okay. So because you were alone or on your own, you were doing everything yourself.
It's true.
Yes. Do you still do the same now, or you no longer do that now?
Now I've got a few people under my auspices in my office.
Yes.
I've got 2 PAs and 2 candidate attorneys.
Okay.
And
all right.
if a matter requires more experience,
Yes.
I brief counsel where it's necessary, or I just go on my own.
Yes. And you have acted in the High Court.
That's correct.
For how long have you acted if you put together all the acting stints?
It's more than 10 years.
Hmm?
More than 10 years.
More than 10 years?
Yes.
Huh?
Yes.
If you put together all the months and weeks, they would make up about 10 years, more than 10 years.
Yes, I started appearing,
No, I'm talking about acting as a judge, not appearing.
Okay. It's not a period of not less than 5 years, if I may put it
So
in that way.
if you put together all the months and weeks where you acted in the High Court, you say when you put all of them together, they would make up a period of not less than 5 years.
Yes, that's correct.
So that's quite a long time.
It is.
Yes. Okay. And have you written judgments? Have you got written judgments that have been reported by any chance?
I have written judgments which has been published, and some of them have been challenged. Some of them have been just implemented as they are, because I acted in the labor court as well. Judgments that I wrote there, a few of them.
Please speak up so that everybody can hear you.
I say I've written a few judgments which have been implemented already. Some have been challenged.
About how many written judgments have you produced during your various acting stints that would make up 5 years? It must be many.
There must be many, not less than 40.
Not less than 40?
Yes.
Yes. Okay.
I include labor court judgments that I did.
Yeah.
And bargaining councils, different bargaining councils which I've been presiding over.
Yes.
And the CCMA as well, where I've been a commissioner for some time.
Yes.
And in the small claims court, though, is just judgments that you're passing through without having to write them.
Yes.
In the small claims court.
And in the High Court, have you sat in full bench appeals, and you have done motion court and civil and criminal trials? Is that correct?
This is correct, JC.
Yes. Yes. What can you tell the commissioners that would show that you embrace the values of the Constitution? What can you tell the commissioners about yourself that would show that you don't reject the Constitution, you embrace its values?
Well, CJ, I'm proud to say, as a South African, I got an opportunity to learn more by participating in all the legal fields that I was given an opportunity to preside over cases, different cases, and where we sit as full bench together with other senior judges and writing different judgments which have been delivered, and some of them have been challenged, some have been challenged but could not succeed. It was confirmed judgments. And being a person who has been also helping in other higher learning institutions as a part-time lecturer, just to help our people to understand how the Constitution works, how is it implemented, how can it be challenged if there's a need, how to approach different problems in a better way within the constitutional atmosphere of our country.
Thank you. I will now allow the Judge President to put questions to you. And after that, Advocate Singh, who represents the Premier, and thereafter the commissioners. They'll put questions to you aimed at establishing whether, if you were appointed, your appointment would meet the selection criteria that are used by this body. And that includes whether or not you are a person of integrity and whether you are fit and proper, whether you are duly qualified, and what message your appointment would send out to the community at large. Judge President, you may put your questions.
Thank you, Chief Justice. Good evening, Mr. Ngosi.
Good evening, JP.
Mr. Ngosi, let me take you through the issue of reserved judgments. It's correct that you did act in the Labour Court in Johannesburg last year, 2021.
That's correct, JP.
Now, on the issue of reserved judgment, the recent report which I have, as at the end of March 2021, shows that in the Labour Court in Johannesburg, you've got 6 outstanding reserved judgments, 5 reserved in April 2021 and 1 reserved on the 5th of May 2021. So the judgments are almost a year old. What's the position with regard? Have they since been handed down, these judgments?
Thank you for the question, JP. As far as I know, I don't have reserved judgments. I have delivered all judgments that were supposed to be delivered.
Yes.
There might have been some error somewhere where they indicated that they remain outstanding.
Okay.
There is none. They don't have any outstanding judgment.
Thank you. I see on your questionnaire, on page 27, on paragraph 9.5, on the questionnaire, where you are requested to set out your reserved judgment, then you indicated 2 part-head criminal cases in Mpumalanga High Court.
Oh, yes.
You did not indicate any outstanding reserved judgment. Is it correct?
Nothing is reserved. If it's not yet completed, it's because sometimes we don't finish, then we postpone to the next period during recess, because most of the judgments that needs to be completed, the ones that I say is partly hit, I only get a particular period in time to do it just during the recess period, because I'm not at all choosing dates, which ones do I have to finish all these cases. There are 3 of them. I could finish them within a particular time, but because I'm only allocated a few days, only to find that the criminal case, mostly are criminal cases, they have got so many witnesses. One case we find that has got 20, 30 witnesses. And if you are given only 1 day or 2 days to do those cases, you don't finish, then you wait until you are given another period during recess.
Lastly, on the issue of your acting stint, when was it when you acted in Limpopo Division? You mentioned Toyando and Polokwane. When was it? What year was it?
2014 and 2015.
And that was the time when Limpopo Division was not yet proclaimed as a division, which was still under...
That's correct.
Under Division Pretoria.
Yes.
Yes. Okay. Since then, you haven't acted in Limpopo Division since 2015 up to to date hereof.
That's correct. I only acted
Yeah.
in other divisions, yes.
Thank you. That would be all, Chief Justice.
Thank you.
Thank you very much. Advocate Singh.
Thank you, Chief Justice. Good evening, Mr. Nkosi.
Good evening, Council.
If you're able to, please tell us how many judgments that you delivered were taken on appeal, and what was the outcome of those appeals?
There's quite a number of them. I listed them on the package. I can't remember the exact number, how many, but there are a number of them that were taken on appeal. And there are a number of appeal matters that we did together as colleagues in the full bench where I'm not alone. So, but quite a number of them, we finished them. And so far, I did quite a number of them, not alone. And we delivered them. Everything is fine, it's just quiet. I haven't heard anything after delivering.
Thank you, Mr. Nkosi. Thank you, Chief Justice.
Thank you. Before I go to Commissioner Makwanisha, Mr. Nkosi, the Judge President's information was that there were about 6 or 8 or 6 judgments from the Labor Court that have been outstanding for close to a year. You are saying that in respect, you are saying that there is no judgment that took more or less that long before you handed them down, or you say, well, there were some that were reserved for maybe close to that period, but they have been handed down now.
Thank you, Sir. Yes, they were handed down, have been delivered.
Yes, after they had been reserved for how long?
Well, I didn't have the precise months or period. I don't want to take a guess because it will be dangerous to say it's 5 months or 6 months, but what I know is that all the labor court judgments have been delivered.
Well, were the periods anywhere close to what, to a year, or no, they could not have been longer than 3 months, or what?
It might have been longer than 3 months,
Yeah.
but not over a year.
But could they have been about 7 months? I'm just concerned about your inability to tell us how long they were, because any judgment that gets reserved for any length of time, a judge should be very concerned about it. And if you are coming to an interview such as this one, you know that this commission wants to know whether you are quick to hand down your judgments, and if you delay, how long you have delayed. So I'm concerned if you come to this body for an interview and you haven't even bothered to check what your situation is when it comes to the length by which you have reserved judgment. One would expect that if you are coming to an interview such as this, one of the things you would do is do your homework in terms of reserved judgments and be able to say to this commission, I have the longest judgments I have reserved in the past 12 months or 2 years is 3 months or 8 months. At least you would be specific, you know, but I'm concerned if you have no idea how long you have reserved judgments.
Thank you, CJ, for the question. What I'm confirming is that I don't have reserved judgments. As to whether, how long did they take, to be specific, otherwise I'll be guessing by using a number of months which I cannot confirm. But what I know is that all judgments that were reserved at a particular moment have been delivered.
What is the longest period you have reserved a judgment in the labor court? That at least you should know. That the longest I have reserved a judgment in that court was X number of months or weeks.
A dangerous guess that I can take is that
You
not
mean you
more.
don't even know that? The longest judgment you have reserved in the labor court, you don't know how long it was.
I can estimate the period of 5 months to 6 months.
That's the longest.
Yes.
Okay, and how long ago was that? Was it last year? Was it this year?
It was last year.
Last year?
Yes.
Okay, so there is no judgment in the labor court that you have reserved for longer than 5 months?
I've delivered all my judgments.
Within 5 months?
Yes.
Okay, and in the High Court, same thing?
In
Or
the
have
High
you
Court,
reserved?
the only judgments that are outstanding is the partly heard matters which could not be finished due to the fact that the time allocated gets shorter than the number of witnesses that are available.
Yes, but I see that you seem to, when this topic is being discussed, your emphasis is whether the judgment has been handed down or not, as if that's all that there is to it. Whereas, even if it has been handed down, it's still relevant to know how long you had reserved it before you handed it down. So my question is, in the High Court, is your record of reserving judgments the same as in the High Court, in the Labor Court, namely that the longest period you have reserved a judgment is 5 months, or is the position different in the High Court?
In the High Court, it's different in the sense that I don't have a judgment that is reserved because we have concluded all the evidence from all the parties and kept without having to deliver it without any reason. All those that have been done and concluded has been delivered. A matter which is outstanding because it is not yet concluded due to the shortage of time remain party-head matters, not finalized but reserved to be judged, to deliver judgment.
So are you then saying to me, your record in the High Court is that you have never reserved any judgment at all, or you have reserved judgments, but you have never reserved a judgment beyond 5 months? Is that what you are saying in the High Court?
That's what I'm saying.
Okay, all right. Commissioner Klaber?
Thank you very much, CJ, and good afternoon, Dr. Nkosi.
Good evening, sir.
I just want to follow up on the list of decrees that you list in the questionnaire.
Yes.
You say you have LLD. Is that
Yes.
correct?
That's correct.
And you obtained that LLD in 2021. And what was the focus of your doctoral thesis? Or let me say the research towards your PhD, if it was PhD?
It's a doctoral study on legal studies and UNESCO Sustainable Development 2030 as a target.
And the title of the thesis, I'm sorry, because I'm dealing with the question.
No, that's fine.
Thank you, CJ. And the title of the thesis?
Sustainable Development on UNESCO 2030 target.
Okay. And does it bother you that the university is not recognized by the U.S. Department of Education?
if I understand your question correctly, Commissioner, you say, did it bother me that the university is not recognized?
That's the question.
You know, when I approached the university for registration of the course that I wanted to do by the time, I didn't approach the university and ask them if you as an institution, are you recognized by any other institutions? Because it's even advertised in all the newspapers everywhere. That
No. The question is, does it bother you
No,
that the university is not recognized by the US authorities?
no, as far as I know, the university is recognized.
All right.
People were saying it's not recognized. I don't know where they take it from.
Okay.
But
I want to move to the second question on the same aspect. Does it bother you that the university is not recognized by South Africa?
no, not at all. Because there's nowhere where the city, you communicate almost every day with them to do further studies with them. There's nowhere where they say they are not recognized.
Okay. And just please bear with me because I'm dealing with the
Yes.
questionnaire,
Yeah.
CJ.
Okay.
And on page 3, paginated 19 of the questionnaire, you list the organizations that you were a member of, the political organizations that you were a member of. Can you see that?
I'm just opening the document. Yes, page 3, I've got it.
Yes. And then on page 4, paginated, page 20, and you also list the secret organization that you were a member of.
I'm just paging through. My page 20 here is different,
No,
Commissioner.
I said it's number 3, paginated 19, and page 4, paginated 20. But I'm sure you should know this without referring to the questionnaire.
No. She's assisting me to get the right page. Okay. Now I've got it, page 19. And I mentioned the UDF, United Democratic Front.
Yes, which you joined in 1983.
Yes,
And then the next one,
the ANC.
which you joined when?
It was 1983 as well.
Where did you join it?
By the time it was an organization which was operating in different cells. It was not open. So
No, my question is, where did you join it?
in Nelspruit.
In?
Nelspruit.
Nelspruit.
Yes.
And if you were a member of the United Democratic Front, you know that you could not be a member of the Democratic Front because it was a federation. Do you know that?
Well, whether it's a federation or give it a particular definition, by the time it was an organization, political organization, which was not openly registered for the purposes of registering.
Thank you very much. What was the name of the organization that was affiliated to the United Democratic Front that you were a member of?
I joined the United Democratic Front.
Mr. Nkosi, an individual could not join the UDF. That's a fact, so we are not going to debate about that. You could not join the UDF as an individual. You had to be a member of some other organization, and that organization would affiliate to the UDF. So how could you have joined as an individual? Did you sign forms for membership of the UDF?
CJ, can I answer the
I
question?
mean, we lived through the UDF times.
Yes.
We know what was happening.
I was only disclosing my participation whether it was formal or informal, I was part of the UTF by the time.
Well, if you say you joined an organization that an individual could not join, it may well mean that it's not true that you participated. Because how could you not know if you were part of the activities of the UTF that as an individual you could not join the UTF?
CJ, if I may also humbly respond to the question.
Yes.
By the time the form was completed, I wanted to disclose my participation, whether it was a formal registration, because you could be arrested at site. There was no time to complete forms to say, now I'm joining, here's the fee that I'm paying. We were part of the activities during that time of our country's political system. So I disclosed that I was part of the UTF, which was part of the ANC by that time.
So you still cannot tell me the name of the organizations you were a member of, which was affiliated to the United Democratic Front?
You know, we're operating underground.
No,
there was no
UTF,
formality.
The UTF was not underground.
That's not what I'm saying, basically. If you can give me an opportunity. I say we participated under the affiliation of the UTF, being Legacy Civic Association by the time. And at the same time, the association itself, we didn't have to complete a form to go and hand it over somewhere and pay money. As long as we were participating on what we had to do, being led by our own leaders by the time. I'm only disclosing what were I part of during that particular period.
Okay, I will pass, Chair. Just this one, last one, CJ, on the question again. You, on page 23, paginated 23, you are asked to indicate the proportion of your litigation work that you were involved in.
Yes.
And I don't know what you want us to read into the answers you are providing.
Page 23, paragraph number.
Yes, page 23.
Yes.
What proportion of your litigation work has been in the field of?
Okay, I'm looking at paragraph number 6.2.
6.2, correct.
Yes. Criminal law, as a general practitioner, one was helping clients in different cases. Criminal law.
No, the question is what proportion of your litigation work, and at least under criminal law, what was the proportion? Now, there's proportion of the entire legal work, and then you indicate, you give each one the proportions, the percentage, or percentages.
Quite a number of cases that one was doing. Some were on individual, or maybe few people approaching you who are charged for a particular offense of criminal law.
That's fine, Chair. Yes. I will pass because of time. On
Yes.
page 27, that's the last question, CJ, my indulgence, please.
Yes.
You list the reserves judgments that were still outstanding at the time of compiling the application form. Is my understanding correct?
Paragraph number?
It's 9.5 on page 27.
Yes. State versus Sihlabela, Mpumalanga High Court. State versus Mashabane, Mpumalanga High Court. Let me explain one by one on this.
No. They were, in terms of what you are stating, you are saying they were outstanding at the time of compiling this application form.
Yes, it is.
Have they been finalized?
No, not yet.
Okay, thank you so much.
Thank you, Commissioner Klaba. Commissioner Mapisa-Nqakula.
Thank you very much, CJ.
Yes.
Thank you, Mr. Ngosi. I just want to, other than the issues raised by Commissioner Klaba, I would like to just check one thing. with you. In 1997, you represented Umkhonto Wesizwe in a military court sitting in Mpumalanga. What was the nature of the case? In 1997, you represented Umkhonto Wesizwe members in a military court sitting in Mpumalanga. The question is, what was the nature of the sitting of the case?
The members of MK by the time were already part of the integrated military in South Africa, and they were charged within the ranks of being ordinary soldiers in South Africa, charged in terms of the military disciplinary code. So we used to go and, or me and others, we used to go and defend most of the members on military cause because they were charged by the military police for failing to abide by the military code on different charges. That's what I meant by this. The military court, they call it court martials, have been charging many people who are members of the SANDF by the time, but they were those that are being identified as former people of the MK and charged on different charges in the military courts. Yes, I did. I was representing them. Sorry?
And you represented them?
Yes.
And they were charged?
Yes.
And they were found guilty?
No, they were not found guilty. I represented them.
How many?
Quite a number of them. Okay. Those who had, you know, after joining the SANDF and the former non-statutory bodies, there's a military code which is only applicable in the military courts. That's where I was representing my clients by the time, who happened to be people who were coming from non-statutory, which is MK. Some of them were APLA. So the military courts have been operating ever since. It's military police that have been continuing to charge them for different offenses. But we were there as attorneys together with others. I count myself in here because I was appearing before a military judge on behalf of these people.
I think no one is, CJ, no one is refuting that. But it's important for the record for us to know that indeed in 1997, you represented members of non-statutory forces who were integrated into the SANDF in a military court.
Yes.
That's all we want.
Okay.
And my last question is a matter which was raised again by Mr. Kaba. I am concerned because in 1983 there was no branch of the ANC anywhere in the country.
It was underground movement, sister.
Yeah,
It's an underground movement. You didn't have to be open, but I'm disclosing what you were doing during the underground movement by the time.
okay.
Yes.
So you were part of a cell operating in Mpumalanga.
Yes.
And that is something which when you disclose organizations, you disclose and say I was part of an underground. Because the question here is membership of organizations. Anyway. It's okay. I think you've clarified the matter.
But at the same time, if I may explain, CJ,
Yes.
When you are being approached by family members of somebody who has been arrested by military police for the purposes of representation, we had to help them. So I was only disclosing what type of people were being arrested by the military police, who were going to be held in detention for as long as they could, only to appear on a particular day when they feel like, because they had to change even where the military courts are sitting. You will be in Nelspruit and be called in Piet Retief. We travel 300 kilometers to go and check people who have been arrested by the military police where a bail system was not there. Once you're in incarceration, you remain in incarceration until the matter is finalized. So this is the nature of how we're operating in South Africa. It was not like normal.
Thank you very much, Mr. Nkosi. Thank you.
Thank you.
Thank you. Commissioners, I've got a not so short list of people here. I'm going to give people an opportunity. All I ask is that each one just evaluates how important the issues are that they want to ask. And if you think that maybe they're not so important, it would help if we don't have too long a list. I skipped Commissioner Makwanishe earlier on, so I'm going back to him. I skipped him by mistake because I had put a tick, and yet I had not given a chance. Commissioner Makwanishe.
Thank you, CJ. Good evening, Mr. Nkosi.
Good evening, sir.
Just a quick follow-up on the issues raised by, in fact, on the issue raised by Commissioner Kaba.
Yes.
Did you submit your LLD for evaluation to the South African Qualifications Authority?
Okay. I didn't have to. I only registered with the university where I was registered, where they were providing the notes and references as to which books to read, and the test that they send to you, you submit it to a particular lecturer and get marked, and that's how you are evaluated. There's no requirement in any law which says if you are registered with this particular university, you must submit something somewhere else for the purposes of evaluation. If that was part of what the university that I'm registered was a requirement to do that, I could have gladly done that. I submitted all my assignments to the lecturers at that particular university, and they evaluated, they marked, they gave me the marks. There's nowhere where I skipped a particular requirement, like the one commissioner that is asking about, which was not there. It's not part of the university. Maybe different universities have got different ways of doing things, but it's an independent university on its own, and somebody has just mentioned that it's not recognized. As to who is supposed to be recognizing other institutions which are being advertised all over here in the newspapers and everywhere, that was not part of the requirement that one has to do it, unless if the university demands that you have to do that.
Mr. Nkosi, it is part of the South African dispensation that any foreign acquired qualification must be submitted to the South African Qualifications Authority for evaluation.
Commissioner, I hear what you're saying, but
Let's
beg
pass.
to differ with you, because the university did not say you have to do this. Once you have read a particular article or portion of what you have to read, you must submit it to a different institution. That was not part of that. How could I have done it?
It's not the requirement of the university, it's the requirement of the South African dispensation that any foreign acquired qualification must be evaluated. But let's pass. You said that you are communicating with the university frequently.
Yes.
But it took me less than 2 minutes to find the following in the website of the university, that Atlantic International University is not accredited by the accrediting agency recognized by the United States Secretary of Education. It's in the website of the university.
I hear it for the first time, Commissioner.
So you've never seen that in the website of the university?
To be fair enough and be to respect your question that you're asking, my response to that is that there's nowhere where I was told that registering in this university, we have to check this and that so that you can see if this university or this institution has been registered at a particular level, or all that has to be dealt with, you have to submit it for the purposes of being checked by a particular organization in South Africa or not.
Thank you very much, CJ.
Thank you. Before I go, I move to Professor Schlemmer. Mr. Nkosi, from what you have said, I gain the impression that your attitude is you don't care whether the university from which you got this LLD is recognized or not. Is my understanding of your attitude correct?
CJ, with due respect, I am not suggesting that I don't care. I wouldn't have involved myself in studying so much work that they've sent us to read and to understand and be tested if I were not to care. All that I've done, I've registered for the course, and if it's not recognized in South Africa, I would have known, because they wouldn't let me to study for more than 2 years, not knowing that I was not even informed that, look, what you are doing is incorrect. If it's not recognized, I'll accept that it's not recognized by our own institutions in South Africa, but what I've done the necessary courses which put me to the level of where it's recognized, and up to master's level, which I did at the University of Pretoria. The LLD, yes, I did from this university, which is for the first time now, I hear that it was not. I wouldn't have spent such a lot of money paying for school fees, university fees, if I'm just throwing the money away.
You have also heard now from Commissioner Magwanishe that by looking at its website, it's indicated that the country in which it is doesn't recognize it. The authorities there don't recognize it. Does that concern you, that now you got this LLD from a university and the authorities of the country where it is don't recognize it, and it looks like South Africa, it is not recognized in South Africa? Does that not worry you, that you have an LLD from a university that doesn't seem to be recognized by your own authorities in your own country and is not recognized by the authorities of the country where it operates from?
CJ, with due respect, just hear this for the first time. And I'll take steps to find out from the authorities in South Africa what I'm hearing for the first time from the commissioner. I wouldn't have known if I was not alerted. I only registered because it's being advertised everywhere. Then I was one of those that got to register.
Yes.
Yeah.
And but now that you know, are you concerned about the fact that your name is associated with such a university?
It troubles me, CJ. I will have to check and see if am I made to register at a university which, as from today now, I know that is not fully recognized by South Africa, but I'll take steps to establish that.
See, part of what concerns me is your reaction to the discovery of the news.
Yes.
That this university is not recognized. Your reaction didn't seem to be that of somebody who gets concerned because he thought it was well recognized. You seem to be defensive and to be suggesting that maybe commissioners are making a big deal out of nothing. Then that's the impression I got. Maybe that's not what you intended.
I'm surprised. I don't know how could I have made it quite clear to everyone present today whether I'm so surprised. I was taken for a ride, maybe, but I still have to take steps to make sure that my name is not associated with this kind of a situation. I didn't know. If I knew, I could have remained with the qualifications that I have, not to disclose it, and remain with the LLM that I have from the University of Pretoria.
Thank you. Judge President Lekhodi.
Mr. Ngosi, I'm here. I am here, and I must just tell you that whatever I come to put to you, I will do so with deep pain in my heart. You'll recall that on Monday evening I spoke to you, and I sought to talk to you like a brother and to advise you what you should not do.
Yes.
And you'll recall that you were not even aware that you were supposed to, that's what you told me, that you were supposed to come today. You thought you were going to come on the 22nd of April for the interview. Am I right?
Yes, that's correct, JP.
I'm not going to ask you to explain why you thought that you're going to come on the 22nd and not today. I will not ask you that. Can you go to paragraph 29? No, page 29 and paragraph 1 thereof. It says, are there any circumstances, and I will not read anything, known to you which may cause you embarrassment in undertaking the office of the judge? I'm sure you understood this question, am I right?
Yes.
And your answer there is no. Now, between the two of us, we know the truth. There was a judgment which was written in our court because you absented from coming to court, and in that judgment you are asked to be given the opportunity to come and respond by way of filing an affidavit. You did not. Instead, you wrote a letter where you actually sought to criticize the directive or the order that was given to you. And thereafter, a judgment was written and you were referred to the Legal Practice Council. You are aware of that. And I discussed it with you again on Monday, remember? Mr. Nkosi, are you still here with us?
Yeah, I'm listening to you.
No, but this one, you don't have to look at the paper. You just have to answer. You are aware that there was a judgment that was written by me and your conduct was referred to the Legal Practice Council. You are aware of that. Am I right?
No.
No, you can't say you don't know, Mr. Nkosi. You confirmed that on Monday, and that judgment was emailed to your office. Are you still saying no? Because I can tell you, Mr. Nkosi, you need to be very careful about what you are saying, because this might result in putting you in a big trouble. It has got everything to do with your integrity. It has got everything to do with the possible commissioner of seeking to mislead us. You are aware of that judgment, am I right?
JP, with your respect, I spoke to you on Monday, as you indicated just now, but we didn't speak about this one.
Okay.
And with your respect, I'm not trying to mislead this commission by any way. If there's anything that I am being accused of having done, it would have been better if this was made clear so that I could respond appropriately. But now I'm taken by surprise.
Okay.
You, on your own, JP, you approached me and asked me if I know that on the 6th, this sitting will be here in Johannesburg. I said to you, I didn't know the way the letter that I received was referring to. It was as if it's the 22nd. That's what I said to you.
Okay. Now, you remember 4 years ago or 5 years ago, I stopped you staying at a hotel in Bombela at a huge expense to the public purse because your home is actually almost like 5 kilos from the hotel. You remember that?
Yes.
And at that time, we're still funded by Pretoria. Do you remember that?
Yes.
Can you share with these commissioners why you decided to put up at a hotel at the expense of the public purse when your home is about 5 kilos away from you, from the hotel?
If I remember very well, we did speak about this.
4 or 5 years ago, am I right?
I'm not exactly sure of the years, whether it's 4 years or 5 years or so, but long time ago. Yes, I remember you asked me about it, but when one was appointed to act in Mpumalanga, the Pretoria office was the one that was booking everything. So the accommodation was booked together with the fact that I will be attending to 1 or 2 cases in Mpumalanga, which one was in Hazyview, one was in Barberton, one was in Nelspruit. So when they booked, they included accommodation by the time. For me, I could not have known that I'm not supposed to be staying in Nelspruit by the time because I'm also staying in Nelspruit. But for me, it was for the purposes that I shouldn't be disturbed when I'm staying at home. I will be having a place where I'll be able to read documents and analyze all documents that I have to do and prepare to go to court, which I suddenly took your advice to say, let me cancel this and I'll pay for myself for that particular moment so that I can prepare my work properly without having to be disturbed at home. No intention to cause government to pay for me on that particular time.
Now, let us go back to paragraph 9.6 on page 28. And the question reads as follows. Are there any part-head matters which you should bring to the attention of the Commission? And there you will see, Mr. Nkosi, that you said State versus Lucas Setole. Defense and State cases closed. I can't read the other thing there, but there is also an issue of heads of argument. So what you are saying here is that you have got only one case which is part-head, and that is Lucas Setole. Now, in paragraph 9.5, and I'm going to read it to you again, on page 27, please list any reserve judgments still outstanding and the date or dates on which judgment was reserved. This question is very specific and is very clear. Now there, this is what you're saying. State versus Setlhabela, Mpumalanga High Court. In other words, you're saying you have got a reserve judgment in State versus Setlhabela. There you have written also State versus Mchwana, Mpumalanga. In other words, you're saying this matter is also reserved. But look what you say immediately thereafter. In brackets, State cases closed, almost finished. And I'm sure, as a judge for that matter, this question should have been clear to you. Now, it looks like there are 3 part-head matters in my division, and I know of only 2. But these matters, can you tell the commissioners that they have been reserved for more than 5 years or 4 years? Am I right? You did this, you assist with these matters before I was even appointed as a JP of Mpumalanga in 2017. Am I right? These three part-head matters, you assist with them even before I was appointed in Mpumalanga in 2017 as a church president. Am I right?
Yes.
Okay. Now, justice delayed, justice denied. Do you want to say anything?
Okay. Let me put it clearly so that maybe it will make sense on what I'm going to say. State versus Sitlabela is not a matter that has been completed waiting for judgment or reserved judgment. This matter up to now has not yet been concluded. The reason is that when I started doing this matter in 2017, we did it at Graskop. It went on to be postponed because we couldn't finish as partly heard. We went on to his review. And this matter up to now has not been completed. The reason is there are so many witnesses and the time allocated for the purposes of this case was so short and so many witnesses. The record is there. JP knows about it. We can't say now, I did it deliberately to make the case as if it's a reserved judgment. It's not a reserved judgment. It's a matter which is continuing. I'm only allocated 1 day to do it on a recess. And recess comes once after 3 months all the time.
Okay.
I'm not allocated more than 2 days for this matter, which is a criminal matter where so many witnesses are there. And it's not my own making that there should be so many people, but only allocated for 1 day each moment.
Does it worry you?
The second
that-
one.
Okay, yes, you may proceed, Mr.
The
Nkosi.
second one, state versus Mashabane. State versus Mashabane is one of the cases also which, during the period when it was allocated to me, there were only a few days. But because I only get allocated 1 day for a case which got more than 10 witnesses, which I cannot finish in 1 day. So this matter is one of the matters that is still not completed because I only get 1 day allocated, despite the fact that the case docket will show you that there's got so many witnesses that has to be called. I cannot short-circuit it to get the matter finalized immediately when everyone is not given an opportunity to be heard. I told that to the JP. I cannot simply just prolong cases of other people to make myself guilty of justice delayed deliberately. There's none of that nature that I deliberately postpone these matters. I'm not allocated enough days. That you know, JP.
No, but Mr. Nkosi, you know that there is no 1 day about these matters. And you know that I also had to manage your cases because they were taking a long period of time. There was an excuse that there is no record of the proceedings. You wanted the record of the proceedings. I case managed those matters because I could see there was a hell lot of delay. And thereafter, you could not deal with the matter. And that brings us to another issue. And that is page 20 of and paragraph 11. Can you have regard to that?
Open it.
I'm not going to mention what is discussed there because it might be having a bearing on your right of privacy. But you know that there are things that I know, and at one stage we had to take you home. And you know what I know, that this matter could not proceed on the day to which it was postponed because you had problems. Now, do you think you have got the energy and the stamina to deal with the load of work for judges?
With due respect, honorable commissioners, JP knows as much that we can't mix issues here. The cases that I'm referring to, that up to now are not yet completed because of the days on which I'm allocated. If you allocate me one day, in a case with so many witnesses, if I've just alluded earlier on, the matter, by the end of the day, will have to be postponed to another date. And this thing is beyond my control because I asked for permission to say I need a few days on which I'll finish the case. Criminal cases usually got so many witnesses. If I deal with one matter at a particular time and the state only is able to do one witness at a particular moment, what about the rest of the witnesses? I cannot simply just close the case and say, let's finalize for the purposes of making it easier for me to come and attend to the case on given moments.
Mr. Nkosi, the last question. There is 4 week or 5 weeks recess period and 2 weeks recess period. And since you started with these matters many years ago, you had the opportunity to deal with those matters during the recess period and not the one day that you're talking about. You could put one matter for 4 weeks during the recess period or 2 weeks during the shorter recess period. Am I right?
You're quite correct, JP, but can I be given an opportunity to respond to the one day that you allocate me every moment when I'm asking for dates? I'm allocated one day and the witnesses are more than 10. What can I do beyond that?
When were you given 1 day period? Can you just explain to us?
Chief Justice.
I don't feel...
Mr. Nkosi.
Commissioner Singh.
Okay.
Yeah, Chief Justice, with due respect that Mr. Nkosi has been using all the time. Our responsibility as a JSC here is to assure ourselves of the credibility, of the integrity, of the suitability of a candidate that appears before us.
Yeah.
And I would like to submit, although I'm on the list of questions as well, I would like to submit, Chief Justice, that as a commission, we have heard enough to be able to discuss during the time that we have the suitability of Mr. Nkosi.
Yes.
So I'm just putting that to the commissions.
Thank you. I just had a word with the JP here, and I wanted to find out whether there is anybody who really still needs the interview to continue. Is there anybody who wants the interview to continue?
No, Chief Justice, I didn't want, but the only thing I wanted to say, because I have a list here of the reserve judgment. Mr. Nkosi's judgment reserved from April 2021 for 9 months, 8 months. My point is, I wanted to say, as a last parting shot, by now Mr. Nkosi should have been charged in terms of the norms and standards. We should not be having Mr. Nkosi. And he patently lied to the JP. Here is a list of outstanding cases which are listed even in the website. I wanted that to put to him. Thank you.
CJ.
Shall I release Mr. Nkosi? Mr. Nkosi, you are excused.
Thank you, CJ. Something is falling here. I think it's missing food.
There's nothing.
Okay, I think it's fine.
Okay.
Oh, thanks.
Please give us the last candidate. Hey. Good evening, Advocate Chidada.
Good evening, CJ.
Am I pronouncing your name correctly?
You're correct. Advocate
all right.
Chidada. Good evening to you, Chief Justice, as well as the commissioners.
Good evening.
Thank you.
How are you this evening?
So far, so good.
So far, so good?
Yes.
Okay, all right.
I've been on this chair before, CJ, so...
Oh, okay. So you are not nervous?
No, not at all.
Okay.
I've already settled down. I think when I arrived, I was a little bit nervous, but I've been on this stage before.
Okay, all right.
Thank you.
You're well prepared?
Very much.
Oh, okay.
I hope so.
I'll ask you some questions, then the JP will ask you, and Advocate Singh, who represents the Premier, will ask you, and then other commissioners. You hold an LLB degree, is that right?
That is correct, CJ.
Which you got from the University of Limpopo in May 2008.
Correct, sir.
And you started working as a clerk in the Johannesburg High Court in 2001.
Correct.
And later on, you were a registrar of the High Court. I guess that means just a clerk or researcher, judge's registrar.
Correct.
Is that so?
That is correct, CJ.
Okay. And that went on up to 2008. And from 2008 to 2009, you sat as an assessor in criminal trials in the High Court.
Yes. And before that, I think in between myself being a High Court, Johannesburg High Court clerk, I was then moved to the judges' chambers where I started as a junior judges' secretary up until I was moved to be a senior judges registrar where I would assist. In fact, I started assisting in the office of the DJP during the reign of Judge Scabot.
Yeah.
And immediately after that, I was then moved to assist all the acting judges who were assisting in the Johannesburg High Court until I left to go and do my pupillage or to go and join the bar.
Okay, all right. You were admitted as an advocate in 2010.
That is correct.
And you have been practicing as an advocate since then.
That is correct, CJ.
So you have been practicing for 11 years, 11 or 12 years.
This is my 13th year, CJ.
This is your 13th year.
Yes.
What types of cases do you do in your practice?
JP, let me answer your question by starting this way, that I was one of those who learned but the hard way, so to speak. But we were assisted. Let me say, at the time when one was doing pupillage with the others, obviously, we had good facilitators and trainers who advised us as to how, as junior as we were, we would be in a position to learn much quicker without necessarily having to go and knock at the doors of the attorneys.
Mr. Chidida,
yes.
Please just focus on the question. My question is, what types of cases do you do in your practice? Just focus and answer those questions that I'm asking.
Thank you, JP. CJ. JP, I was a general practitioner, so to speak.
Yes.
I've done almost everything except for those matters that obviously with seniority and one would say those that are meant for the elite group, commercial specifically, your measures and acquisitions and your tax laws. Not that one was unable to handle any of those matters, but due to the unavailability of briefs for people of my caliber or for practitioners of my caliber, one was unable to do those. But otherwise, I was general practitioner starting from criminal, civil, applications, matrimonial matters. I've done almost everything on a pro bono basis, as well as doing pro deo matters, which were coming from the legal aid of South Africa that I was in a position to handle criminal trials.
And how much of constitutional law do you have in your practice?
CJ, in terms of proportion, I would say 10%. I would allocate 10% as I did in my questionnaire. But otherwise, constitutional law applied almost in every matter than what one would say he or she handled, or those that I handled. The examples of matters that comes to mind, CJ, is the matters that I assisted either on behalf of the defendant, which would be the Minister of Correctional Services, or as a plaintiff or appearing on behalf of an inmate. Those matters or those applications would vary from application for allocation of study materials for those inmates who would be studying, or for health facility, and so on and so forth. I've also dealt with matters relating to recognition of customary marriages, recognition of traditional leadership, and so on and so forth. CJ, basically, the constitutional law, in my view, lies in almost every matter that one would handle, or there comes a time where constitutional law has to be fused in our daily litigation that one find himself seized with.
Yes, I see that you also do labor law.
Beg your pardon?
I see that you also do labor law.
I did.
Yes.
Yes.
Yes. And how long have you acted in the High Court?
CJ, I have 79 weeks under my belt, which equates to about 1 year, 10 months to date. And from the 1 year, 10 months, there is 29 weeks, which equates to about 7 months that I have assisted as an acting judge on a pro bono basis.
Yes.
Yes.
And about how many written judgments have you produced as an acting judge?
CJ, I have not written less than 50 judgments during my acting stint.
Yes.
And I would also count in the region of about 20 or plus on extempore judgments that I've also delivered, not necessarily written, depending on the exigency of the matters that would be before me, and also on whether the complexity of the matter. Some matters you'd find that the issues are very narrow, that I would be in a position to deliver an extempore judgment immediately after the hearing of the matter.
And during your acting stint, you have sat in full bench appeals.
I have.
You have done motion court, opposed and unopposed. You have done civil matters, civil trials.
CJ, I think I'm one of the fortunate candidates for the Limpopo division who has been in all the courts in that division, in both the division, the Limpopo High Court, Polokwane, as well as the Thohoyandou High Court. I've been in all the courts in that division. I have the JP, I recall there was a time that he assigned me to handle the civil trial role, which is the busiest in the Limpopo division in the Polokwane High Court for the whole term. And I did it, and I acquitted myself with precision. Currently, I'm at the Thohoyandou High Court, where I'm assigned or in charge of the civil role, including the civil trials as well as all the application matters that comes before that court, because there's only 3 judges in that division. 2 of my senior judges, one Judge Khomo and Judge AML Patudi, are in the criminal court. I'm the only judge who's dealing with the civil role of the entire region, starting from Messina, if the CJ knows the area, right up until the Malamulele area and the Bembe district in its entirety.
Thank you. I will now allow the Judge President an opportunity to put questions to you.
Thank you, Sir.
Thank you, CJ. Good evening, Mr. Chedada.
Good evening, Judge President.
Yes. On your acting stint, during your last interview by this commission was October last year.
Correct.
Thereafter, after your interview, you proceeded to act as a pro bono judge up to the end of the year, end of December, correct?
That is correct, Judge President.
Right. Now, with effect from the 8th of February up to date hereof, you are acting at the Limpopo Division, Toendo, correct?
That is correct, Judge President.
Now, I just want to take you on your performance there. As at the time when I assigned you to take over the civil role there, I had a lot of congestion and backlogs there. Now, immediately, I mean, a day ago, then I managed to get the statistics. Between the period, the 8th of February up to date hereof, there were 733 matters on civil matters on the road, which include civil trials, opposed and opposed motion, and the pre-trial, judicial pre-trial, and then civil appeals and so on. Now, do you have an idea, out of the 733 matters which were on the road during that period of 2 months, how many did you manage to dispose of, to finalize, and how many maybe were postponed and so on?
Yes, I mean,
you don't have to break it up, just say overall, that overall idea.
Thank you, JP. Yes, I managed to prepare, as I usually, on daily basis, in fact, keep my roles, that at the end of the week, I'll do my own statistics of matters that came before me, those that have been finalized, and those that would be pending or postponed. JP, from the date that you assigned me that court, I was able to handle 725 matters. From the 725, I finalized 402 matters. From the 725, there is only 37 matters which are pending, largely because most of them have got return dates. It's those ones that would, in our language, there is a rule nisi issued onto those matters, most of them, that there is a return date upon which a certain part of the application will be returning to court. And from the 725, I also have 236 of matters which were either removed because parties were not ready to proceed on the day, or it was either by agreement between the parties, probably to file other documents and so on and so forth. Others were just being postponed, and others were struck off. The struck off flowing from the civil trial role agent application and the entire civil role as it were.
Lastly, would you say that that backlog of cases, would you say the role is now up to date?
I have cleared it up, JP, without any benefit of the doubt.
Thank you.
I'm also ready to continue as of next week, Monday, to continue from where I've left off, JP.
Thank you, CJ.
Thank you, Judge President. Advocate Singh.
Thank you, Chief Justice. Advocate Shidara, good evening.
Good evening, Mr. Singh.
I'm not quite acquainted with such details as the Judge President asked you with his cases, but I've been to Toendo,
Yes.
and I've seen it's a very poor rural area.
It is, Mr. Singh.
And I hear from your answer to the JP that you've been very busy at the court.
Yes.
Have you done anything from a legal perspective to uplift the community there?
I have done so, certainly. One thing that when I arrived at the Toando High Court that I realized was that there was quite a number of junior practitioners who, when they appeared before me, I could detect that they were still inexperienced in terms of practical experience. I then took it upon myself, firstly, that every time when I presided in matters, I would, with the permission of the senior counsel, ask them and request them to allow
junior members to call and mention their matters first, so that those senior counsel who are available to assist, in fact, firstly, to detect and identify junior counsel who needed assistance and still required to be mentored, that those who were able or would have been in a position to assist them would then at least start picking them up and assist them going forward. But I didn't end there. I then decided to approach the University of Venda, which is down, or rather across the road from the court, and I approached the Dean of the School of Law there and engaged him on an initiative to start, or rather to establish a relationship between the court and the School of Law. My initiative or my request was well welcomed. I was then allocated a newly established class of the law school students, whom I have since started assisting ever since I arrived there. My assistance it's on weekly basis that I would, after court in the afternoons, every Tuesdays and Thursday, go and assist them in class, assisting them by advocacy trainings, or just making myself available for them to ask me any questions that they will seek assistance from, or clarification of anything that they would not have understood in class from their lecture rooms. I have also extended an invitation to those students to attend my court proceedings so that they could enhance and improve their practical skills by observing the proceedings in court on daily basis. And I'm glad to mention that more than half of that class, I would usually see them in court every time I'm in court. This is an initiative that I think last week, when the Solicitor General, Mr. Pandelani, was around the university, and I know for a fact that he's also an alumni at the university, learned about the initiative that I have put in place, and he endorsed it, and he pledged his support to the initiative that I have started at the university. In the next couple of weeks to come, we have a program where we will be doing revision, and I'll be assisting them in the preparation for their board examination that is coming sometime, I think they said in August. So that's one other program that I've put in place to assist the up and coming aspirant legal practitioners in the area. And I know for a fact that even Minister Ronald Lamola is also an alumni at the University of Venda, and I hope that he will in due course consider either supporting the initiative or not. But I know for a fact that he's from there. And yes, I've realized, and I've since gotten confirmation from the Dean of the School of Law that the initiative, he has gotten the reviews and the feedback from the students that my initiatives are really assisting the students.
Thank you very much, Advocate Shirara. That's all, Chief Justice.
Thank you.